Welcome in, everyone. My name is Carrie, and today I'm going to give you a quick introduction into the Kouri Richins case.
A community is shocked tonight after news broke earlier today of what seemed like a grieving wife and mother now arrested for the murder of her husband. Kouri and Eric Richins were married for 9 years before his death last March. And just a month ago, Kouri came onto ABC4's lifestyle show to promote the book about grief and loss after the loss of her husband. According to unsealed court documents, autopsy reports revealed Eric died due to an overdose of fentanyl, 5 times the lethal dose.
In August of 2024, a judge decided that a Utah mother of 3 who wrote a children's book about coping with grief after her husband's death will be tried for his unaliving. The father of 3 was poisoned and passed away at the age of 39 in March of 2022. Prosecutors say that Kouri Richins mixed a lethal dose of fentanyl into his Moscow Mule cocktail. Kouri Richins was arrested a year after her husband's death and has since been charged with aggravated murder, drug charges, and various fraud charges. This is deep. There's a lot to it, and I don't know if I can get to it all before we go into this hearing today, but I'm certainly going to try. Eric Richins was a successful contractor. He owned his own business. Kouri Richins was a realtor, and she ended up buying and flipping a lot of homes to make a profit. Kouri's mom was interviewed by 48 Hours, and she claims that Eric had told her his chest had hurt, and she said that he also had looked horrible a couple of days before he died. And Kouri's mother also said that Kouri was devastated after his death and would not go back into the bedroom for 2 months. Prior to his death, Eric told his family that if he did die, they needed to take a look into Kouri because he said he thought she was trying to kill him. Kouri has 2 brothers, Ronnie and DJ, and one is scheduled to testify in her trial. According to Kouri's family, they were celebrating the purchase of a mansion for her business. She had bought it, going to finish it, and then flip it. First responders on the scene said they thought Eric passed of an aneurysm. In 2009, Eric and Kouri met while she was working as a cashier at Home Depot, and of course he was there buying products for his business. Her family thought a lot of Eric, and they said that he was a great dad. And in 2013, they got married. Her colleagues said that she was a brilliant business person. She usually would buy about 3 properties at a time to flip. Eric's autopsy revealed fentanyl. And Kouri's family said that Eric took THC gummies every day and not always from reputable sources. They also claimed that he liked to take pain pills. A spokesperson for Eric's family denies the claims of an accidental drug overdose, and they say that right from the beginning, they knew there was foul play.
We know Eric Richins died from an overdose of illicit fentanyl. According to Scortis, people have speculated of a potential drug problem Eric may have had to confirm the possibility of him overdosing of his own accord. But looking at documents, there is no history that Eric ever suffered from any substance abuse. Scortis says to assume that he had an addiction he hid from everyone is outrageous and untrue.
After Eric's death, the 3 boys were lashing out, so Kouri decided to write a book. The name of the book is Are You With Me? In the book, Eric is portrayed as an angel. Just weeks after her local television debut to discuss her book, she was arrested and charged with aggravated murder. Now, her attorney does say that the police never found any fentanyl on any of the glassware in the home. When Kouri's mother was asked about the relationship between Kouri and Eric and if they ever had any kind of issues or disagreements, one item brought up was that he did not want Kouri to work. He wanted her to be a stay-at-home mom. And the brother brought up that Kouri didn't like that Eric would take long hunting trips and stay gone. There was also alleged infidelity on Eric's part at some point. After that, they went to therapy, and Eric's family spokesperson said that he wanted it to work for the kids. He lived for those boys. So when he realized that he would stay in the marriage, to protect the boys, Eric put his estate in a secret trust, and he put it in his sister Katie's name without Kouri knowing anything about it. The prosecution is stating that, of course, greed is behind the motive of his killing. They say that he had 6 life insurance policies totaling nearly $3 million.
Officials say that the 4 life insurance policies on Eric's life totaled almost $2 million, and he reportedly knew nothing about them. When the two were married in 2013, it was established that both of them did not have the rights to each other's present or future income, property, or assets, except for if Eric died while the two were married. And between 2015 and 2017, Richins purchased 4 life insurance policies on Eric's life without his knowledge. When speaking to life insurance experts, they said that there are some cases where a spouse can take out life insurance policies without the affected party knowing about it.
1, a person may obtain insurance on a dependent who does not have legal capacity. 2, a creditor may, at the creditor's expense, obtain insurance on the debtor in an amount reasonably related to the amount of the debt. And the third is a person may obtain life and accident and health insurance on an immediate family member who is living with or dependent on the person.
At this point, it's not known exactly how Richins obtained the life insurance policies.
She had also stolen from his personal accounts and misappropriated money from his business. She was over $2 million in debt. Now, there's a lot of question behind Kouri's behavior after the death of Eric.
It's the case that just keeps unfolding. Kouri has been charged with 1 count of aggravated murder and 3 counts of possession of a controlled substance with intent to distribute. Here's what's been amended on those charges. We've now learned that after her husband Eric's death on March 4th of last year, Kouri hired a locksmith to open Eric's safe containing between $125,000 and $165,000. Eric's sister told Kouri she didn't have the rights to those funds, resulting in Kouri punching her.
So they believe what set all of this off was Kouri's purchase of a mansion that was just outside of Salt Lake City. She paid $3.9 million for it. And it was 20,000 square feet home with a 4,000 square foot guest house. The flipping guest house is larger than most of our homes. And it was located near a ski resort. When she purchased it, it had not finished. I think it was one of those things that the builder went into bankruptcy or something, and he just left it. So she would have to go in and put some money into it. But they had estimated that the profit would be around $12 million if they stayed on budget. Her attorney said that buying and flipping houses had its ebbs and flows with money, obviously. You know, you go in debt for a little bit to make a profit. But Eric's family thinks that he wasn't on board with her buying that house, and that what set everything into motion was their arguments about her buying it.
That 2 weeks after the death of her husband, Kouri placed the house back on the market, and now a year later, at an asking price of $3.7 million, it seems the house may have a new buyer.
So Eric's family believes that she had tried to kill him before his death in March of 2022 on 2 separate occasions. Once on vacation in Greece, where she claimed that the waitress had given him something that he wasn't supposed to get. And then before that was on Valentine's Day when she made him a sandwich that caused him to break out and have trouble breathing. Her attorney claims that he went and laid down afterwards, took a nap, and he got up later and went to the boys' sports game. So it wasn't a big deal. Here's what they have on Kouri that makes it kind of questionable. There was a woman who cleaned houses for Kouri who had a shady past with drugs. She had contacted that woman for fentanyl on more than one occasion, and she purchased 15 to 30 fentanyl pills that were sold to her for cash in February of 2022 before the Valentine's Day alleged sandwich poisoning. A week later, she reached back out to the lady for more fentanyl and said she needs something stronger. Now, the first time she paid her with cash, but this time she paid her with a business check. And the defense attorney said she paid this woman all the time for work that she did she cleaned houses. So how do you know she wasn't paying her for a house? How do you know she was paying her for drugs? So of course that's all up in the air. Now the problem is that because of this woman's past, she has drug charges against her. I guess she might still have some pending things. The defense, of course, is saying that they're using her charges against her to get her to say what they need her to say in Kouri Richins' case. And of course, she would get a lesser charge or they would drop her existing charges. You know, that's the normal thing that happens when there's a situation like this, right? The judge eventually denied bond for her in that hearing. That was in June of 2023. In September of 2023, Kouri had a medical emergency while she was in custody. And she said that they gave her the wrong medication. I don't know if there was I kind of wonder, was she like trying to unalive herself? I'm not really sure. Again, new to the case, we'll check into these little details. Now, since she's been in custody, Kouri has been writing her mother letters, and Kouri's mother is in charge of taking care of her dog. There's a letter called Walk the Dog that apparently everybody's seen out there. And it was questionable because they said that she was feeding information to her mother to get back to her brother, who was supposed to testify in her upcoming trial. I'm going to have to do some court docket diving on this one to find out more about these letters. They requested a no contact order to her mother or brothers because of that. And I've got to see if that occurred. So when she was questioned about these letters to her mother, she said that they were all part of a book that she was writing. She was not ever charged with witness tampering. As of now, the boys currently live with Eric's family. Her family has been denied private visits with the boys, but her mother does say that she goes to their ball games because they can't keep her from doing that. There's been multiple civil cases ongoing because of the money that Eric had left on his estate. So that's a whole nother docket to dive into and see what's going on there.
Camus' mother and children's author accused of killing her husband, once out of jail now. And if released on bail, Kouri Richins would wear an ankle monitor and would not be allowed to contact witnesses, among other things.
So her lawyers say part of what kept her in jail originally was the possibility that the state would seek the death penalty, something the state has since said it doesn't plan to do. They also say Richins has been a model inmate, displaying no signs of violence, as well as completing several certificate classes in jail. On top of this, her team argues her 17-month stay in jail has hurt her relationship with her kids.
In May of 2024, Kouri Richins fired back at prosecutors in jailhouse audio. She had an exclusive interview with ABC News.
Give me a chance to prove it to you. The world hasn't heard the real facts of the case. The media's twisted turned what they think they know or what will sell or get the most views. And it's time to begin some serious damage control. What I've really done is protect Eric at all costs. What I really didn't do is murder my husband. I could not and would not ever do that to Eric or anyone for that matter. I will not give up. I will not give in. Please, just give me a chance.
This audio was released just days after her attorneys had filed a motion to withdraw from representing her. They cited irreconcilable and non-waivable situation that emerged from her civil cases, which also required them to withdraw from her criminal cases. Okay, that's another story that we're going to have to get into here. So her attorneys were alleging that the state had listened to privileged jailhouse calls between them and Kouri, and the prosecution countered saying that the defense lawyer failed to download a specific app that shields those calls and that the prosecution did not listen to the calls. So the prosecutors are denying the allegations. Okay, so here's the dirty laundry part of the story. The case includes shocking allegations. The prosecutors are alleging that Kouri was planning an all-inclusive vacation with another man before, during, and after the death of her husband. According to the court documents, Kouri sent text messages to a person prosecutors are calling her paramour. That's just a real expensive word for lover, by the way. They're saying that apparently she said that she was in love with a man who's not her husband. I think I want you to be my husband one day. Not only did she say, I love you to this new man, she also said it 5 separate times in the week between her husband's death and his funeral in 2022. Now, the family of Eric Richins says that Kouri's statements are nothing but a ranting sociopath, a woman who has no compassion, no feelings, no sense of remorse or guilt for what she's done, and is only thinking of herself. So that's where we are now. What we don't know yet are the really nitty-gritty of this case. And that's what I'll be working on for you guys off and on until this thing goes to trial. Kouri Richins appealed to reconsider bail and release from custody. This was written on October the 23rd. The Utah mother accused of poisoning and killing her husband with fentanyl before writing a children's book about grief is renewing her request to be released on bail as her trial moves forward. Kouri Richins, 34 years old, has been in state custody since May of 2023 when she was charged with the murder of her husband, Eric Richins. In the 17 months since, her attorneys say that Richins has been a model inmate, and the wait for her trial has gone on for too long. I'm going to share this screen with you guys. This all comes from abc4.com. The judge originally denied Richins bail after a lengthy detention hearing in June of 2023. At the time, they determined that since Richins was potentially facing the death penalty for her alleged crimes and that evidence presented by the state of Utah could potentially persuade a guilty verdict from a jury, Richins should be held pending her trial. When the judge, I want to say it's Mazik, that's probably how you say it, made his decision, and she would face trial within the next few months. However, several delays, including a change in attorneys for Richins, pushed the trial back to May of 2025. The state also declared it would not be seeking the death penalty as a punishment if convicted. In the appeal, Richins' lawyer said that their client has a plan to live with her brother and sister-in-law in Salt Lake County. If released, the attorneys argue it will remove any risk of inadvertent interactions with possible witnesses in the case and allow her to have supervised visits with her sons, who they say have become estranged. She will be able to continue to work on higher education degree and will be highly motivated to comply with all conditions set by the court so that she can conduct supervised visitation with her sons. Mrs. Richins' family is prepared to provide essentials such as food, clothing, and educational resources, and they are committed to making sure that she appears at all court proceedings as required. According to court documents, the judge will consider the motion to grant the bail as well as any arguments from the state prosecutor against the motion. Some news clips that I put together for Kouri Richins so that for those of you that are new to the case like I am and trying to get caught up and figure things out, this might help you a little bit.
And children's author accused of killing her husband, once out of jail now. And if released on bail, Kouri Richins would wear an ankle monitor and would not be allowed to contact witnesses, among other things.
So her lawyers say part of what kept her in jail originally was the possibility that the state would seek the death penalty, something the state has since said it doesn't plan to do. They also say Richins has been a model inmate, displaying no signs of violence, as well as completing several certificate classes in jail. On top of this, her team argues her 17-month stay in jail has hurt her.
So see the blondes right there? That's her new attorneys. The gorgeous, the attorney she had before that, oh my gosh, she was absolutely gorgeous. They had to come off the case.
Relationship with her kids. A local defense attorney tells us this is a good, low-risk move from her lawyers at this point in the case.
It couldn't hurt her because all the judge could do is leave her in jail. It wouldn't. So if she is freed, her situation would be improved, but it wouldn't make her situation worse because she would just remain in jail.
The state removed the possibility of the death penalty for Richins again. Her team filed a handful of motions to expand the jury pool to Salt Lake County and handle it all in person. A ruling hasn't come down on those yet. Today's session focused on a lawsuit against her sister-in-law, Kouri Richins Benson. Now, Benson is suing Kouri for more than $13 million over the husband, Eric's estate. And the judge in the case is putting a hard divide between the two former relatives.
I'm inclined to adopt Mr. Yossi's suggestion that any meet and confer required under Rule 37, which is the Statement of Discovery Issues rule, occur in writing so that you are not in the position of speaking to lawyers that represent your adversary.
I like that, Judge. But you know what's going to happen if they let her out? There's going to be a whole bunch of sparks flying between her and the sisters, because it's already gotten heated. He signed over his entire estate to the sisters, or to one of the sisters, to handle. And it follows the kids. Wherever the kids go, his estate goes, which makes complete sense. But at first I was like, wait a minute. She had all this money, supposedly. She claimed indigency. Yeah, she attacked the sister. Are you telling me, or are you asking, JPC? She attacked the sister because the sister was trying to get into the safe to get the paperwork where all his files were or something. And I guess there was cash in there too.
Do you understand?
Yeah, I think that's perfect. I'm fine with that.
Cam's mother, accused of killing her husband and then writing a children's book about grief, is back in court today.
Kouri Richins' lawyers want the prosecution to be disqualified. Our Jonathan May is live outside the courtroom for us in Park City. Jonathan, why did the defendants make this motion today?
Well, that's right. Brian, Sarah, they argue Chief Prosecutor Brad Bloodworth or either the Summit County Attorney's Office as a whole should be off the case, saying they violated the Sixth Amendment, which protects the rights of the accused.
The conspiracy alleged that jail personnel are intruding into the attorney-client relationship and sharing information with the prosecution is speculative at best and bad faith at worst.
I can understand why your office is really pissed about the content of that motion, but that is not enough to form a Sixth Amendment violation.
This afternoon, a back and forth in the courtroom while Richins listened. The defense arguing prosecutors violated the Sixth Amendment by accessing recorded phone calls between Richins and her defense team.
The issue that concerns us the most is any finding that there would be a waiver of any privilege knowingly.
The defendant wanted to make a motion to either disqualify Bloodsworth or
disqualifying the Summit County Attorney's Office as the prosecution in this matter as a whole.
It is wrong for a lawyer to intentionally throw a wrench into the gears of the system of justice.
The evidence showed Mr. Bloodworth didn't listen to him.
I like that, Judge. He's cute too. You know what? She did sell that house, though. That mansion was sold. She lost like $1 million on it, though, I think.
And that jail staff did not read the substance of that notebook. That's it.
With that, the judge denied the motion. The court found no evidence there was a violation of Sixth Amendment rights.
Disqualification of Mr. Bloodworth or any other attorney in the Summit County Attorney's Office is not necessary to maintain the fairness of these adversary proceedings.
Behind me stands that house that was closed on, according to court documents, the night Eric died. Kouri says she told police that they were celebrating the closure of a home that she had purchased for her business. She was wanting to flip the house. She says she made Eric a drink, went to go put the kids in bed, and when she came back, she says that's when she found Eric. We know that Eric died of a fentanyl overdose. It's here at this house in Midway where those illicit drug transactions took place between Kouri and her dealer. The dealer telling police she left the pills at the Midway house. The house is nearly 20,000 square foot mansion. It boasts 8 bedrooms, 6 bathrooms, and a half bath, and a 3,000 square foot guest house, all on an 8-acre lot.
3 days after her attorney, Sky Lazaro, withdrew representing her in her murder case, a new law firm has been appointed. And this comes just a short time after recordings of Richins in jail were released. Now, ABC4's Annika Johns joins us with the very latest in this trial.
To be able to speak out for the first time is terrifying, but is much needed. The world has yet to hear who I really am, what I've really done, or what I really didn't do.
From behind bars, the Utah woman accused of poisoning her husband is breaking her silence for the first time. In audio released to ABC4's affiliate, ABC News, Kouri Richins shares words of her innocence and is asking for the world to give her a chance.
Give me a chance to prove it to you. Let me show you the facts. Let me show you the evidence. I will not give up. I will not give in. Please, just give me a chance.
The audio was released just days after her attorney Sky Lazaro filed a motion to withdraw from representing her.
Okay, this is 231-500-139, State of Utah versus Kouri Darden Richins.
Today in court, a brief hearing was held where Richins' former attorney was officially relieved of her duty.
Ms. Lazaro, your motion to withdraw is granted. You are being removed.
Okay, so Simmer Down, Texas is asking how they tied Kouri to the drugs. So apparently there was a lady that she hired to do housekeeping services for her because she would buy houses. She was a realtor. She would buy houses and flip them as well. So her having someone that did a lot of house cleaning made sense, right? So this lady apparently was involved with the mansion, and that's where she bought the drugs from that woman. And I think that woman already had some charges against her. So they kind of held it up against that lady, and she kind of had to spill the beans on Kouri Richins. It seems like they kind of bullied her into talking, or else they were going to press more charges against her. I don't know if that's how they got it out of her, but somehow they got it out of her. Okay. But anyway, that's how they figured out, because she had like 15 to 30 fentanyl pills. And then when she went back, that was in February of 2022. And then when she went back before his death, she told the girl that I need something stronger. So they think she tried on Valentine's Day to unalive him, and it didn't work.
Moved as counsel from this case.
And now Wendy Lewis, Catherine Nestor, and the team at Nestor Lewis PLLC are the newly appointed faces tasked with representing Kouri Richins.
We have a newly appointed indigent defense counsel, Ms. Lewis.
According to the law firm's website, Lewis and Nestor started practicing law together in 2022. And now moving forward with this case, the two of them have been given time by the judge to get familiar with the case. He canceled and rescheduled the preliminary hearing originally set for June 18th.
We are staying any briefing deadlines related to the motion to disqualify or the motion to suppress.
The motions the judge is referring to are first the motion to disqualify state prosecutors from the case. The second is a motion to suppress the 6-page walk the dog letter the Summit County Sheriff's Office located in Rich jail cell late last year.
What I've really done is protect Eric at all costs. What I really didn't do is murder my husband. I could not and would not ever do that to Eric or anyone for that matter.
The Utah judge allowing prosecutors to access only a few pages of a letter from her jail cell. Richins was accused last year of poisoning her husband and then writing a children's book on grief. Last September, prosecutors accused her of smuggling potential evidence out of her Summit County jail cell in an envelope marked attorney-client privilege. The judge partly ruled in the defense's favor, saying Kouri's writings is privileged and the defense won't have to hand it over, but prosecutors will be able to access a letter they claim another inmate wrote to Kouri.
This morning, the family of Kouri Richins, accused of fatally poisoning her husband, Eric Richins, and then writing a children's book about grief.
I just wanted some story to read to my kids. I couldn't find anything that really, suited them or helped them find comfort and peace.
Speaking publicly for the first time.
We know Kouri's innocent, and all that's going to come out in court. And I think that's going to shock people.
Days ago, while searching her cell, guards opening this letter in which prosecutors allege Kouri attempted to coach family and friends into giving false testimony on the stand. But Kouri's attorney says the letter was marked attorney-client privilege and should never have been opened in the first place. Her brother DJ accusing the jail of misadministering her medication to get her out of the cell.
And you say that they have messed up her medication 6 times?
6 times. 1 time is an accident. 2 times is incompetence. 6 times looks like it's on purpose. When I got the news that Eric had died, I broke down into tears. He was a good guy. I mean, he lived life to the extreme and, eventually got him. But it's my sister. I knew Eric. She didn't do this.
In the hours we spent with DJ this week, he painted a very different picture of his sister.
Her and the boys would go to church every Sunday.
What is she like as a mom?
She's a great mom. Those are the busiest boys you'll ever meet, whether it be soccer, baseball. There's always something.
So she's juggling flipping houses, which is a lot of work.
Which is a lot of work.
Kouri Richins' siblings say that just before Eric's death, the couple was doing well.
At the time he died, I thought they were probably in the best place they've ever been. Kouri told the police that he didn't use drugs to protect his image.
Eric's family disputes that.
He was a person who took very good care of his health, and so to try to cast the light on him that we've seen recently is really troubling. It's really it's sad.
Kouri Richins in court today concerning a plea in advance for a misdemeanor assault charge. That hearing, as you can see right there, virtual, about paying a fee and taking a thinking errors or grief course relating to the assault charge last summer. Now, her attorney says Richins was in grief counseling at the time, but she has no report or documentation on that treatment.
This was all due before the defendant was put into custody.
They weren't due until January 4th of this year. The monies weren't.
Okay, Your Honor, for the monies, that's correct.
Okay, so what we're talking about here is the class.
And if the state wants to object to a continuance, can we just set an evidentiary hearing on that? She is entitled to that.
That was going to be my point, Ms. Lozaro, that we're going to set the evidentiary hearing. But part of it is I also want to make sure we're talking about setting the evidentiary hearing on that second allegation, because that.
Okay, so as for the counseling allegation that Richins did not attend the class or counseling in that time frame she was given at the time of the court.
Yeah, Judge Mrazek has ruled to grant the gag order, but only in certain circumstances. The gag order was motioned by the state in hopes of limiting those involved in the case from speaking to the press. The judge says lawyers, past, present, and future, are not allowed to make any extrajudicial statements. Lawyers will be required to inform any witnesses, investigators, or members of their team about the court's terms.
With respect to preserving the integrity of the process, that is ensuring that Ms. Richins, who is presumed innocent, receives a fair and impartial trial and a timely one.
An unsealed search warrant obtained by ABC4 reveals new information about the early stages of the investigation. It sheds new light on how investigators went about researching Kouri's family and what they found. ABC4's Annika Johns joins us in studio today. She's been digging through some of these documents. Annika, tell us, what have you learned so far today?
Well, Sarah, so many of us, as we know, Richins is the Utah mom and children's author that is accused of murdering her husband. And now it's been revealed her mother was living with a female roommate in 2006 who unexpectedly died from an overdose of oxycodone. To be clear, Lisa Darden is not currently under investigation and has not been charged with anything, but these new filings do shed light on how investigators approached the Richins case.
I do not believe in my heart Kouri could ever not just kill Eric, but kill anything or anyone.
This is Lisa Darden, the mother of Kouri Richins. Richins is the Utah mother suspected of killing her husband Eric in 2022. And today, unsealed documents ABC4 obtained state detectives in the Richins case speculate Darden may have had a hand in her son-in-law's death.
I believe Eric may have gotten pain pills and didn't realize that they had fentanyl in them.
Document state detectives from the Summit County Sheriff's Office began to investigate individuals close to both Kouri and Eric Richins in May of 2023. As part of that investigation, the past of Richins' mother was looked into. Court documents revealed Richins' mother was the subject of a search warrant after investigators learned that a romantic partner of hers died in 2006 from a drug overdose. Shortly before her partner's death, Darden was named as the beneficiary of her partner's estate.
Now, see, that could have just given Kouri an idea. It doesn't necessarily mean her mother was in on it. I mean, I'm just saying.
Partner reportedly died suddenly from an oxycodone overdose. Darden's partner was prescribed oxycodone at the time of her death and had a history of abusing her medication. But documents state at the time of her death, Darden's partner was not in a state of recovery from her addiction, which would likely overrule the possibility of an accidental overdose. The similarities between both cases, detectives say, raise red flags in their investigation, further speculating Darden possibly was involved in Eric's death.
If you knew Kouri, she would never, ever do this, not only to Eric, but to those boys.
But prosecution tends to disagree with Mama about that one. So, innocent until proven guilty, I guess. We'll see what happens there. Viewer discretion is advised for this video, as we may end up discussing something that could be disturbing and graphic. But now we're going to dive into this whole financial thing. See, there was a hearing on August the 20, hang on. It was in August of 2024. They had a hearing. Now, there was supposed to be a bond hearing this past month, and they ended up moving it to, I think it's the 12th. But because she's trying to get out on bond since her trial's been moved back to next year. So In August of 2024, that's kind of when they had their preliminary hearing. They're presenting all the evidence, and the judge is going to rule on whether or not this can go to trial. Obviously, it ruled on that it could go to trial. But what I found interesting about this particular hearing was more so what the forensic accountant said, because she gets into everything that doesn't seem right about the financial side of it. All right, let's get into this. The prosecution called up their third witness in the hearing. Her name is Carrington. She's a forensic accountant. Quick note, CPA versus forensic accountant, big difference. She had also testified at the detention hearing. Now, they did bring up that she had originally been hired by the estate of Eric Richins. And eventually, when the prosecution asked her to work with them, she then ceased that contract with the Richins family and began working with the state on the account. Now, she's reviewed bank accounts, insurance documents, loans, email communications with the loan and insurance applications, and all that back on, going all the way back to, I think, 2018 on their accounts. She said they had various accounts. There was one under the Kouri Richins Realty account, and Eric did not have access to that. There was one that was both of their joint accounts, which was like their household and family expenses. There was a third that was Kouri Richins' personal account. And then, of course, there was an account under Eric's business, C&D Masonry. Now, they made a note to mention that in April of 2019 is when Kouri began her business. She was a licensed realtor, but she primarily purchased homes, fixed them up, and then flipped them. And in April of 2019, that was when it was a nice housing market. The interest rates were low. The market was booming at that point. She also noted that the premarital agreement between Eric and Kouri basically said that the C&D Masonry property, business, money, all that was to be maintained separately from their marriage. That was part of their premarital agreement. The only thing that would trump that would be if Eric had died, then Kouri would would have access to the business. Now they're starting to dive into. We know that the state has alleged that Kouri was taking money that Eric was unaware of, and they've brought up that, okay, if you're going to buy and flip houses, you need money. You need cash quick, and you need to be able to purchase the houses quick. And they brought up the fact that there was a home equity line of credit that was taken out on their home in March of 2019. Now, what is interesting is that the home itself, this is the home that they lived in. Eric was the sole owner of the home. But in March of 2019, there was a loan application that was signed by Kouri referencing power of attorney in regards to a line of credit against the home, like a second mortgage type thing. So it's getting deep. We're starting to dive into all this now, and we're going to see exactly what's going on with how she was able to kind of move funds around. This is actually what I find to be most interesting of all of the evidence they have. This is damning evidence.
I'd like you to take a look at now. Lost control. It's always right here. We do have it in here. think we have marked them as State's Exhibit 70 for the court. I'm going to approach the witness.
Of course.
I'm not sure she has State's Exhibit 70.
Go ahead.
Can you please just describe or the title of that document for the record, number 70?
This is the Willow Court Loan Advances and Payments.
Okay. When is the first withdrawn that home equity line of credit?
It's March 26, 2019 for $60,000.
When is the next withdrawal?
August 5th, 2019.
Could you describe the next couple of withdrawals on that?
Following that $2,100 in August, there are a series of withdrawals for the next few months.
Okay. In August, is there more than one or just the one?
There are several.
Does that strike you as important for today's
Yes.
purposes? Would you explain to the court what you draw from that?
Beginning in August of 2019, this is around this time is the first property that Ms. Richins purchased after obtaining her business license. It's a home in Heber City. As far as I know, that was the first home in Utah that she flipped.
We have State's Exhibit 71.
Mr. Bruce, are you offering State 70?
Yes, yes, I will be offering State 70 and 71 as summary charts.
Okay. Is Nestor any objection?
No, sir.
Okay, 70 and 71 are admitted.
Could you read for the record the title of 71?
Encumbrance and Real Property Chronology Trust Deed Summary.
So what, does that help you state for the record what that first transaction was and where?
Yes. It's the 550 house. The first warranty deed involving Kouri Richins Realty was August 1st of 2019.
Now, I'd like to portray that in another way. Did you prepare a timeline bar chart?
Yes.
Does it depict much the same information, just in
different format? Yes.
Would that be helpful in conveying your testimony?
Yes.
Okay. The state would offer State's Exhibit 69, and we're just going to build the first chart.
Is Nestor any objection?
No, sir.
State's Exhibit 69 is admitted.
That's the whole PowerPoint? I'm sorry.
It is, but I've only laid foundation for the very first.
Got it.
Is that the chart you were just referring to?
Yes.
And so, can you just explain for the judge how this chart works?
Sure. I think you've seen this before, and the colors don't mean anything. They're just to distinguish one line from another. I've just got the years along the top and the months, and then going down the different properties just as some sort of an illustration to depict when properties were held at any particular time.
And then within each bar is the address of the property purchased?
Right, and so if you wanted to know what was held in June of 2021, you could draw a vertical line to see which properties were owned at that time.
I see. Okay, so any more purchases in 2019 by Kouri Richins Realty?
Not that I know of. There could be others, but this is what I have been able to compile.
How about in 2020?
2020, yes, there were others.
Okay, how many purchases by Kouri Richins Realty of properties in 2020?
I think there were just the 5.
Now, is there one that stands out to you?
In 2020?
Yes.
Not particular. Well, the Franson Lane one toward the end of 2020, in October of 2020, the Franson Lane property in Oakley.
I see. Let's drill down into the Franson Lane property. You said, when was that?
It was acquired in October of 2020.
Is it different from the previous 5, I guess, county 2019?
Yes.
In what ways was it different?
It was a more robust project, more ambitious project in amount. You know, it was. I think she acquired it for 1.3 million, and the others had been somewhere in the neighborhood of like $300,000 or $400,000 or $500,000.
Did she require money, outside money?
Yes.
To make this investment?
Yes.
What sort of investors?
They were hard money lenders.
Do you know who they were?
Yes.
Who are they?
Sierra West Capital was the primary lender, which is this, as is the case on several of her properties. And then there were other investors who contributed the funds basically for the rehab.
I see. Was there something else different in this application that you garnered from all the financial records?
I'm sorry, I didn't understand your question.
That's the way I roll. Okay. Was there something else that you found in reviewing all of the documents, not just the loan documents, that distinguished this purchase as opposed to the ones that had gone before it? Involving, all right, how about this? Do you know if C&E was involved in this project?
C&E was involved in this project.
Okay. And what did you discover about C&E's involvement?
After the acquisition of the Oakley property, the Franson Lane property, C&E, there are several checks from C&E that were deposited to the Kouri Richins Realty account, and they specifically have a memo on them that tie them to this property. And so over the next, between October and when this property was sold in March of 21, there are a series of checks. I think there are 6 or 8 checks that are about $133,000, I think.
Was this property ever sold?
Yes, it was.
When?
In March of 2021.
Okay. What happened to the proceeds from that sale?
This was a property where the net proceeds were about $466,000, which came into the Kouri Richins Realty account, that 6577 account. And then from that, $217,000 was paid directly to C&E. And then there were some other payments, transfers out from the account that were associated with this property as well, and left her with about, around $200,000 in net proceeds.
In your examining of all the evidence in this case, were there other things that you looked at to inform your examination that took place in October of 2020?
There were other things in October of 2020, yes.
Did you take a look at State's Exhibit 22? Are you familiar with that document?
Yes.
Could you explain what it is?
This is an intake form from a divorce attorney describing that Eric Richins was wanting to consult with this attorney on a potential divorce, and it's dated October 8th of 2020.
In the wake of that, are you aware of any other instruments that were created out of that?
Yes, there are the notes that the attorney appeared to have handwritten during the course of that first meeting.
Were there financial arrangements made after that meeting that you're aware of?
Yes, the notes indicate that there was some new information by Mr. Richins that there was the HELOC had been taken out on the home, that as if this was new. And then from this, he set up the Eric Richins Living Trust and also a will.
Was there something dramatically different about the trust situation as before?
That Ms. Richins was not the beneficiary of his estate. It was to be for his children, and the trustee was going to be his sister, Katie.
So I'd like to go back to 70. It should be the HELOC loan balance for will. By August of 2020, what was the balance?
August of 2020, $246,931.
Okay. Is there a significant, well, up until that point, how was there money being paid on that debt?
Yes, they were the interest-only payments. The minimum payments were about $900, $1,000, something like that, that were made every month.
Did something different happen in October of 2020?
Yes.
What happened?
There's really the first significant payment, and it's $50,000 on October 12th.
Do you know what the source of that fund was?
Yes, Ms. Richins had sold the Cleveland Avenue house in Salt Lake, and from that she received net proceeds of about $63,000. There was a transfer, and then this $50,000 was sourced from that.
On October 12th?
Yes.
Bringing the balance to approximately what?
$196,000.
Do you know whether in October she was in a financial position to just pay that $196,000 off?
She was not.
Let's go into 2021. I guess we've still got the timeline up. Direct your attention to timeline. And could you describe for the record a summary of what purchases, et cetera, took place in 2021?
Yes. So she acquired a property in Heber City before she got the proceeds from Branson Lane. And then after that, she acquired a number of properties throughout the summer especially, and then ending the year acquiring 3 on the same day in November. And I think there may be another property that she was working on that I don't have on here, but all in all, she had about 15 properties in 2021.
So, did she go to the same lenders for all of these 15 properties?
No, there is some consistency in the lenders, but she did diversify a little bit.
Okay. Can you tell the court some of the lenders that you found? that she used?
So she primarily used the Sierra West, and that's pretty consistent through here. And those investors who would have been taking second, third, or fourth position were pretty consistent as well.
Those are like Cockerhands?
Cockerhands, Ellis, Soto, Lieb. There's a number of them.
Okay.
And then she also went to a company called Ironbridge, a company called Boomerang. She did 4 projects with Boomerang.
So let's take, when did she go to Ironbridge and when to Boomerang?
Those were in the summer of 2021.
And Ironbridge, how would you describe what Ironbridge is or does?
They appear to be a hard money lender. The terms are somewhat more flexible than typical hard money lenders, but the interest rate on that loan, I believe, is 13%. Was 13%.
And in 2021, is that high?
That would be high, yeah.
So, how did the application process go between the defendant and Ironbridge?
There is an original application that is submitted. It appears to be online. I don't know that for sure, but it appears to be online. And then there was a series of emails back and forth where the person analyzing the loan or underwriting the loan is asking her to submit some additional documentation.
Okay. Can you take a look at State's Exhibit 58, please? Is that what you were talking about? Some email going back and forth between Ironbridge and the defendant?
Yes.
Okay. Is there something about a bank statement in there?
Yes. That's her personal bank statements, the most recent.
Okay. Based on your experience and training, why would they want to know that stuff?
Typically, they'd call that proof of funds. They want to, they need to verify. In banking terms, it's KYC, know your customer. Every financial institution needs to know and verify the individual and entities that they're dealing with.
I'd like you to take a look at State's Exhibit 59, if you would. What is State's Exhibit 59?
This is a secured promissory note for what I call the 299 house.
I'm muted again. Sorry. No, I was just saying that they said that when she sold that first house, she profited like $200K, and then she paid back like $270,000 to C&D Masonry, his company, which means he would have known that she owed him money, which made me think that he knew that she had done that line of credit. I could be wrong, but I don't know. Now, just to run over this really quick. He did at one point go to the divorce attorney. He visited them. He decided to stay in the marriage for the kids. They're saying that he decided to stay in the marriage for the kids. And when he did that, he went in and set up that trust with his sister's name on it. And Kouri had no idea that he did that with the life insurance. Okay. Back to the thing.
In Heber, Ironbridge.
And first of all, this is Kouri Richins Realty purchasing this. Is that what it?
That's right. And I misspoke. This is 10%. I had misstated the interest rate earlier.
And what is the amount that they're loaning
$346,500.
When?
This is in July of 22. I'm sorry, July of 21, sorry. It's signed July 7th, 2021.
Now, did you examine a bank statement from Iron Bridge purportedly given to them by the defendant?
You mean from Iron Bridge, meaning?
It was obtained from Iron Bridge, so but submitted to it that it used to.
It was part of the Iron Bridge loan information that we received, yes.
Okay. Would you take a look at State's Exhibit 11, please? What is State's Exhibit 11?
This is America First Credit Union bank account statement for May 31st, 2021 for Kouri Richins Realty, account number 6577.
And do you know where this was sourced from?
This was sourced from Iron Bridge, as indicated by the number on the top.
Okay. And how do you know it's Kouri Richins Realty?
The header on the bank account statement purports to be Kouri Richins Realty.
And then in the body of that statement, does it give the amount in the bank account?
Yes.
What is that?
The summary of the accounts for the three accounts that are included in this bank account statement is $210,898.61. That's the ending balance.
So I'd like to direct your attention now to State's Exhibit 12. What is State's Exhibit 12?
This is the America First bank account statement for Kouri Richins Realty for that same month, May of 2021, for account 6577. This is the actual statement that we received from America First Credit Union.
In what way is it the same, and in what way is it different from the State's Exhibit 11?
The header is the same, but the body, the transactions that are contained are different.
What is the total balance?
The total balance is $15,609.
All right, let's take a look at State's Exhibit 13. What is that?
This is the actual bank account statement for C&E Stone Masonry, ending in 7664. This is the document that was received directly from America First Credit Union.
And how do you know it's C&E's?
The header indicates that it's C&E's, and the transactions appear to be consistent with what C&E would be doing. And it matches the bank account statement that Iron Bridge produced, but it has the different header on it.
So let me make sure I understand this. 11 has a header from her account, Kouri Richins Realty, but yet the body of C&E's May 31st bank statement.
That's correct.
I'd like you to take a look at State's Exhibit 60. That's 60. I believe that's an email exchange. Is that right?
That's right.
What's the subject?
Quick question.
Okay, and is the quick question physically below the response? Is that?
Yes.
Okay. So what is the quick question?
This is from Mr. Caney, I don't know how to say that, from Iron Bridge. emailing Ms. Richins asking for an explanation about her credit score, the credit cards, and referencing that bank account statement.
Okay. Is he perplexed? I mean,
Check speculation.
Sustained.
Specifically, what does he say to her?
He says when he first ran credit, it was lower than expected. There were some delinquencies on the credit cards, but he can see from the bank account statement that she provided that she's got plenty of money in the bank to cover expenses.
How does she respond to that?
Would you like me to read it?
Yes, please. If you just read what she says to that question.
She says, "Hi, Richard. Hope you had a great 4th of July weekend. Yes, sure. Everything is paid off now. It just probably hasn't updated. I recently learned about all of this as well, LOL. And then my husband decided to explain to me that this was his doing a while ago. We are in the process of separation for one of many reasons, but this is one of them, to keep it short and sweet, LOL. It's been crazy to say the least. I look forward to working with you guys on our first and hopefully many projects."
Okay, you said that she obtained some loans from Boomerang 4, I believe you said.
Yes.
I'd like you to take a look at State's Exhibit 14, if you would. What is State's Exhibit 14?
This is from Boomerang, but it's an America First Credit Union bank account statement. Kouri Richins Realty, account 6577 for June of 2021.
And how do you know it's Kouri Richins Realty?
Just the header.
What is the balance on the
The ending balance is $702,831.
Let's take a look at State's Exhibit 15 then. What is that?
This is the actual statement that was obtained directly from America First Credit Union for Kouri Richins Realty, account 6577 in June of 2021.
The header says Kouri Richins and Realty in the 6577?
That's right.
What is the ending balance?
Ending balance is $15,339.
Okay, let's take a look at State's Exhibit 16. What is that?
This is the actual bank account statement that was obtained directly from America First Credit Union for C&E Stone Masonry LLC, account 7664 for June 2021.
And it presumably says C&E and 7664
Yes.
in the header?
In the header, yes.
What's the ending balance?
The ending balance is $702,831.
That's the same as State's Exhibit 14?
The one that was issued to Boomerang, or submitted to Boomerang, yes.
Okay. So once again, cut and paste of header for Kouri Richins Realty and the data, the amount of money on hand from C&E.
That's correct.
Direct your attention to State's Exhibit 61, if you would. Could you describe for the record what this is?
Yes, this is from Boomerang. This is a document that came directly from Boomerang. It's a kind of an internal review summary of a potential loan, kind of ahead of it would be prepared in the midst of the approval process.
Just a quick note I wanted to tell you guys that she originally had a paid attorney. She had a really good attorney. And because they went into a civil suit with that money on the estate, I guess she was using his money to pay for the attorney. then Sky, exactly. Sky something. She's a gorgeous woman. They had to, she had to go public defender. She had to claim indigency. So now she's dealing with a public defender job, or dealing with someone that's been assigned to her by the public defender.
And what was the property?
This is for the 75 East Midway House, I think. Yes. The smaller Midway House.
Okay. And in there, does it reference, well, first of all, how much is the loan amount?
The loan amount on this is $454,750.
And does it talk about the defendant's liquidity?
It does on the second page.
What does it say about it?
Let's see. It says under liquidity and net worth, Kouri has liquidity in the amount of $702,000. She has a net worth of $2,719,000 made up of cash, securities, life insurance, retirement funds, and real estate investments.
And so that number 702,000 is that same figure from CNE that she's submitted in State's Exhibit 14?
Don't remember the exact exhibit, but yes, that number is drawn from that bank account statement that was actually CNE, not Kouri Richins Realty.
Did you find any other instances where this similar type of cut and paste header with some other account was submitted to lenders?
Yes.
How many times did you find that?
I found 6 so far.
Including these two?
Yes.
Now, I'd like you to take a look again at the timeline.
Yes.
Okay, so these purchases in 2021, you've already mentioned, it's 15, more and more. Did any of them sell?
Yes, great number of them did, yeah.
Okay, tell us about that.
As like the Mill Creek House, for example, that was acquired in the spring. That's a home in Salt Lake County. And so there was a primary lender on that, and multiple investors who gave Kouri Richins Realty money for the rehab costs. And then when it was sold, most of those were paid from closing, like at the title company. Some were not. Some came out of Kouri Richins Realty's net proceeds.
So she's turning over property, isn't she gaining money by doing this?
Yes.
Okay. What's happening to her debt load?
That was increasing, especially she started in the middle of summer of 2021. She started acquiring personal property loans that they're not secured by real property and were secured by advanced, her future receivables.
Okay. Is Greengrass holding one of those?
Yes.
Okay. Turn your attention to State's Exhibit 20. So could you, first of all, tell us what State's Exhibit 20 is?
This is a revenue purchase agreement dated, it's in September of 2021.
And could you explain the basic terms of this?
This is an agreement with Kouri Richins Realty and then some other companies pledging $87,000 of advance receivables for $60,000 upon execution of the agreement, and e-signed by Kouri and Doreen Kouri.
Okay, so let me make sure I understand this. So she's saying, I will give you $87,000 of money I haven't earned yet, but I'll pay it to you in the future if you give me $60,000 now.
Yeah, and what's represented here that it's been earned and it's going to be coming in, but it's not in yet. And so she's saying, I'll pay you back $87,000, $60,000 now.
I see. Okay. And what did it obligate her to pay?
$5,438 every week.
Did she pay that?
For a series of payments, yes.
Okay. How much did she pay the year worth?
I think she paid about $20,000. I'm not exactly sure the amount on there, but she paid about $20,000 and then defaulted in December.
Did something happen as a result of that default?
Yes, they filed suit in New York.
Okay, the state would direct your attention to State's Exhibit 21. Could you describe for the record what State's Exhibit 21 is?
This is the summons and the verified complaint associated with that lawsuit.
And so in a lawsuit like that, there's some alleged facts?
Yes.
Okay, so I direct your attention to page 5, fact number 11.
Yes.
And what is the allegation there?
That she did pay $21,752, leaving the balance of unremitted receivables of $65,248. And then there's default fees of $2,500 and attorney's fees of $19,574.
Did you find any other agreements or attempted agreements between the defendant and these type of lenders?
Yes, I found several.
Okay, what are they?
QFS Financial is one she entered into where she pledged $167,000 for future receivables for $105,000. That was the largest one by far. Most of them are in the $20,000 to $30,000 range.
Is Blue Bridge something like that?
Blue Bridge is one, Delta Bridge Funding, Zahav, Asset Management, Crown Funding. There are over a couple of dozen, over a dozen, yeah, about 20 or 25.
You mentioned early on that the defendant had an account with Navy Federal.
Yes.
So Navy Federal, do you know what kind of account she had there?
At Navy Federal, she had a checking, a savings, and a credit line.
Okay. During the period of August to December of 2021, do you have any idea? Well, first of all, what was the maximum amount for that, the credit limit for that revolving line of credit?
That was $15,000.
For that period, August 2021 to December 2021, do you know what her balance was, relatively speaking?
Bill, it was almost maxed out most of the time during that specific review period. I would say, I think that's about $13,000.
Okay. Can you take a look at State's Exhibit 26, please? Is that a multi-page document?
It is.
So what are they?
These are the bank account statements for the account ending in 0060, starting in July of 21. Ending in March of 22, and for Kouri Richins.
Does the statement include the balance on revolving credit?
Yes.
And throughout that time period I just mentioned, it's more or less maxed out?
Yes.
I'd like you to take a look at State's Exhibit 27. Do you know what those are?
Yes.
What are these?
These are checks from the account of Kouri Richins at Navy Federal, and these checks were deposited into the account of Kouri Richins Realty. I believe all of these were deposited into that account, and none of them cleared.
Let's just do an exercise of one of these. Let's take a look. What's the check number on the very first one of State's Exhibit 27?
Check 271.
And when is that?
The date on the check is 8/28/2021.
Can you find that transaction in State's Exhibit 26, which is those statements for that appropriate time period?
Yes. Yes. It's on, the Bates number ends in 99 at the top, and it was returned on 8/31/21.
So that check, and how much was that check for, that particular one?
$2,100.
And all of the checks then in State's Exhibit 27 are similar in that way.
That's right.
So now we're at December of 2021, the end of the year there. What is her financial status at that point?
All in all, with all of the property, she had acquired and sold a number of properties. She retained several as rentals. She still had loans on those properties. So at that time, it was about $4 or $4.5 million that she still owed on those. Well, the trust deeds, she had paid some on them, but there's that. And then with all of the personal property loans, it's hard to tell for sure, but I think somewhere around $500,000 or $600,000 she owed on those personal property loans as well.
Now you mentioned that one, for example, was green grass.
That's right.
Required her to pay $5,000 weekly?
$5,438 weekly, yes.
Were there some that were daily?
Yes.
And how many payments did she have to make for the month of December, for example?
She made about over 90 payments on debt. You know, there's a difference. There's the debt load and there's the debt service. So she owed the amounts that I stated, and then the debt service are the payments that she paid on that debt. And they're little, well, there's over 100 that she paid payments.
So for the month of December, how much debt service is just what she paid? Not necessarily, it could be the same as debt load, but.
In this instance, no, it's different.
Okay.
Yeah.
What was the debt service for the month of December, do you know?
It was over $300,000.
I'd like to take a look at, this is back to State's Exhibit 69. I'm going to move on to the next chart. Can you describe for the record what this next summary chart is?
This is the debt payments that she made during these months.
Once again, this is debt service, not debt load.
That's right.
Okay.
This is not the amount of debt she possessed. This is the amount of payments that she made on that debt.
Okay, and for the months of
June of 2021 through February of 2022. And I do need to make a note that in preparing for this hearing, I've noticed that in December of 2021, I made a duplication. So we need to reduce that number by about $44,000 in December. Because it's still about $320,000.
Now, in January and February, it appears to go down, is that right?
That's right.
Let's once again look at the same information expressed differently. Can you describe this for the record? This is the third chart on the PowerPoint.
So this is drawn from that previous data. And so it's just showing it in a pictorial format.
It seems after December, it seems to be going through the floor.
That's right. These are the payments that she made on the debt. She did pay off one of her lenders, one of the personal property loans. She did pay that off in January. That was about $19,000. But mostly because of what had happened in November and December, so many transactions had been returned and not cleared by the bank. They did not. Some of them continued to try to draw in January and February, but they were unsuccessful. And so those payments were not made.
So this doesn't depict her debt load, the amount of debt she has, but rather she's just not paying.
That's correct. At least from the accounts I have. At least from the accounts that I have reviewed.
Sometime around this period, did she take on another project?
Yes, she did.
Is it different than previous projects?
You're talking about the Legacy Way project, the large house?
Oh, okay, yes. Tell me about that.
She, the first REPC, which stands for Real Estate Purchase Contract, was in December of 2021, and it's a very large property on Legacy Way and Midway, and that's the property that she did end up closing in March of 22.
Okay, so it begins though in December and concludes when in March?
Well, the settlement statement I had seen is dated March 4th. Some documents were signed March 4th, some were signed on the 7th and recorded on the 8th of March.
How is this different from any of the other previous projects?
It was an unfinished house and just quite large, a very, very ambitious project. The purchase price, I believe, was $2.9 million.
What was its state of repair?
It was under construction, so it didn't have much inside, down to the studs, exposed wiring, things like that.
Did she ever, that you're aware of, give an estimate to lenders about what she anticipated those costs would be to rehab it?
Yes.
What was that?
Her estimate was between $3 and $4 million to rehab that property once it was acquired.
And how did she obtain this property?
Through hard money lenders.
All borrowed then?
Pardon me?
All borrowed?
Yes, all borrowed.
Okay, I want to talk about life insurance. Have you had the opportunity to look at life insurance policies that were owned by the Richins family?
Yes.
Do you know about how many there were?
I think there were 6.
This is the fourth chart before from State's Exhibit 69 PowerPoint. Can you describe what that is?
Yes, these are the life insurance policies on Eric Richins' life, and I've taken the effective date. Some of them were in 2015, 17, 18, and there's the one in 2022.
Okay. And those dates, those years are the date of purchase?
That's right.
Are they different, for, I guess, different purposes?
It appears to be, yes.
In what ways?
Oh, the first one on the top is a mortgage insurance policy. So basically, it would pay off the will pay down the mortgage. I think it's some odd amount, like 72.05% or something. But
okay. Was there one for business?
I believe so, and I am unclear as I sit here if that's that $1 million one or not. So I'm sorry, there is one on the business where Eric and his business partner, if one passed away, then it would benefit the other and allow the other one to buy out the business from the estate of the other.
Okay, so it doesn't go to the spouse, but rather to the other business partner.
The business partner.
To buy out the spouse.
Yeah.
Are you familiar with the life insurance company called True Stage?
Yes.
Is it some sort of business association with PenFed?
Yes.
To your knowledge, what is that relationship?
Well, True Stage is an insurance company, and they typically market their product to credit union members, all sorts of credit union members, different credit unions.
Do you know whether the defendant was a member of PenFed?
She was, yes.
How about, do you know whether Eric Richins was?
I know that he was not.
Direct your attention to State's Exhibit 62. And what is that, just for the record?
These are the bank account statements for Kouri Richins at PenFed Credit Union, the account 9118, for the period starting in October 2021. It's just through April of 2022.
And State's Exhibit 63. What is that?
This is a declaration of custodian of records, no records. This is from PenFed Credit Union, stating that Eric Richins did not have any accounts at their institution.
Are you aware of an application from the defendant to True Stage for life insurance in January of 2022?
Yes.
All right. Direct your attention to State's Exhibit 17. What is State's Exhibit 17?
This is the application for True Stage individual term life insurance to ATD. And this is dated the end of January 28th or 29th of 2022.
And who's applying for what in this application?
This is for life insurance for Kouri Richins and for Eric Richins.
Now, is there something unusual about the information provided, contact information for each of those two applicants?
Yes.
Tell us about that.
The contact information is the P.O. box that Ms. Richins used for her business. Her email address is on there. There's no email address for Mr. Richins, and the phone number that's listed for Mr. Richins is not correct.
How is it different? Do you know off the top of your head?
Yes. It says 892. His number starts 792.
And then ends with the 9317.
That's correct.
To be clear, the mailing address is the business address for Kouri Richins Realty for both of them?
Yes, this is pre-populated. It appears to be pre-populated this way with Kouri Darden Richins and her PO box in Camas.
And when is it effective?
This policy was effective February 2nd, 2022. Okay,
direct your attention to State's Exhibit 65. Now, before I go there, I'm sorry, I skipped over something. Early on, we talked about docket 127.
Yes.
That was, if I remember correctly, that was Throckmorton's report.
That's right.
And in there, he has how many question samples?
3 questioned samples, yes.
And so 1 and 2 are the power of attorney we've already addressed.
That's right.
So question number 3 is?
It's the signature on this life insurance policy.
I see. And so is your understanding what?
He calls them simulated forgeries and that they're probably not Mr. Rich's signatures.
Okay, so now let's go to State's Exhibit 65. You ready? What is State's Exhibit 65?
This is a letter from True Stage Insurance to Eric Richins at that PO Box 759, dated February 4th, 2022.
And what is it informing Eric Richins of?
This is a welcome letter. Thank you for choosing True Stage Life Insurance and talking about the premium. The premium would be deducted from the checking account 6577, which is the Kouri Richins Realty account.
Okay.
On February 14th for $46.50.
And that's an automatic withdrawal?
That is.
Okay. Have you examined AFCU account for Richins Realty? That's 6577 for December, January, February of December 21, January, February, March even of 2022?
Yes.
Okay. So in 6577, is there that automatic withdrawal that you were talking about?
There is in February, yes.
Is there any other insurance premiums that are paid from 6577?
No.
Okay. Now let's take a look at State's Exhibit 64, and I'll let you just take a look at what 64 is and 37.
What was the second number?
37. Could you describe for the record, what is 64?
64 is part of December. So this is an America First Credit Union bank account statement from America First Credit Union. Eric Richins account 2204. So this is the joint account where the typical household expenses were paid. And it is for December 2021, pages, and it goes through, March 1st of 2022.
So looking at those, are there any of the insurance premiums that you've mentioned before paid out of 220?
The payments that had previously been made, historically been made, I should say, are paid here, but not that one.
But not the new one, just all the previous ones.
That's correct.
So, just a second. Have to steal my courage. Oh, okay. So we are looking at, in your chart there, I guess that you find evidence of payment of those top 4 in your chart?
I'm not sure.
The 204?
The payment of the premium?
Yes.
Yes,
But not the bottom one.
that's correct.
Do you know if the defendant made any claims on those insurance policies?
Yes, she did.
Particularly the true state?
Yes, she did.
Okay. How does the claim process work?
Just for a certificate for that microphone.
How does the claim process work?
A claim is made, the insurance company would initiate a claim, give it a number, and then proceed to do their due diligence.
Okay. A couple of things. Based on your experience and training with working with insurance companies, is there a convention for naming these claims?
Yes, everyone's got a little bit different process, but in this situation, there are 2 different claims that we can see from the information contained in the diary that the insurance company kept, and also the name, the number of the claim. We can see what day it was opened.
I see. Okay, so in addition, is there any are insurance policies treated differently if they're made, a claim is made on them near in time to when they're opened versus if you've had a policy intact for 10 years or something?
Yes, I worked on, I don't know, a few dozen death investigations, and what happens, every insurance company will have a different policy, but typically if a life insurance policy is taken out and there's a death of the insured within a certain period of time, usually it's a year or 2, there's a standard death investigation that takes place. And I worked on many of those throughout my career.
Okay. I'd like you to take a look at what's been marked as State's Exhibit 18. Now, what is State's Exhibit 18?
This is notes for claim 2204-28003. So this would be the claim opened on opened on April 28th. It's probably the 3rd one that they assigned that day or something.
Okay. And so that, do you know which policy this is referring to?
This one is the larger 2. This is the $250,000 policy that from 2017.
And is this what you referred to earlier as a diary?
Yes.
Okay. I think we have an State's Exhibit 67. We just, at the beginning of the day, I think offered State's Exhibit 67 is.
Yes.
Yes, I do. It's right here. It's
And can you identify for the record what State's Exhibit 67?
Yes. This is a similar document. This is for the other claim, number 2204-22032. So this is the claim that was opened on April 22nd, 2022, and this is the first one is for the $100,000 policy.
And it was opened on April 22nd of 2022.
That's right.
Okay. Let's look a little closer then. First of all, with State's Exhibit 18, can you describe what this is recording and how it works with business?
This is a chronological diary, just note taking about the date and time of a call or a contact, and just some notes. So over time they can go back and refer to what happened and when.
Now this is State's Exhibit 18 is referring to the 2017 policy.
That's right.
And it was made then by April 28th, so a week after the other minor.
Yes.
Okay. In there, does the defendant ask some questions, or I guess is the insurance company asking the defendant some questions about the case?
Yes.
Do they want to know about fentanyl?
Yes, they needed the final death certificate showing the cause of death, and then they need to know if the fentanyl was prescribed.
And does the defendant respond to that?
She does. Toward the bottom, she said the fentanyl was not prescribed, so she can't give any information about it. She also added that she don't have any idea how did her husband got that. Just for the record, that's what it says. That's not my grammar.
Let's turn to State's Exhibit 67. Now, to be clear, this is the first in time request.
Yes, it is.
And the policy that she opened, and I believe was effective, you said?
February 2nd. Mm-hmm. Yes.
At some point, I think in July of 2022, is there a conversation between the defendant and the insurance company about what's taking so long?
Yes. This would be, well, there were several conversations in July. They're talking about needing the medical records from the medical facility. And then finally in August, that they say, she called to know the status of the claim. And then they said that they had received the medical records from the clinic.
Okay, I wanted to. All right, so they finally get them when? The medical records?
That's, according to this, is 8/15/22.
In the, you see the entry 822, the bottom of page 2?
Yes.
Are they talking about the medical records there at that last?
It looks like, yes.
And that they received them on what day?
Well, this is when they received the invoice.
It's the invoice, the payment. All right, so do they describe what is important to them as far as this investigation in at least one of those 822 entries?
Yes. Yes. It looks like they received the records on 8/2 and 8/11. I don't know if that matters. Okay, yes, they received the 36 pages of records on 8/11. And then there's substance use other than prescribed. It's marijuana once or twice a year. and no concerns about substance abuse in the household.
I have a moment.
Yes.
That's all the questions I have.
Who is doing the questions? Ms. Nestor, level with me. How much time do you think you have with Ms. Harrington?
30 minutes.
Okay. Do you have a bus warrant?
By a gentleman named Todd Gabler, is that right?
That's right.
And Todd Gabler is a private investigator, also not law enforcement at this time.
I don't think he's ever been law enforcement, but that's true.
And how did you know Mr. Gabler?
We've been colleagues for 30 years or so.
And by colleagues, do you share office space? Do you work together on cases just randomly, or what do you mean by colleagues?
No, I have worked on the same cases that he has worked on. I would not say we've ever worked on cases together.
Okay. And he approached you and asked if you would be interested in working for Eric Richins' family, who was dealing with trust issues, right?
With the trust, the Eric Richins Living Trust, yes.
Who's the trustee of the Eric Richins Living Trust?
Katie Richins Benson, his sister.
And so would she have been the individual basically responsible for paying you as the trustee?
Yes.
And did you meet with her?
I don't know that I ever met with her. We had phone conversations.
Okay. And did you have a contract of employment with her or with the trust?
An engagement letter, yes.
And what did they agree to pay you to help them?
My hourly rate and yeah.
How much was that?
$325 an hour.
And I believe you said you worked for them up until the county attorney approached you. Is that right?
That's right.
So how long a period of time did you work solely for the trust?
I don't remember when I first started working for them. In the summer. It was in the summer, I believe, of 22.
So a few months after Mr. Richins had passed.
Something like that. I can get that exact date for you. Something like that. And then toward the fall of that year, they engaged in some litigation, and I was pretty much out of the picture at that point.
So maybe 5 or 6 months, you think you worked for them?
Probably 4 or 5, yeah.
And do you remember total how much they paid you during the time you were employed by them?
I think it was about $9,000.
And during that time, did they provide you with records to analyze?
I did have some records, yes.
And so these are being produced to you by Eric Richins' family?
That's right.
And that would include these life insurance documents?
I did have some. Whether or not they're this, I honestly don't remember. It includes this one. I don't think it did. There were several New York life insurance policies that I reviewed.
Do you know how they obtained those records before they gave them to you? Are you aware? You may or not have a copy.
I don't know.
What other records did the Richins family give you to analyze?
I had some of the C&E Masonry bank account records. I had some tax returns. I know I had some other things. I had some odds and ends. So nothing, and I do not know how they obtained.
And then how did it come about that you switched from working from Eric's family to the prosecution team in this case?
Well, in my view, they are separate entities, separate cases, separate engagements, and I did not feel like I could work on both. And at that time, when I was engaged by Summit County, I had not had any contact, well, I shouldn't say any. I had really not had much, if any, contact since like the fall. I did have a Zoom call with their counsel where they just kind of wanted to see where I had left off, but the complaint that they filed doesn't include any of my work.
And the complaint that they filed is basically an effort to make sure that Kouri does not get a single penny from Eric Richins Trust, right? Is that your understanding of litigation?
I actually don't know much about that litigation, and on purpose, I have tried to ignore it. I try to stay in my lane and in my box, and this is the box I'm in. And so I really don't know the status. I don't know what's been happening there. My overall understanding is they were trying to enforce the trust, the Eric Richins Living Trust and associated documents. That's a weird way to say that, but that's my understanding.
And when you were in their box, when you were in the box with the trust, was it your understanding that Kouri Richins was aware that a trust had been created before Eric passed?
I was under the impression of the opposite, that she did not know about the trust. And whether or not she knew or didn't know, I really do not know the answer to that question.
So you've not reviewed any police reports in this case that talked about interviews of Katie the morning of Eric's death?
I know that there were some that took place, but I have purposely not reviewed them.
Okay, so you don't have personal knowledge one way or the other about whether Kouri knew this trust was in place before Eric died?
I cannot testify one way or another about that.
Okay. Did Todd Gabler ever give you any documents to analyze, or it all came from the attorneys of the trust?
I didn't get anything from the attorneys.
Where did you get the documents from the trust?
I believe I got everything from Katie.
From Katie, the sister?
I believe so.
Okay. All right. Are you still retained in any way by the trust?
No. I haven't engaged in conversation with them. I haven't responded to anything for the better part of the year.
Okay. Did you review new documents before you testified today that you did not review before the detention hearing?
Yes.
What are the new documents you reviewed before today?
We have more bank account statements. There are loan documents that I did not have before, and that includes promissory notes. And I know that payment ledgers have been requested, and there's very little of that due to the nature of the loans. I searched and obtained many more deeds in South Carolina and in Utah, and the UCC filings of the personal property loans, the unsecured loans, the insurance documents. I'm sorry, I'm getting a little conversational, but at the detention hearing, it was early in the week, say a Tuesday, for example, and most of the documents, the financial documents that I reviewed, I had had for just a couple of days.
Okay.
Literally.
I want to talk about these properties that you've looked at as far as Ms. Richins. Mm-hmm. It appears from your testimony with the county attorney that you were looking at the debt that those properties put her in. Is that right?
Yes, and I did testify about that exact point at the detention hearing, because at that time, that's all I had access to were those recorded documents. So I could see the amount of the trust deed, and I did acknowledge that that does not necessarily represent what she owes on it, but what she encumbered. That's why I'm calling it an encumbrance.
So these charts that went up dealt with what she owed on the property to the best that you could determine looking at publicly available records, right?
Not necessarily. The timeline chart that has all the colors. I mean, that has a date. Well, it has a point at which she no longer owned it. Her name is no longer on that.
Okay.
And so that represents that she no longer had that debt.
Successfully flipped that property, right?
Successfully would be a judgment call, and I've not been asked to give opinions.
Okay. All right, so let's talk about equity.
Okay.
When someone owns a home, you have what the home is worth when you buy it, but then you put money down on it, you pay money towards your mortgage, and at some point you build up something called equity in your house, right?
That's true.
And when you have a lot of equity in your house, you can go, like she did on their house in Willow Creek, right? And go and say to a banker, hey, I have this property that has about $600,000 worth of equity in it. Can I borrow $50,000? And what is the banker likely to say to that?
The banker's likely to look at a lot of factors, right? Go through some due diligence. Given a lot of different factors, probably going to say yes.
Right. Because equity has value.
That's true.
And it's part of your net worth.
That is true.
So when you're evaluating someone's net worth, you're looking at their debt for sure, but you're also looking at things they have that have value.
That's true.
Their jewelry, right?
That's true.
Their artwork.
Yes.
Their stocks and bonds.
Yes.
Their equity and property.
Yes.
You were not asked to make that evaluation by this county attorney's office, correct? Because I don't see that you did a net worth evaluation yet.
I have done some. There's some holes in it. There's some holes in it, so.
Okay. So you haven't today put on evidence of Ms. Richins' net worth?
No, and there are a lot of things that I don't know, like I'm aware that she has a tax liability, and I know that I can estimate a range, but I don't know how much that is, and that would factor into her net worth.
And I know you're an experienced accountant. You would never make a statement about someone's net worth if you knew you were missing critical documents to make that evaluation. Fair?
I would definitely put a footnote on that.
Okay. As far as the profits that Ms. Richins made when she flipped these houses, unless you have the settlement statement, the closing statement, all the records, it's not always possible to tell what her profit margin was, is it?
Well, profit margins, the answer is maybe yes, maybe no. Do you mind if I explain?
Go ahead.
Okay. For example, Ms. Richins has a schedule that she had submitted to some lenders that talked about the projects that she'd done. And she included in there is the acquisition price, the rehab budget, what it was sold for, and her profit. And I've gone through a few of those, and they're not accounted for correctly. The sales price does not reflect what her margin is. You asked me about margin, and the margin is not correct. Her profit is not correct on that. What I can tell you, the answer to your question, is I do have the settlement statements on a lot of those. And the settlement statements are prepared by the title company at closing. And so that'll go down the item, the sales price, and the deductions from that, like the property taxes that need to be paid, the encumbrances, like the first trustee, the second, if there are more, some other agreed upon amount that needs to be on one side of the ledger or another. And then we get to a net proceeds amount. And then I can go to her bank account statement and I can see those funds hit the bank account statement. But the way she had borrowed money, not everybody who was involved, I use that term as not everyone who had participated financially in that project would have had a deed filed that would have them hit the settlement statement. So once the funds hit her bank account, then she also had to pay out some funds associated with that property.
So once she flipped a property, paid off everybody that helped her out to buy it or rehabbed it, whatever's left in her pocket after she pays everybody is her profit.
That's right.
And you can't say that, what that amount was on every one of these properties, can you?
Not every single one, but I can on many.
And if you, as I understand it, she was servicing some pretty major debt and servicing it, right? Sending those checks out.
That's correct.
Check after check after check, making payment to her lenders, right?
Yeah, they mostly were auto withdrawals, but yes.
And out of all those properties that you have with the pretty colors on your chart, How many of those got foreclosed on before she flipped them?
Before she flipped them? Well, she doesn't own any anymore.
So none is the answer, right?
None then.
So she successfully purchased the property, got what she needed to rehab it, flipped it, and it never went under on any of those properties, except for after she got arrested, before she was arrested.
And again, I'm gonna not use the word success because everyone's got a different version of what that term means. But I think what you're trying to say is, did she end up selling them? Yes, she did.
Okay. All right. Did you ever interview any of Ms. Richins' hard money investors?
Yes.
Right. Did any of them, other than Greengrass, did any of them ever file suit against her for defaulting on their deal, as far as you know?
I do not know that.
All right. The joint account with Eric and Kouri that they paid their bills out of and their kids' soccer fees and things like that. Did you ever compare the deposits from Eric into that account versus deposits from Kouri into that account?
I'm aware of how much was kind of coming and going.
And who put more money in that account?
Eric's paycheck was auto deposited there, and that was more than Kouri's. There were funds coming and going, and so, but they were for different purposes. So
disagree with me that Kouri substantially deposited more in that account than Eric did in the joint account from her KRR account.
I don't know if I would agree with that or not, because there's a lot. There are a couple of instances where C&E, there is money coming from C&E. I will say that there are a lot of instances where there are, say, like there's a $5,000 payment from Kouri Richins Realty account, the 6577, into the joint account. But there are some instances where there's a lot of money coming from Eric's resources too.
Okay, now I want to back up just a little bit when you very first got on the stand and you were talking about the accounts, who had access or whose name they were in.
Yes.
So spouses have their own decision about who does the money, who doesn't do the money, and you were not privy to that arrangement between Eric or Kouri, were you?
No.
So you don't know if they sat down at dinner every night and looked at every one of their bank accounts together, do you?
I do not know that.
You do not know if Kouri gave Eric the password to all their bank accounts and said, babe, it's shared money, look at whatever you want to look at. You don't know if that happened.
I do not know.
You don't know how often they talked about finances or what Eric knew or didn't know about Kouri's business.
That's correct.
You do know that Eric invested in at least one property himself through his C&E account, the
Branson Lane.
Thank you.
I would not call it investing. I know that there were the C&E checks that went into the Kouri Richins Realty account.
Okay. Looks like they invested in the property. If you were just looking from the outside, fair?
I have other information that tells me that's not the case. That's why I've not included it in my testimony.
Okay. You also looked at the prenup agreement, and we all know what prenups or agreements are from TV, right? It's an agreement before you get married about how you're going to split stuff up if you get a divorce, right?
That's true.
Okay. And in the prenup that was signed when they got married, was the home contained in that prenup that you've reviewed? The home they lived in?
I don't recall. I'd be happy to look at it if you want me to.
Take a second, please. It's exhibit number, it's docket 106.
I'm skimming this. I don't recall it's in here. Was that correct?
It's not.
Okay.
Thank you for checking. So if you don't have your home in a prenup, regardless of whose name is on the title, would you agree with me that as a spouse, you have an interest in your marital home? Correct?
That's.
Well, hold on. They're about to object that it calls for a legal conclusion.
Your Honor, if I can argue this because
It calls for a legal conclusion. Sustained.
Okay. Let me ask you this way. You testified earlier that Ms. Richins got a HELOC on that house. Is that right?
That's correct.
All right. And you don't know if, you're not a lawyer, you're not a divorce lawyer, certainly, right?
That's correct.
So you can't tell, and I almost just called in the jury. Automatically. You can't tell the jury. You can't tell whether or not Ms. Richins had a lawful interest in that home that enabled her to put any type of lien on it or anything based on her marital interest, because you're not a divorce lawyer, right?
That's that legal conclusion.
Okay. So, and you also don't know if Eric knew about the HELOC or when he knew about it or what he did about it.
Objection calls for speculation.
Well, I think that's what she's establishing, but you can answer the question.
I am aware that there are indicators that he knew about it in October of 2020.
That's right, because he told it to the lawyer that he was saying about maybe getting a divorce, right? So when he told the divorce lawyer, hey, she took out this money on my account, that was October of 2020, right? So
and the indicators are that's when he learned about it.
Right, so a little less than 2 years before he passed away.
A year and a half, yeah.
Okay. And how many payments did you see Eric Richins make on that HELOC after October of 2020? In your review of every payment that was made toward that HELOC, how many did Eric make out of his account?
Out of which account?
Out of his accounts.
The 657s, or I mean the C&E account?
Did he make any out of the C&E account?
No.
Did he ever sign a check for that you ever saw?
I don't think so.
And it was coming out of their joint account or out of the KRR account, the realty account?
Mostly out of the 5244 account, which was Kouri's account.
Okay, so she's paying it. The HELOC that she took on it?
Yes.
Okay. And he knew about it in October of 2020?
Right.
Okay, and they stayed together, obviously. All right. If the home was not contained in the prenup, since you did work for the trust, is it not true that the trust is taking the position that the home gets poured into the trust upon death?
I don't know.
She's just asking what Ms. Carrington knows. Let's find out.
Thank you. Do you know?
I don't know.
Okay.
To be clear, I think my knowledge on these issues is superior to that than anybody else in the room, and so I can keep it straight.
Well, yeah, and I appreciate that, John. I think the court in summary judgment motion 2 weeks ago ruled on this very issue.
I can give you chapter and verse on these if we need it.
Okay, thank you.
You can just keep it.
I'll try to skip
Which is fine, Your Honor.
I understand. We'll just keep it.
Okay, just a minute. Just making sure I don't miss anything. I want to talk about those life insurance policies that were on your chart. If you could look at that chart in front of you, those 6 policies.
It's not up, but that's fine.
Oh, I thought you had a binder. I'm sorry.
It's okay.
I can keep back up.
Thank you. It's exhibit number.
Number
Exhibit
69.
69. Yes, sir. Thank you, Your Honor.
I think I got that.
Now, of those policies on Exhibit 69, the very first policy is a mortgage policy.
That's correct.
Which just pays off the mortgage if you die.
It doesn't pay it off, it pays it down significantly.
Right, sorry, you said that, 70, some weird percent.
Yeah.
Okay, so that life insurance policy is made payable to the mortgage company.
And as far as I know, it was paid directly to them.
Okay. And in your chart, it says it was paid to the trust. Do you see that? They were the beneficiary?
I say they were the beneficiary, but that was, no, that's not what I said, but it was paid toward the mortgage is my understanding.
So, Kouri, and when was that policy obtained?
15.
Okay. And do you even know Eric applied for that, right? Himself?
I do not know.
You don't know.
I don't know.
Okay.
I don't recall.
Second policy, what's the second one?
On my chart is the $250,000 true stage from 17.
And that's 2017.
That's correct.
And do you know whether Eric, that is not one of the questionable signatures, right? You've agreed that's Eric's signature on that application.
Let's make it clear, I'm not making any determination out of signatures. That's not me.
Okay. So the report you read from the handwriting analyst didn't look at that signature of the true stage $250,000 policy, correct?
Actually, I don't know. He looked at, in his report, he lists a few dozen exemplars. I don't know if that's one or not.
Okay. Do you know whether or not Eric Richins had to take a medical exam to get that life insurance policy?
I don't recall. I think I've got the documents for that, but I don't off the top of my head know.
So you can't say right now, as you sit here, whether Eric was involved in getting that policy or not. You just don't know.
I don't recall. There's both of those next two. There's the true stage and the auto owners. That was part of a group of policies where there's one on Ms. Richins, one on Mr. Richins, and somewhere along the line there's some on the kids too.
That auto insurance policy, that's the big one. That's $1 million, right?
Auto owners. Mm-hmm.
And what is the date that insurance policy was applied for?
That's also in 2017.
So help me with math, 5 years before he died.
That's right.
And that $1 million policy, there's no way they're going to insure somebody for $1 million if they don't have a medical exam. Do you think that's fair?
I think that's a fair statement, yes.
And then the next insurance policy was what day?
This is in April of 2018 with New York Life.
So that's 4 years before he passed.
That's right.
And do you know who applied for that?
I have the documents that I don't recall. I'm sorry.
And do you know whether Mr. And how much was that one for?
$500,000.
And do you, again, that's pricey, plus you, that's a pricey insurance policy. Again, I would imagine that would require a medical exam. Do you know if Eric submitted to one?
I know that he did on a policy. I've seen that, and I can't recall which one it was. I just don't recall those details.
So that really just leaves, and the policy that he had with his partner, the buy-sell policy, which partners do all the time, right?
That's correct. Yes.
That money goes to the partner. That doesn't go to the spouse.
They're set out specifically that way.
Right. So the only policy on there that was obtained within any short period of time before Eric died was the very last one for $100,000, right?
Right, and that's typically in my experience, that's an amount that probably would not have required an exam.
Totally agree. And that policy is one of those ones that we all get in the mail if you belong to a credit union, where they send you a little flyer, you get it in your junk mail, and it says, hey, you want to up your insurance? No exam, just sign here and we'll add some more for free. Please do that. Is that what that is?
It is a brochure from the credit union, but what you just described it's not contained in there. It was an offer of life insurance though.
Made by the credit union.
Yes.
To all their credit union members. It's just like a perk for being a credit union member.
It's a marketing brochure, yes.
Here's some pretty cheap insurance, grab it if you want, right?
That would be a fair statement, yes.
Okay. And that's the policy that was taken out, I guess, that was signed to become effective a few weeks before or a month and a half before he passed?
A month, yeah.
And again, that's $100,000 out of a total insurance amount that had been obtained years before, exceeding $2 million.
That's correct.
Were you ever asked to look at Eric's financial records in his company or his business? Anybody ever give those to you?
I do have his bank accounts, the bank accounts for their company, yes.
And the bank accounts that you talked about where, I'll strike that. Okay, court's indulgence, I think you smelled through. You want to ask a quick question? Your Honor, thank you very much. Thank you, Ms. Carrington.
Mr. Berger, is there any redirect within the scope of process?
Yes. Ms. Carrington, you were asked about a successful flip.
Yes.
If we're measuring success as an amount above and beyond all costs that go into purchasing, rehabbing, taxing, etc., the flip. That is a measure of successful flip. Were these purchases and subsequent sales successful?
If they were sold, if that's your measure of success, then they were sold, so that would be successful. There were several instances where the investors were not going to get their money out of that particular property, so their trustee, their investment was transferred to a different property where there was room for them to be repaid.
So some of these subsequent sales did not even meet the investment that went into them.
That's right.
So at the time of the defendant's death, March 4th, what was the summary of debt owing? Do you have the figure?
Yes. 3 of the homes had recently, prior to Eric's death, had been sold for about $170,000 in net proceeds. And then Ms. Richins had retained, I believe, 5 properties at that time. The HELOC was over its limit. It was at $252,000 on its balance. Her credit line at PenFed had been exceeded. Her credit line at American First was about maxed out. And she had ended the year in 2021 in the hole. I think in her 5244 account, she was in the hole $15,000, and in the 6577 account, she was in the hole $22,000. There just were no resources.
When you say there's no resources, so then she's unable to service all the debt she's acquired.
That's correct. And at that time, again, it's kind of mix and match to try and figure out how much debt load she had. She owed about $4 million on, well, let me restate that. The trustees associated with the property that she retained were about $4 million. So she probably owed a little bit less than that. And then the personal property loans, the accounts payable loans, I believe her balance at that time was about between $500,000 and $600,000.
somewhere then between 3 million and 4 million is her total debt load she has at the time of March 4th, 2020.
No, it would go the other direction. So she had roughly $4 million in real estate that she owed on, and then another $500,000 to $600,000 in those personal property loans. So $4.5 million, something like that.
You mentioned the HELOC and talking to defense counsel. Do you know, other than that $150,000 payment on principal in October of 2020, were there any other payments that you're aware of that were substantially beyond just paying the interest?
No, they're pretty much the minimum payments for the rest of the life of the loan.
When did she stop drawing money on the HELOC?
Do you mind if I look at my notes? In October of 2021 is the last draw of $2,300 payable to Kouri Richins Realty.
And why didn't she just take some more out of there?
Objection to speculation, Your Honor.
I think he's asking a financial question.
The balance of that account, the limit was $250,000, and as of that time, the balance was $253,199.25. So there's no room to draw more.
Did these lenders that you're aware of analyze the defendant's net worth when she was taking out these loans? Accounts receivable.
It appears, yes, they did.
Okay, so how much did she have in artwork?
I don't recall any artwork listed.
Okay, how about jewelry?
I don't recall any jewelry listed either.
Okay. When you look at the AFCU bank accounts, from which bank account were the payments made to the top insurance 1 through 4?
Those were paid from the joint checking 2204.
Okay, and that's distinguished from the last one, the one made on February 4th, or entered into on February 4th. Apparently no notice to Eric. That was paid from which account?
From the 6577 account for Kouri Richins Realty.
I have nothing.
Ms. Nestor.
Nothing, Your Honor, thank you.
Ms. Carey,
I think if you flipped houses and you were the type that you could get off of them really quick, that's fine. The whole point in flipping houses is you're not supposed to put a whole lot of money into them. You just kind of make them look good and then you flip them. It sounds to me like she was sitting on them way too long. Like she just didn't know what she was doing. What do you guys say that? She's just not a good business person. And if you're new to it like that, why would you start out with such high-end properties? Why not start out with like a slumlord style thing? Try to work your way up to something. I mean, my gosh, that is ridiculous. And so that he was, I bet that's what did it for him. He was probably like, I'm done. This is, you're not bringing me down with you financially. And honestly, I could see why now he put the money in because he probably didn't trust her. He probably knew she was taking money here and there. I wonder how long he had a feeling about her and the not being able to trust her or whatever. That's interesting. There were some big changes in the case against Kouri Richins this week. So let's get to it. So on Tuesday, the court considered some major changes, including dismissing some of the charges and then taking what's left of the charges and then splitting them into two completely separate trials. And of course, the big thing that was happening in Tuesday's hearing was the judge saying yay or nay to her being let out on bail prior to trial. It was a reconsideration of bail is what it was. Now, originally when he said no bond, the trial was set to start fairly quickly, but now it's been moved all the way back to 2025. So that's when the defense went in and said, please, if you would reconsider it. So that's what they're talking about today. They also started with the prosecution, not the defense, the prosecution asking to get the fentanyl drug charges dropped. Now, they didn't explain why they were doing all that, but the prosecution did say that they will still be using that argument that fentanyl was the cause of his death. And it was used in the quote-unquote red rum. So I don't know what's going on there. That is interesting. The defense came back and argued to split the case, saying that some of what she's accused of is completely unconnected to the homicide charge, and it would bias the jury. And of course, they also want the charges of mortgage fraud and the attempted homicide to go to a separate trial. The judge agreed. He said, look, we'll do this part. Since the fraud happened a complete year before the homicide, then we'll allow that to be separate. But as far as the attempted homicide, no, that's staying in with the full red rum trial that we're going into. He kind of took this attorney who was going a little bit too far and just said, ma'am, sit down, please. Now, another thing we found out in this hearing, and I didn't know this, maybe they had already stated it, but apparently the jury pool is going to be made up of people coming from not just Summit County, but also Salt Lake County. What was interesting is that they had planned or said something about doing a web conferencing for jury selection. I've never heard of that. In a way, it does make sense to do that at first, like just the first portion of jury selection, and then do the second portion in person. But the defense and the prosecution both said, we want it all in person. We can't do what we need to do. So I think the judge is still considering that. So then they talked about the bail charges, and they said, Judge, she's complied with every order, and as her attorney, it makes it harder to prepare for her defense with her being behind bars. What? Who says that? And she said, it just cannot be overstated the disadvantage that we are at when we cannot review the case material with our client in a functional way. The judge says, no. Partly because of the severity charges and then the loss of her business and the fraught relationship with her children. He said, now all that gives her a reason to take off. So no, she's staying in jail. No bail. The judge said structurally, she doesn't have the same connections to the community that she had then. And it's very true. A lot of people were saying that have been following this from the very beginning. And they said, yeah, no, she needs to she needs to stay put.
I was not concerned that Ms. Richins was a flight risk because of her connections to the community through her business and her family, and because her kids were here. Her relationship with her kids has been negatively impacted, to say the least, in the intervening time. Structurally, she just doesn't have the same connections to the community that she had then. Subsection 1, an individual charged with a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony when there is substantial evidence to support the charge and the court finds by clear and convincing evidence that, 1, the individual would constitute a substantial danger to any other individual or to the community after considering available conditions of release that the court may impose if the individual is released on bail, or 2, the individual is likely to flee the jurisdiction of the court if the individual is released on bail. The court made that determination in June 2023 and found, 1, that the aggravated murder charge was supported by substantial evidence, and 2, that although the court was not concerned that Ms. Richins would flee the jurisdiction, given her structural ties to the community and to her children, which were in the community, that the court was nonetheless persuaded by clear and convincing evidence
that she would constitute a substantial danger to herself and to the community if released on bail, and that danger could not be mitigated by reasonably available conditions of release. Ultimately, the court is not persuaded. While defendant no longer faces the risk of the death penalty, she now faces 2 first-degree felonies, each with a minimum sentence of 25 years to life, in which may be run consecutively, one after the other. As before, the severity of these sanctions, put plainly, of potentially dying in prison, creates a powerful incentive for defendant to harm herself or witnesses in this case, and to flee the jurisdiction of the court. And as before, substantial evidence supports the charge that defendant secured fentanyl and deployed it to kill another person, which is inherently dangerous conduct. Moreover, defendant's relationship to her children and her ongoing real estate businesses were, in June 2023, substantial connections to the local community that mitigated the risk that she would flee. But now, in November of 2024, those anchors have been weakened substantially. The juvenile court has granted guardianship of Ms. Richins' children to members of Eric Richins' family, and through that guardianship, they are limiting Ms. Richins' contact with her children, and that circumstance is likely to persist in some form, even if Ms. Richins is released on bail. And there's a reasonable inference based on the evidence admitted at the preliminary hearing that defendant's real estate business is now defunct and that she would not be able to restart it at any time in the near future, given the cloud constituted by this case. So as compared to June 2023, the current circumstances support a finding by clear and convincing evidence that defendant poses a substantial danger to the community and that defendant is likely to flee the jurisdiction if released on bail. True, GPS-enabled ankle monitoring is available, but any report from those monitors comes days after the fact. We have, with some regularity, seen defendants just cut them off and flee, and we don't know about it until days later. They are not as protective as we would like. Living with family in Salt Lake offers Ms. Richins a place to go, and without impugning her family at all, they're not law enforcement officers, they're not probation officers. It's not reasonable to expect or require them to supervise her 24 hours a day. The court finds by clear and convincing evidence that there simply are not reasonably available means of mitigating her risk to the community and to herself, or the strong incentive for her to flee the jurisdiction of the court. Defendant's motion to reconsider bail and conditions of release, docket 653, is respectfully denied.
He seems like a very nice guy, this judge. I call her the faux children's book author. Apparently she had a ghostwriter. Here's what's going on in her trial. Some new stuff has come up. Apparently there's a second employee that she had been talking to about procuring fentanyl from. So the Herbert City Police have agreed to hand over a cell phone belonging to a former employee of Kouri Richins, who was allegedly asked to procure drugs for her in the weeks leading up to Eric Richins' death. The witness is William Hayden Jeffs. He worked as a handyman on several properties for Kouri. So the sheriff's office detective said that they did interview Jeffs earlier this year, and he showed text messages allegedly corroborating his statement that Kouri had asked him to supply her with fentanyl. He provided copies of the text to the investigators. He's the second employee that Kouri is accused of asking for drugs before her husband's fatal overdose on March 4th of 2022. The search warrant, signed earlier this month, does not indicate when Kouri may have contacted her handyman for the fentanyl. Jeff's is 35 years old, and he died in a motorcycle accident on September 30th. Oh, wow, I didn't know that. His cell phone was seized by the Heber. It's probably Heber. I'm probably saying that wrong. His cell phone was seized by the Heber City Police Department in a separate investigation. And the officers released it to Summit County Attorney's Office after the warrant was served to assist with the homicide case. A second search warrant was also signed on November 6th, granting law enforcement access to Richins' Francis home. Now, when it says Francis home, she had multiple homes. Remember, she was flipping houses, so she may have owned more than one during all this. We know she owned that big mansion that she ended up selling. Investigators wanted to collect any and all documents, writings, or journals located on the Richins family home property, including in outbuildings, garages, and detached home offices. Kouri is charged with 9 crimes, including 2 first-degree felonies, aggravated murder, and attempted criminal homicide, as well as several second- and third-degree felony charges of mortgage fraud, making a false insurance claim, and forgery. She needs to be charged for forgery for that book. We're going to pick up again and finish watching the hearing this week for Kouri Richins. And this is the hearing where they're trying to get a bunch of evidence suppressed on the defense side. It's called the walk the dog letter, and it was found in her cell. We last watched the first detective in the case, who is now over in the K9 unit. She got up and spoke a little bit about, when they did search warrants, when she spoke to the defendant, all this kind of good stuff. And then now they've got this second prison guard up on the stand, and they're going through this one. Well, I think there might have been 2 times when her cell was searched. Now, one time it was searched because they had said that something happened on the unit and everybody's cell got searched. And then another time, she had some kind of medical, they called it a medical issue. They never said what it was. And during that, they all went up and checked on her cell, and they ended up moving her to a cell below, like 1 floor lower. So they went and had to pull all of her stuff out. In doing so, they were also checking for some type of paper that she held up in like a, how when they have their jail calls with their visitors, she was like on a video call with somebody, and she held up a piece of paper, and they're wondering what was on that paper. So they were looking for that specific piece of paper, and in doing so, they found this walk the dog letter. Now, if anything looks suspicious, they have to go and they have to scan it in. And once it's scanned in, then they send it over to the prosecutor's office and let them decide whether or not they need it. It went through the formal process, but her attorneys are now trying to just go through everything that they did to get to this letter and say that it was attorney-client privilege. It had her attorney's name on it. It had her attorney's, and it was an envelope with her attorney's name on it. But that's not what they're saying. They're saying it was just a random piece of paper or pieces of paper found in a book. So that catches us up. So let's get going.
Which I think there were nine pages. Did you take all 9 of the pages at that time?
I did.
So when you saw these pages that were in a handwriting, you read all of them, right?
I read most of the document on my way out because once I verified that there was something in there of concern, then I was taking them out of this section to take to my supervisor.
So the very beginning of that, in front of you, the first couple of lines, and you can just read it to yourself right now.
Okay.
Is about a conversation between Ms. Richins and her attorney, correct?
No. It's saying she's referring to this guy as the third person.
Right. She's talking about something that her attorney told her, correct?
Correct.
All right. So as you started to read this, you immediately saw that she was talking about something between her and her attorney, correct?
Correct.
But you continued to go on and read it?
Correct. So I scanned the document, and then fairly quick, she talks about basically what she's telling her brother to say.
Well, that's I understand that's what your interpretation of the document is, but let me back up a little bit. So when you come across documents that are privileged, do you typically go on and continue to read them?
They weren't marked as privileged.
When you come across documents about an individual's case that they've written,
We scan those documents, yes, to look for safety security threats.
you scan them or you read them?
Scan them. Or you read them until you determine that it's a legal document when it's a handwritten letter that's not in a legal folder or anything like that.
Now, you refer to that as a letter, but is that a letter addressed to anybody? Does it say "Dear somebody" at the top?
No, not at the top. At the back of it, it clearly is addressed to her mom.
Well, wait a minute. Let's clarify here. Addressing a letter would, there's no,
Hold on.
oh, sorry.
Go ahead, Mr. Bloodworth.
Like all the other documents in this case, it says what it says. We don't need a quiz on what it says.
Are there questions about why Sergeant Thomas did or didn't do whatever he didn't do next that you need to ask?
There is, and it's laying foundation for argument that will be made in the briefs.
If you need to ask questions about what he did or didn't do, that's fine.
Well, I think it's important to clarify, for purposes of argument and privilege, whether or not this document was obviously a letter.
Well, but you can, candidly, I don't care whether he thinks it was obviously a letter. I can address that, and I have to, under the law, make an objective determination of that. If you want to ask him why he did whatever he did or didn't do next, that's fine.
Okay. All right. Well, can I get an answer to the first question? Is there a salutation on the letter to somebody?
No.
All right. But you continued to read it.
Correct.
Anyway. And it's not signed on the bottom by Ms. Richins. It's not "Love Kouri" on the bottom, correct?
I would have to.
I'll go ahead and take a quick
Ms. Lewis,
look.
if you just ask the next question, I'm going to move you along just a little bit here.
Was there an envelope with that to mail it?
No.
Were there any letters in her cell that were ready to be mailed out that you found that day?
I don't recall any. This is the only letter I remember. This was the only letter of significance that I felt was a violation of rules and a safety security threat.
All right, and it was attached to 3 other pages that were just notes, correct?
Yeah, it was like a checklist it appeared to be a checklist. I couldn't really tell you everything that was on it on the last 3 pages.
Okay, but it wasn't you didn't think it was part of the first 6 pages?
Yeah, I thought it was part of the actual document, yes.
All right, are you aware that the next page, page 7, was found to be privileged by the taint attorney in this case?
No.
You're not aware of that?
No.
Okay, Your Honor, I just want to Exhibit 158 for the record. This is not a document that this witness would be familiar with, but I don't think I have any objection from.
What is it?
This is a letter from the taint stating that the 7th page of this document.
Okay.
Your Honor, the other way, of course, to read that letter is that the first 6 aren't.
Why? Either way, I don't have the 7th page in front of me, do I?
No, you don't. I can get it to you and we can submit it, but it was determined to be privileged, so the government doesn't have that either.
I've not seen it.
Okay.
The only one that.
I'm sure I'm never going to rely on this, but we'll mark it and you can.
Well,
make
yeah, I
whatever
just
argument.
want it for the record that
Okay.
the documents this was found with were
It's been offered.
privileged.
Okay. 158 is offered.
Okay. Now, you said you don't recall if they were glued together at that time.
Them being glued together, no.
All right, then if I could just also offer, I guess this would be Exhibit 159. Sorry, Your Honor, after discussing this with Mr. Bloodworth, I'm going to move ahead. All right, so
again, I have trimmed this down, guys, so that if there was any pauses or secret meetings during the trial or the hearing, we're not going to watch that.
The only thing that was taken from the cell was this 8-page, 9-page document, correct?
Correct.
And what did you do with the document after you took it from the cell?
I took it into the jail commander and explained the contents of the letter to him, which then I was referred to take it to the county attorney's office to verify if it was a legal document.
I'm sorry, can you leave more? I didn't hear that last part.
I took the letter out to the jail commander and discussed the contents with him, and then was referred to the county attorney to determine whether it was a legal document or not.
All right. And it was determined this is not the document that was held up to the video camera when Ms. Richins was visiting her mother that you were originally looking for, correct?
Correct.
So this is a different document that you took out of the cell.
Correct.
All right. And then the rest of her belongings were put, or I don't know if the rest of them, a number of her belongings were put in a bin, correct?
I wasn't there when that happened.
I think you were, actually. Why don't we put on video Exhibit 78 again?
Are we doing this to refresh his recollection?
Yes, but it's in evidence. I mean. Let's put back to the box. All right. So you are in the cell when Sergeant Barrett takes the bin down, correct?
Correct.
And Alex, if you can back up more from where he comes from. Now, he comes from behind the door, correct?
Correct.
And those belongings are things that were behind the door, it appears, correct?
Correct.
But isn't that where the LSAT book is in that bin at this point?
I wouldn't know. I was looking at the document the whole time, so I don't even recall him taking that bin out.
Do you recall coming back about an hour later to take pictures of the LSAT book?
I do.
And where was the LSAT book when you took the pictures of it?
I believe it was down in that property down there.
It was in the bin, correct?
Correct.
And did you take that book out of the cell and put it in the bin?
No, I don't know if Barrett must have grabbed it, or if he grabbed it later and put it in there, or if he grabbed it like while I was reading the letter.
Well, shouldn't that be on the video? If he put more things in the bin?
Yeah, I'd imagine.
All right. Your Honor, you'll have the videos. So he doesn't recall. I don't want to just sit here and show every video. But
Well, to be clear, I don't know how many of these there are, but I'm not going to watch all of them unless you have determined that one of them is relevant.
all right.
You can just proffer which one you want me to watch, but
I'd like to proffer a negative. There is not a video of anything else being put in the bin after we see the bin coming
Okay.
down the stairs.
fair enough.
So, and there's only a few videos after this.
Okay.
But so there is a video though of you pulling the book out of the bin, correct?
Correct.
And taking a picture of it. All right. Your Honor, we don't have anything further. Thank you.
Mr. Bloodworth, any redirect for?
Take a look at that video. What is this depicting?
Me grabbing the book out of the bin
And why are you grabbing the book out of the bin?
so I could take a picture of where I found the letter.
And by book, you mean the LSAT book?
Yes.
And why did you want to take a picture of where you found the letter?
To book it into evidence or attach it to the report of where I found the letter.
Okay.
Because I stated it in my report.
Is that the LSAT book in your left hand where you found the letter?
Yeah, it looks like it.
Is this you using your cell phone to take a photograph of that?
Correct.
And is that the photograph that, if you know the number, but is found at 86 in the court's binder. We can show you that photograph. Do we have it real quick? Your Honor, can I borrow the court's binder to show? Sergeant Thomas, is the court showing you Exhibit 86?
Yes.
Is that the photograph of the LSAT book where you found the walk the dog letter?
Correct.
And is that the photograph you took that was depicted in the video we just watched?
Correct.
To recap, you found the walk the dog letter in the LSAT book, correct?
Correct.
And you never searched a folder, a manila folder during that entire search we've just discussed?
Not that I recall.
And you never
I don't
searched,
remember it at all.
and you never searched a folder with Ms. Lazzaro's name on it?
Negative.
And you conducted your search at the head of the bed?
Correct.
Head of the bed is about 6.5 feet from the foot of the bed where Sergeant Barrett was standing?
Roughly, yes.
No further questions. Thank you, Your Honor.
Ms. Lewis, may we release this witness?
Yeah, we may, yes.
Okay. Counsel, what's next?
Your Honor, sorry.
It's still your floor.
We would just want to admit into evidence, which is State's Exhibit 107 and 108.
They've been offered. You'll have an opportunity to tell me why they're important.
Those are a recording and a transcript of said recording of a phone call between Ms. Richins and her mother, where she talks about that these 6 pages, the walk the dog document, were located in the envelope with the privileged papers. There's other parts of the conversation, but that's what we would be offering.
Proffer the date for me.
September 17th, I believe, 2023.
It's the 16th.
16th?
And then we have nothing further.
Okay.
Your Honor, the state, as to the same walk the dog letter motion to suppress, wants to call Detective Jeff O'Driscoll. The state intends to call Mr. Kojadimos testify to the effect of, based on tons of training, knowledge, and experience with these types of warrants. This warrant is very typical of phone extraction warrants. In fact, it's more narrow than many phone extraction warrants that contain language simply like dump the phone as long as it has to do with the crime. And he can explain why warrants require that breadth. Now, I can see where that information would be unnecessary given the fact that this court has approved so many similar warrants and just probably knows that.
Well, the other issue that I think there's a scope of the inquiry issue that I have here is that the warrant was issued. It says what it says. Is there a legal route for collateral attack on its scope at this point?
So,
I mean, once it's issued, isn't the only routes of attack either that it was secured through fraud, that's a Frank's hearing, or that its execution was unreasonable? But as long as the information seized or secured is within the scope described by the warrant, is there a legal basis for the warrant was overbroad when issued kind of attack?
Your Honor, the state doesn't believe so. And to be clear, that the defense in their motion has not challenged the veracity of the probable cause under Frank's.
Understood.
The defense has not challenged the execution of the warrant. They are indeed challenging the 4 corners of the warrant as issued.
Help me understand, Mr. Ramos, what's your hook?
It's a lack of particularity described in what to search for within it.
And let's assume you're absolutely right about that, and that the judge that issued it missed it, wasn't sufficiently attentive. At this point, though, where we have, I believe, good faith reliance on an overbroad warrant, isn't it black letter law that that's not a violation of the Fourth Amendment?
Well, no, I don't believe so. If it was issued and it lacked particularity, Your Honor has the discretion to go back and either suppress it entirely.
Do I have that authority?
I believe you do, Judge, based on case law.
Okay. And you'll be able to cite me to that?
The way I've read it, yes, Judge.
Okay.
Now, that's assuming Your Honor believes it does in fact lack particularity.
Okay.
If it doesn't.
Well, I need to give you a fair opportunity to lay that foundation, though, and make your arguments.
Now, to be fair, coming into this motion or to this hearing, we were going to just submit on the four corners and just brief it. So I had no plans on calling anybody. However, I understand the state's position of wanting to call Mr. Koutroudimas.
Candidly, I really don't care what Mr. Koutroudimas thinks is typical. I mean, I'll wager with him about how many of these I've seen versus how many he's seen, and so I think I can make that call.
And the state's comfortable with that, Your Honor, because candidly, the court has signed warrants with identical language.
Yeah, probably so.
It is our stock language that we use in every phone dump warrant.
Right. But I need to give Mr. Ramos an opportunity to make his arguments, and so, yeah.
Well, that, Your Honor, I believe that opportunity will come in paper.
Yeah.
I'm happy to limit this based on the court's experience with such warrants to the four corners, not call Mr. Koutroudimas and move on.
Is there any evidence you feel like the defense needs to put on to provide the record from which you can make your arguments regarding this warrant is infirm because of a lack of particularity?
Judge, I believe that I'm limited to the four corners.
Okay.
I don't believe I can present any evidence, even if I wanted to.
Understood.
Should he want to do it, and I'd certainly love a chance to cross-examine
No, I don't.
somebody.
Candidly, I don't think Mr. Koutroudimas's testimony on that issue is going to be particularly persuasive.
We would agree, Judge, and one thing we did discuss, which we would just, it's already been offered. I've discussed this with Mr. Bloodworth. In the initial motion that I filed, I identified some warrants. Come to find out later, there was another one that it just wasn't identified as through the IMEI number.
Okay.
So we've gone back and forth. All of the warrants have been offered. We're stipulating to them, and I'll cite them in the brief, but just want to let Your Honor know.
Okay. All right. Mr. Ramos, anything else we need to discuss today regarding the motion to suppress electronic data?
No.
Okay. Mr. Bloodworth?
Nothing further on that motion, Your Honor. I think we can call Detective O'Driscoll in relation to the walk the dog motion. I think we can complete that before 6 o'clock. Your Honor, may I, Coach?
Please.
Handing Detective O'Driscoll a copy of 6-page walk the dog letter that is in the court's docket at 2:14. Detective O'Driscoll, I'm going to ask you some questions to ideally provide the court with some clarity regarding some of the discussion inside the walk the dog letter, okay?
Okay.
Your Honor, I'm going to object at this point. I don't see how going through this is going to be helpful to the court, like Mr. Bloodworth's been telling us all day. What's in the letter, what's in the letter, the court can read it. The question here is whether...
Pause one moment. Help me out, Mr. Bloodworth. Where are we headed?
Sir, it's interpretation more than reading.
Why can't I interpret it, though, as well as this gentleman?
Your Honor, because some of the interpretation requires information that the court doesn't possess that Detective O'Driscoll has developed through investigation. Can I give you an example?
Let me ask you another circumstance question. Is it information that Sergeant Thomas had when he handed it over to the Summit County Attorney's Office?
No, Your Honor. It is information to decode, if you will, some of the coded pieces of the letter and to explain why to explain the meaning of the letter. And let me proffer why that's necessary, right? The defense in their moving papers have essentially argued that among an attorney-client, the letter is a attorney-client communication. They've also, I guess, alternatively argued it is attorney work product protected.
Right.
It can't be both. It can be one or the other. They've argued in the alternative. And their work product protection argument is essentially that This walk the dog letter, the defendant prepared it in anticipation of litigation or trial.
Or that it reflects a conversation she had with her attorney about those preparations. That the substance is attorney court work product, yeah.
Correct. All grounding in, we're doing this because of litigation and trial. The state will make an argument in the future when we prepare our opposition papers that, no, the walk the dog letter was not prepared by the defendant in anticipation of litigation or trial. Rather, it was prepared by the defendant in anticipation of witness tampering and publicity. To make that argument, the court needs a deeper understanding of the walk the dog letter, who the various references are in the walk the dog letter, so that the state can make that argument.
And when you say references, are you referring to names, places?
Yes, names, places. So,
Why don't we just ask those questions, Ms. Lewis? That's fine.
That's all the questions, Your Honor. I'm going to hold up so the court can see it. It's the highlighted pieces of the walk the dog letter that Ms. Lewis has.
The way to do this, to obviate the objection, is to the extent this letter says something to the effect of names a person named John Doe, just ask this witness, do you recognize that name? Does that person have any significance to this case?
Yes, Your Honor, that's the plan.
Okay. Ms. Lewis?
For the record.
Yeah.
Just renew the objection that the letter can be read on its face for purposes of a motion to suppress.
Fair enough. Can you speak specifically, though, that there may be names or other references in there that you all recognize that I don't recognize or wouldn't when performing an objective review of the letter, because I don't have the same level of information that you all have?
I think that who these may refer to, I don't know what he's going to say, but may not be what we believe, what he believes may be something different. But now we're back to infecting the jury pool again. They're going to argue that these are coded words. Where he gets his information is certainly not from Ms. Richins, who wrote the letter. So we're going to put a whole bunch more stuff out there that Mr. Bloodworth was very concerned about.
With respect, it's already out there. This was all on the record. Gosh, we had a hearing about this. Ms. Lazaro was standing there saying the same thing, and I said something to the effect of if they thought they had probable cause to charge her with witness tampering, they would have charged her with it, but we are where we are. Ooh. Everybody has their arguments. This has been out for a year and a half. Can we just get the factual information out, and then you'll all be able to make your arguments? But that concern was vetted a year and a half ago.
All right, I understand. I just have an ongoing objection to this.
I understand. Just ask factual questions.
Yes, Your Honor, and can we agree that the state has discretion in whether or not to charge?
Sure.
If there's probable cause?
We'll see. Okay, let's keep moving.
Detective O'Driscoll, can you please turn to page 3 of the letter?
Yes.
In the middle paragraph, that reads, also please text Lotto or call, tell him, do not text me.
Yes.
Do you know who Lotto is?
It's Mike Kelly.
And who, at the time of the walk the dog letter, was Mike Kelly in relation to the defendant?
Close friend or intimate interest.
The letter then says, tell him not to text me. What do you understand that reference to text me to mean?
Text messages sent over the HomeWave system from the jail.
And did they have a history of texting over the HomeWave system from the jail?
Yes.
Everybody say hey to Michelle's boo, who's listening in for the first time.
Can you please turn to page 4?
I know they didn't introduce him, but I'm going to introduce him. This is Detective Driscoll. I think they brought him up twice during this because I seem to have 2 different things of this. He did not come onto the case until about a year into it, but he was on the case at the time that she was arrested.
Do you see right at the top a reference to potentially working out mortgages for houses identified as hers, yours, and Chelsea's.
Yes.
The hers, you can tell from the letter, relates to Marissa's. Who is the yours in that sentence?
Lisa Darden's.
And how is it you know that?
Because at the time, Lisa's house, just like Chelsea's and Marissa's or those properties, was facing foreclosure.
And who was responsible for the mortgages on those 3 homes that were facing foreclosure?
K. Richins Realty, or Miss Richins.
You see about 2 sentences down, there's a reference to Lotto and his house in Hideout.
Yes.
Did Michael Kelly at that time own a home in Hideout?
Yes.
At the end of that paragraph, you see a reference to the Yotels.
Yes.
Do you understand that reference?
Yes.
What is it?
2 properties at the Canyons Resort that were short-term rentals owned by K. Richins Realty.
And like the other 3 properties, were those 2 Yotel properties in foreclosure at that time?
Yes.
The next paragraph asks, one way to get at Katie is going through my phone and finding pictures of her girl.
Yes.
Based on your investigation, did the defendant's mother, Lisa Darden, at that time have access to either a copy of the defendant's phone or a new phone that contained the information from the defendant's phone?
It appears so, yes.
I object. He doesn't have any direct knowledge of that. Speculation.
Yeah, we lay a little foundation. I'm not sure what he means by it appears so.
Sure. How do you know that the defendant's mother, Lisa Darden, at that time had access to information from the defendant's phone?
During several other instances of calls or text messages between Miss Richins and her mother, she frequently asked her mother to retrieve data or information from, quote, her phone.
And based on that, and based on that request, and jail calls, did Lisa Darden appear to retrieve information from the defendant's phone?
In reply, yes.
On page 5, the letter references my girls and then Chelsea, Kelsey, and Selma. Based on your investigation, who are Chelsea, Kelsey, and Selma in relation to the defendant?
3 of her closest friends.
Finally, turn to page 6, please.
See, what I don't understand is she was so in debt, and I don't know if he knew how in debt she was, but the whole fight with them began when she bought that mansion because he knew that he was going to have to bail her out and give her money in order to flip it. So he knew she didn't have any money to put into the work that it needed, and it needed a lot of work. They ended up selling it too, by the way, and it was still needing work when they sold it because they didn't touch it while they had it. But at least I wonder how, when it sold, I guess, I'm sure she didn't get anything from it. She didn't make anything off of the sale of it. She probably lost money on it. And we may have covered that, but I don't remember exactly.
In the middle, it reads, lastly, don't forget to work on the gun receipts. We want to file charges and let the prosecutor not do anything about it.
Yes.
Based on your investigation, what is this business about gun receipts?
Miss Richins.
I'm going to object. I think he's identified the names of the people. I think now Your Honor can read the rest of this letter. There's nobody else to identify in here.
I think I can draw an inference on that one, Mr. Bloodworth. We can move on.
I suspect the court can draw an inference on Crest white strips as well, so I will stop there.
Okay, very good. Ms.
Oh, so she can beat a dead horse, but he can't.
Lewis, any follow-up for Detective O'Driscoll?
So, one moment.
Of course.
Your Honor, we don't have anything further.
All right. Detective, you can step down. Thank you.
Yeah, I like him too.
Detective O'Driscoll, you've testified to this before. As a part of your investigation, did you contact representatives of the hunting camp in Mexico where Eric Richins hunted?
Other investigators on the case did, yes.
I object. I don't know where this is going. It doesn't seem to have anything to do with what's in front of the court right now.
I have similar questions. Tell me where we're going.
Your Honor, the court has heard this testimony, and that the testimony.
Stop there, though. Why do we need to get into this today?
Your Honor, because the defense has argued, not only in its moving papers, but in some of its questioning today, that this business about the hunting camp was a discussion between Ms. Lazaro and the defendant.
How would this gentleman know whether that is the case or not?
He would know that that discussion is inconsistent. The purported discussion between Ms. Lazaro and the defendant is inconsistent with the facts of the case that Ms. Lazaro had at the time. I'm also mindful of burdens here, Your Honor. The defense, of course, has the burden, right, to
showing that this is either privileged or protected from disclosure as work product.
Correct, and they have presented no testimony on that issue. Nevertheless, the state could present testimony right now regarding the investigation into the hunting camp.
Yeah, let's stop there, though. The hunting camp issue potentially opens several different cans of worms. I'm going to limit you on this topic today. We'll see if we ever need to get into this prior to trial.
Yes, Your Honor, understood. Can I propose this? To the extent the state, because we haven't seen substantive papers from the defense, right? To the defense opens this can of worms.
Understood.
Can the state rely on Detective O'Driscoll's previous testimony on the issue in its responsive papers?
Sitting here today, I can't remember if these lawyers were present when he testified to that.
It was the previous set of lawyers.
Okay, I'll consider that.
Okay.
Still not sure this is ever going to come up on this motion, but we'll see.
So I appreciate that. I'm not sure either.
So that's even more reason to move on.
Fair.
Okay, anything else for this witness?
No, sir, thank you.
Ms. Lewis, may we let this gentleman step down?
Yes, Your Honor.
Okay. Mr. Ramos.
No, Judge, thank you.
We need to talk about deadlines. I am happy to let all of you talk amongst yourselves, agree to some briefing deadlines, and tell me what they are when we convene on February 3. Is that agreeable?
Yes, Your Honor.
Yes, Your Honor.
Mr. Bloodworth?
That's agreeable, Your Honor. I would just ask, because I've seen the court do it both ways, is the court's general preference for kind of a more substantive briefing from the defense, followed by opposition by the state and reply?
I mean, you all can stipulate around whatever you want to do. To the extent people want to have the last word on the issues for which they have the burden, I don't know that I'm going to say no to that. That can create some lengthy back and forth. So just talk to each other, see if you can agree to what's going to happen here. I would prefer to receive all the briefing, be able to read all the briefing, and then have a hearing where I can ask you questions about it and have you make your arguments after I've seen it. That works best for me.
Yes, sir.
Okay. Talk to each other, though, about the timeline for that, and let me know what you decide on February 3. We are reconvening on February 3 by WebEx, I believe, at 9:30 a.m. to discuss juror questionnaire related topics. Is that correct?
Yes, sir.
Okay. Ms. Lewis, is that your understanding?
If that's the case, maybe the trial's going to be a lot sooner than April. I don't know. I just saw on the internet, though, it said that somebody said Court TV has it that The trial date was set for April, like the end of April. Okay. Let's go over here. We're going to hear Driscoll's full testimony, what he did a little bit before all this happened. We've got his testimony. I'm sorry, not Driscoll, O'Driscoll. And then we've got the testimony of Eric's brother-in-law, his sister's husband, and it's the sister who had control of the estate. But first, we're going to Detective O'Driscoll.
Supervisory changes to the investigations division as well.
And when you say her case, you mean the case at that point in time investigating the death of Eric Richins?
Correct.
What was the change to not only you as the lead investigator, but you said, I think, the supervision of the division?
There was a new sergeant over the detectives, the investigation division, Sergeant Hoffmeyer.
So I take it you determined to then personally call on the defendant on April the 14th, 2023?
Correct.
And why personally instead of over the telephone?
It had been a year since Eric's death. I felt it was more professional considering the loss that she had gone through in the family, and felt that it was more appropriate to show up in person to speak with her and to introduce myself than over the phone.
Okay. There came a time then when you appeared on the doorstep of the Willow Court home where she was then residing. Is that correct?
Correct.
And thus began your interaction with her on that day, right?
Yes.
Did you record that interaction with her?
Yes, I did.
How did you record it?
I had a audio recorder running, and then later I activated a body cam that I had with me.
Okay. Let's talk about the body camera. When did you activate it?
After we were invited into the home and asked to sit down.
And did you activate it roughly contemporaneously with the point on the body cam, or the point on the recording where you say, "Do you mind if I record this interview?" or something to that effect?
Correct.
Can you please describe the body camera, not only how the body camera itself looks, but where it was sitting in relation rather to the defendant?
Yes, I wasn't dressed in a law enforcement uniform, and so I didn't have a mount that's typically available to officers to mount their camera to their body. I just had it loose. It's a small square black body cam that's similar to those worn by patrol officers at that time, and when I activated it, I sat it on the armrest of the couch between myself and Miss Richins.
Was it in Miss Richins' plain view the entire time it was active?
Yes.
Does the body camera itself make any noise or light?
Yes.
What noise or light does it make?
It beeps and vibrates every few minutes, and there's a red flashing light that also indicates that it's recording.
And would Miss Richins, the defendant, have been able to see from the location of the body camera vis-a-vis her the blinking red light and hear the vibration and beeping?
Yes.
You mentioned it was similar to body cameras that officers on patrol wore at the time. Was it similar to the body cameras that the officers on patrol were wearing while they interacted with the defendant in the early morning hours of March the 4th, 2022?
Yes, at least some of them were wearing the same body camera.
Have you reviewed both the audio recording and the body camera recording that you made that day?
Yes.
Are those recordings true and accurate?
Yes.
Did there come a time when you were on the front stoop of the defendant's home, that she invited you in?
Yes.
And is that accurately reflected in the recording?
Yes.
Did you then, upon her invitation, enter the home?
Yes.
Can you describe how you entered the home how the home was laid out and where you and Sergeant Hoffmeyer was with you?
Yes, correct, he was.
Where you, Sergeant Hoffmeyer, the defendant, and ultimately the defendant's mother, Lisa Darden, were sitting?
Yes, so the front door of the home opens into a short foyer. Directly in front of the door, through the foyer, is the main living area of the home. There were couches and love seats in the family room. Miss Richins sat on one end of the couch. I sat on the other end, and Sergeant Hoffmeyer sat in a separate piece of furniture near us. When Miss Darden entered, that Lisa, the defendant's mother, she seated herself on a entertainment center across from the couch on one wall of the living room.
What was your observation of the defendant's mood throughout the conversation?
She seemed very cheery, very open, happy to be talking with us, happy to have the opportunity to talk to investigators. She was outgoing.
At any time throughout your interaction with her on that day, did you observe her cry or become, did you observe tears fall from her eyes?
I didn't see tears, no.
I want to turn.
Okay.
Are you familiar with the emails at tab 12?
Yes.
What are they?
They are emails that Miss Richins sent myself and Sergeant Hoffmeyer a few days after we spoke to her in her home.
Do those emails follow up on the conversation and interaction you had with her on April the 14th at the home where she resided?
Yes, she was providing us additional information, follow-ups to the things that we had spoken about in her home.
And are they true and accurate depictions of those emails? You don't see them altered at all?
No, not as far as I can tell.
I asked you two questions, which was sloppy form. Are they true and accurate depictions?
Yes.
Were they altered at all?
Does not appear so.
Thank you. No further questions.
May it please the court. Good afternoon, Detective. We've met before, but Kathy Nestor again on behalf of Ms. Richins. All right, so I want to talk to you about your deciding to go visit Ms. Richins. And you said that you had just been appointed, or not appointed, but assigned to the case, right?
Correct.
How long before?
I'm not sure. Less than a month, I think.
And when you were assigned to the case, there was a case file, wasn't there?
Yes, there were different locations that information about the case were stored or recorded.
All right. And you've been a law enforcement officer for some time. I'm certain you didn't go to her house unprepared to interview the primary suspect of a murder, right?
No, not entirely unprepared, but again, the intent to go to the house was not solely to get an interview. It was mainly to introduce ourselves and the change that had happened with the Eric Richins death investigation.
How long would that have taken?
I'm sorry, how long would what have taken?
An introduction.
Not long.
Okay, how long were you there?
3 hours.
Right. Okay, so before you went to her house, isn't it true that the day before you went to her house, you had applied for an affidavit for a search warrant of her phone and a computer?
I'm not 100% positive on dates.
Your Honor, can I approach?
Yep.
I assume the
Here it is.
application.
I'm sorry. The affidavit was on the...
I don't know if Mama said anything about
Yes, thank you.
if the attorney should be there or not.
Handing you a warrant. And Your Honor, if we could just mark this really quick as 150.
Well, Your Honor, that's Exhibit 9 in the state.
Oh, Exhibit 9, great.
He's got a binder with Exhibit 9.
Yeah, I can use this if it's in here.
This attorney, she's kind of, I don't know.
Okay, if you could turn to that exhibit number 9 in the binder and just look at that for just a moment. And is the affidavit along with the search warrant there in tab 9 or just the warrant?
It has the affidavit.
Okay, can you go to the last date, the last page of the affidavit and tell me the date that you executed it?
It says executed on 13th day of April 2023.
The day before you interviewed Ms. Richins, correct?
Correct.
And in this affidavit, you have multiple pages of why you want to search her phone, right? It looks like basically two pages of facts to support your affidavit.
Yes.
Single spaced. And in this affidavit, you refer to things that happened on the night of Mr. Richins' death and things that Kouri had told detectives before you. Is that right?
Yes.
And things the toxicology report had recorded, right?
Yes.
And you refer to an interview that was done of a friend of Ms. Richins that you refer to here as CB, as in boy, where she had been interviewed and that you suspected she had deleted messages, correct?
Yes, that's correct.
And did you interview CB or are you referring to what someone else did?
I believe in this affidavit I was referring to an interview that was conducted, that I did not conduct. That was conducted by other officers.
CB is Carmen, right? The one that got the drugs for her? Does anybody know?
And specifically Detective Woody, correct?
I believe from my recollection it was Detective Woody and Sergeant Davis.
And she was in charge of the case before you.
Yes.
And you obviously had access to her notes or someone's notes from that meeting with Detective Woody and CB, right?
I don't know if I had access to notes from that interview with CB at that time. From my recollection, what I knew about that interview came from oral statements from Sergeant Davis and Detective Woody.
So you talked to Detective Woody about this case.
Somewhat.
How often did you talk to her?
Not very often.
When did you talk to her first?
I don't recall.
Before you interviewed Kouri Richins?
Yes.
All right. So before you interviewed Kouri, you had enough information about the case to prepare a 2-page affidavit with specific facts that had happened in meetings with Detective Woody, right?
Enough for this affidavit, apparently, yes.
And did Detective Woody provide you with her file from the case?
Again, there's not one file, but yes, I had access to the information about the case.
That she had put together?
Yeah, I mean, even from the beginning of Detective Woody's investigation, from what I understand, it was a collaborative effort of multiple investigators.
Somebody tell her it's a box file. It's a box of files. It's a box fort. Somebody tell her.
Okay, but you had what she put together.
Yes.
And you talked to her about it.
Not about all of it, but some of it, yes.
Okay. And you certainly looked at it before you did this sworn affidavit to a judge, right?
Again, not all of it, but some of it, yes.
Because you don't have personal information. You weren't at this meeting with Woody and CB.
No.
Okay. So would you agree with me, sir, that in this affidavit it is extremely clear that Kouri is a primary suspect of this investigation?
I would have to take time to read the whole thing to answer that. I can if you want me to. Okay, I've read the whole thing. Could you repeat the question for me?
Yes. Would you agree with me that when you prepared this affidavit that it was clear that Kouri Richins was a primary suspect of your investigation?
No, I wouldn't agree with that statement.
You would not?
No.
You didn't think she was a suspect at this point?
I didn't have definitive information that she was a suspect.
Okay. But you wanted to look in her phone, and you were asking a judge to let you look into a phone, right? Her phone.
Correct.
And you're asking to look into her phone, by your own words, to see if she tried to obtain fentanyl on her phone.
Yes, that's the part that's recalling my memory is at that time, with the limited information I had, The most important fact that I felt we knew was that Eric died of fentanyl overdose. So the biggest question to me was how the fentanyl got into his system. And in my opinion, there were basically 3 different ways that Eric could have died of a fentanyl overdose. It could have been an accidental overdose, it could have been a suicide, or it could have been a homicide. In order to be thorough, I was trying to investigate all 3 of those possibilities.
So 1 year after he died, you still had no idea whether it was a suicide, a homicide, or an accident?
That's correct.
Okay. So you show up to have this friendly introduction with Ms. Richins. Do you tell her that you had just applied for this affidavit?
No.
And when you say you started from scratch, I mean, you didn't start from scratch. You'd spent a month reviewing the information prior to talking to Kouri, right?
No. I had not spent a full month reviewing that information. I still had a full caseload besides this case. When my time permitted, I reviewed what I could.
Okay, so you reviewed the files, right? Enough to do this affidavit.
Enough to submit this affidavit, yes.
You had talked to the previous case investigator, right?
Yes, but not a full debrief of the case.
Okay, but you'd talked to her, right? You'd reviewed the ME report, because you just said that.
Yes, I have.
Right? Had you looked at the material that was taken off of her phone previously?
No.
All right, so you show up, you don't tell Kouri that you just applied for a warrant to search her private information. Actually, what you tell her is that you all coach soccer together or something? Is that what you said when you came on to the house?
Your Honor, let me kind of renew this objection. What he told her is documented in audio and video recording. There's no dispute. It's not a game of gotcha. It is what it is.
Are you just trying to jog his recollection, lay foundation, or can we just move on?
All 3.
Okay, thank you.
Can I just get him to answer that one question? You talked about the fact that you all had ties in the community through soccer coaching and things like that, right?
Correct.
And then maybe she knew your wife or something?
That sounds familiar.
Okay. But you didn't tell her you were investigating her for homicide at any point in those 3 hours?
No.
You also didn't tell her you had a hidden recorder on your person, did you?
It wasn't.
Can you be specific at which
Yes.
point in time you're talking about?
When you first arrive at her house. Thank you, Your Honor.
No, the intention was not necessarily to hide it. The audio-only recorder was brought as redundancy in case of failure of equipment technology.
Where was it?
In my pocket.
Okay. Did you tell her
It wasn't
there's-
visible to her.
Right.
But my intent was not to hide that I was recording her.
Did you know whether Sergeant, it's Hoffmeyer, right, that was with you?
Correct.
Did you know whether Sergeant Hoffmeyer had a hidden recorder on him?
So our memories have been a bit confused on this point. Originally, I thought I had remembered that he had the recorder. The recorder was his piece of equipment and tools, but I think after listening to the recording from how far away he sounds from the microphone, I think I had the recorder on me, but it was just the one audio recorder and the one body cam.
And you intended to go in there and ask Kouri questions directly about what happened with her husband's death, didn't you?
After she invited us in and consented to having us interview her, yes.
When she invited you in, did you Mirandize her?
No.
Right. Did you know she had a lawyer?
No, I did not.
You did not? All right, let's look at the transcript for just a moment. I believe it is number Exhibit 11 in front of you. And can you go to page 7? And can you, this is, I mean, literally, you guys have maybe exchanged pleasantries and you've only been there like a couple of minutes at this point, if it's page 7, right?
Yeah, it looks like about the time we were sitting down.
So can you read what Kouri said to you on line 3 of page 7?
So my attorney has been pushing to, obviously we just wanted her off the case because we're not getting anything done. anything accomplished.
And who's she talking about wanting off the case?
I think she was referring to Detective Woody.
So minutes into your meeting with her, she advised you she had an attorney.
Yes.
And you knew that you were going to elicit information from her that could be used against her, did you not?
I didn't know what information she would provide. I just wanted to know the facts surrounding the night of his death.
If she had said, hey, I killed my husband, would you have used that against her?
Likely.
Okay. So you didn't Mirandize her at that point. You knew she had a lawyer. You knew you were looking for information about her involvement in her husband's death, and you did not Mirandize her, correct?
Correct.
Did you tell her that she didn't have to meet with you, that you were only there if she wanted you to be there?
I don't remember the exact words that were exchanged before we entered the house, but I didn't say that specifically, no.
And you didn't record those, did you?
Yeah, they're recorded on the audio, just not on the body camera.
Okay. Were you wearing a gun?
I think so.
Was Sergeant Hoffmeyer in a uniform?
I think so. I don't remember specifically.
Did he have a gun?
Probably.
Prior to your meeting with Ms. Richins, when you were applying for the warrant of the phone that had been seized from her in April of 22, did you review the reports about the seizure and the investigation on the 12th?
No.
When you were reviewing Agent Woody's file, do you recall seeing correspondence from her attorney, from Kouri Richins' attorney, instructing that no one investigating the case interview her client again without the lawyer being present?
Your Honor, objection that wildly mischaracterizes the correspondence. The correspondence is in evidence. It says what it says.
Would you rephrase the question?
Do you remember reviewing correspondence from Ms. Richins' attorney
Why don't we just pause there?
in Detective Woody's file?
There you go.
No.
Do you remember discussing it with Detective Woody?
No.
So prior to going to interview the key suspect of a murder investigation, you didn't take 1 minute to check and see if she was represented by counsel after a year?
No.
Okay. All right.
Your Honor, the state's going to object to this line of questioning. The state renews its objection based on the Sixth Amendment, in that the Sixth Amendment has not yet attached.
So you say, but we're going to have to get into some briefing about whether this proceeding had reached a quote-unquote critical stage under the case law and whether we'd begun to focus on a particular suspect or other critical stage. Let's just get the facts in.
Thank you, Your Honor.
Your Honor, let me make the record.
Sure.
Then let me finish the record on the Sixth, quick move to the Fifth.
Sure.
I think the Sixth Amendment case law in Utah, it's the Padaki case, says it attaches at arraignment. And so I think it is a clear decision that there is no Sixth Amendment point. The Sixth Amendment has not attached at this point in the narrative. Moving to the Fifth Amendment. Your Honor, the Fifth Amendment, of course, attaches when there is a custodial interrogation.
Truth.
And Utah's Perea case, really citing to McNeil v. Wisconsin of the Supreme Court, says one cannot anticipatorily invoke a Fifth Amendment. You need custody before you can invoke the Fifth Amendment. And so all this business about whether the defendant was represented, whether Detective O'Driscoll knew she was represented or otherwise, is immaterial.
To the Fifth?
To the Fifth.
Not necessarily to the Sixth. We'll see if your citation to Utah case law is correct. But I understand your point regarding the Fifth. I think the Fifth Amendment issues, right, are why they keep asking her if he had a gun on and show of force, free to leave, Mirandized, all that stuff.
Correct. I believe that line of questioning goes to the Fifth Amendment argument.
Correct.
They will one day make.
Right.
But here's the state's concern is the state is certain that we can select a fair and impartial jury from Summit County potential jurors. But the state is very cognizant that the more information, and in this instance, the more false information put into the potential jury pool will make it more difficult and take longer to select those fair and impartial jurors.
Well, I have shared this concern generally in this case from the detention, the first detention hearing, given the level of media attention. But the reason I don't think that cuts one way or the other with respect to Summit County versus Salt Lake County versus, candidly, Washington County is because the outlets that are covering this, 95% of them are national or international outlets or new media outlets on YouTube that do not respect any county boundaries. And so I think the concern you're expressing, while valid, applies to every potential jury pool.
Well, yes, Your Honor, I agree with that. I think we will argue that one day in the future. The reason I mention it is the gratuitous publication of false information through the course of these moving papers and this examination is unhelpful to creating and quickly filing a fair and impartial jury, whether it's Summit or Salt Lake or wherever.
I appreciate your concern. I don't think we are even approaching, never mind beyond, the point of no return in that regard. And I'll stay aware and vigilant.
Thank you, Your Honor.
Okay.
While he's bringing up the whole jury thing, I wanted to read you guys an article here that was put out by Summit County Park Record is the name of the publication. And it said that next month, the Utah Supreme Court is scheduled to hear oral arguments from the appellate lawyers representing the Summit County Attorney's Office and Kouri's legal defense, asking justices to reverse a ruling made by 3rd District Court presiding judge Laura Scott. Prosecutors and defense attorneys want to pull prospective jurors from 2 counties, Summit and Salt Lake, and also hold the voir dire, which is the questioning of the jurors, in person instead of online. They filed a joint petition asking the Utah Supreme Court to hear their case last month. Now the oral arguments have been set for 10 a.m. on February the 11th at the Matheson Courthouse. So they're still up in the air about that. So we'll find out about that pretty soon.
Just pointing out, Your Honor, all of these materials have come from the state, and this is the
Ms.
first.
Nestor, we can just move on.
Okay.
Thank you.
Thank you. All right, so I want to move now to the search that you did and the arrest. By the way, Kouri was arrested. You sought an arrest warrant for her within a couple of weeks of having this start from scratch interview of her, right?
Yeah, that time frame sounds correct.
So in the space of your interview with her on the 18th, whatever the date is, the 14th, and her arrest on May 8th, which is about 2.5 weeks, in between that time, you decided it was a homicide and she was the one who did it. And that's 3 weeks. Okay. All right. So then you apply for a warrant of her house, which you applied for on May 3rd.
Please proceed.
By the way, in that period of time between when you had this interview with her and were open to hearing however it happened, the death, and the time you issued the warrant for her and the search for her house and her arrest on May 3rd, did you investigate any other potential suspects in that 2.5 week period of time?
To an extent, yes.
And I assume you have reports about that?
Yes.
That you prepared? Okay. I'm not going to go into that, Your Honor. Okay, so what is the date that you applied for the search warrant to go search her home? When did you ask a judge to give you permission to search her house again, a year later?
May 3rd, 2023.
Okay, so again, like less than 3 weeks after you interviewed her, right? And in this interview, this warrant.
1 second. Would you repeat that for us?
I just said I believe that math works out. Yes.
Okay. In this warrant that you got, You asked to search for two things in the house, right? Two things.
Correct.
Counterfeit pills and copper cups. That's it.
Yes.
Okay. And that warrant was issued by a judge, correct?
Yes.
And that's the warrant that gave you authority to exercise a search of her house on the day she was arrested, correct?
Yes.
All right. On the day she was arrested, Ms. Richins was located in another location from her home. She was down in Salt Lake, is that right?
Yes.
And you were there at the location where the arrest took place, right?
Correct.
And other officers or deputies were involved in the search of the house up in Camas.
Correct.
Right. While you were arresting Ms. Richins, when you arrested her down in Salt Lake, did she have a phone on her at that time?
Yes.
On her person?
It was in her hands, yes.
And when she stepped out of the car, what did you tell her to do with that phone?
She didn't step out of a car.
You pulled her out?
No. She was exiting a business building.
Okay.
And I approached her while she was walking out.
Sorry, my bad. So when you approached her, what did you tell her to do with the phone?
I didn't tell her to do anything with the phone.
What did she do with the phone?
Your Honor, objection. This seizure is not the subject of any of the three motions that today's hearing set for.
I think that's right. Isn't that right?
No, it's relevant to Mr. Ramos's motion.
Electronic data?
Yes, because I'm just identifying the foundation of where that phone came from.
Your Honor, that motion, the electronic data motion, challenges the four corners of the warrant itself. The actual seizure of the phone is irrelevant, other than the fact that it was seized pursuant to that warrant.
Yeah, forgive me. I listened back to our discussion regarding burdens. Is there anything about the execution of that warrant that defendants believe was unreasonable?
About the execution of the warrant of arrest?
The search warrant, or is it that you believe the phone was seized without the benefit of a warrant?
I'm about to get into the statements she made at the time of her arrest prior to Miranda that directly deal with the phone that was in her hands. So I'm just laying a foundation for which phone it is and what they say to her and what they get her to say.
Your Honor, none of that information is relevant to the three pending motions.
Yeah, forgive me. This is new to me. I don't know that you filed a Rule 12b3 motion that regards this? Yeah. We just need to make sure the state had noticed that this was coming. Correct me if I'm wrong, Ms. Nestor. I believe it's undisputed that Kouri was arrested. A phone was seized from her during the course of the arrest.
Right.
2 hours later, a warrant was issued with respect to the contents of that phone, correct?
Right. We are not actually challenging the search of the phone. I am dealing with the issue of the statements that she made after her arrest, but
that topic is not, and forgive me if I missed it, that topic is not a part of Mr. Ramos'
hold on just one moment, Your Honor.
Yep,
Can I talk to
no problem.
Okay. I'm sorry, Your Honor, I got confused. I don't need to go into that. So I will move on. That is a different issue.
Okay, very good.
Okay, so you're down there, you're with her when she's being arrested. Meantime, there's officers searching her home up in Camas, right?
Correct.
And at some point, you get a phone call from one of the officers on the scene. Is that right?
I don't recall. I'm sure I took lots of phone calls that day.
Did they advise you that they had found something in the search that was not within the permission of the warrant?
I don't recall.
Do you recall being told?
Go ahead, Mr. Bloodworth.
Your Honor, I think this goes to the seizure of the orange notebook, which is issue 4 in the defense motion to suppress statements and evidence.
Right.
As we discussed last Thursday, the state has conceded that the state seized that notebook on May the 8th, 2023, beyond the scope of the warrant that Ms. Nestor is addressing.
Correct. The state, I understand, will be arguing inevitable discovery.
Yes, Your Honor, and that argument relies exclusively on paper, various warrants. Their tabs, I think it's...
We'll get there. We don't need to name them all now.
13 through 17-ish.
Okay.
The point being is this examination is nothing more than to prove a fact that the state has conceded.
I think that concession matches my notes after re-listening to the last status conference with counsel. Anything else we need from this witness regarding the orange notebook?
Yes.
Proffer for me what else it is you need.
Your Honor, all the steps that are made and the chronology of the steps that are made about the search file into my entire fruit of the poisonous tree argument. I need to lay a foundation if I ever need on appeal. I need to be able to make clear the steps that they went through to...
With respect to the orange notebook?
Yes.
Once they have it, though, outside the scope,
yes,
it's a problem that they now need to invoke some kind of exception to fix. Isn't it the steps after the orange notebook that would be relevant to the fruit of the poisonous tree?
That's what I'm getting to right now. Is I just asked him about the orange notebook and what he does next. I mean, that's where I'm going.
My apologies. Okay.
No worries. Okay, so may I proceed? I'm sorry. So you get this call that they find a notebook in her house, right?
I don't.
Go ahead.
Your Honor, I don't know that we're fully clear on this issue.
Let me sound out what I understand is the possible benefit of this. Are you preserving the ability to argument that there was a gap in time between when the notebook was actually found and when it would have inevitably found?
Yes.
And during that gap in time, they learned some things that is
Yes.
fruit of the poisonous tree.
Yes.
Here's the gap I'm not sure we're square on, Your Honor. State has conceded that the search on May 8th that discovered the content of the orange notebook was beyond the scope of the initial May 8th warrant to search the home. Based on information obtained from the orange notebook.
At that time
on May 8th, there was a second warrant written to search the home on May 8th for a notebook. The state is conceding that that second warrant, the portion of that second warrant to search for notebooks, there were other collateral issues that don't touch on this, was invalid because it relied on information discovered in the notebook pursuant to a search beyond the original warrant.
Okay.
The state's inevitable discovery argument is about warrants that occurred way after May 8th. All the information those warrants relied on are in the affidavits of probable cause for those warrants.
May we pause here for just a moment? I think this discussion would be more detailed and fruitful if you both weren't worried about seeding the public record with a bunch of stuff you don't want potential jurors to know about. That is a sufficient basis to close these proceedings briefly to have a more detailed discussion about this topic. So, everybody who is on that side of the bar, including all of you, I need you to step out. Now.
He has spoken. So he basically sends them all out of the room. They cut the feed, and it picks back up where they're bringing in a new witness. So I guess they decided that's it for now. Boom. Yep. He said, boom, mic drop. All right. The last witness that we're going to see tonight is, again, the brother-in-law. This is the sister who maintained custody of Eric's trust. Her husband's going to be testifying, and it's not a very long testimony.
Beck's link is unmuted. Mr. Bloodworth, Sir, you're under oath, correct?
Yes.
Very good. Mr. Bloodworth, please proceed.
Thank you, Your Honor. Your Honor, for the record, the state is called and the clerk has sworn Clint Benson. Mr. Benson, are you familiar with the trust relating to the estates of Eric Richins?
Yes.
And who is the trustee of that trust?
Katie Richins Benson, well, it'd be the Eric Richins Trust. And then Katie Richins Benson would be over that trust.
And what, if any, relationship do you have with Katie Richins Benson?
I'm her husband.
Are you familiar with the Willow Court address where Eric Richins lived?
Yes.
Does the trust own the Willow Court address?
Yes.
Does the trust have control, like physical control over the Willow Court address?
Yes.
Did the trust gain control, physical control over the Willow Court address upon the defendant's arrest on May the 8th, 2023?
Yes.
Who, on behalf of the trust, has controlled access to the Willow Court property?
That would be me. So after Kouri's arrest, locks were changed, cameras were installed, and I have monitored all access to that property.
Okay. In monitoring all access to the property, other than law enforcement, who, if anyone, has entered the property?
We have had Todd Gabler has entered the property.
And let me just break you there. Is Todd Gabler an investigator retained by the state in connection with the civil litigation?
Correct.
Other than law enforcement and Todd Gabler, has anyone entered the home?
We did have one instance where it was a bank matter where someone did try to enter the home. Law enforcement was quickly called, and he was stopped at the garage man door and garage entrance.
Okay. To wrap a little specifics around that, a bank holding a lien on the property had asked a locksmith to go to the house and change the locks. Is that right?
Correct.
When that person was at the house to change the locks, that generated a call to the police?
Correct.
Deputy Shane Norton responded to that call?
Yes.
And he contacted that locksmith in the garage before that locksmith entered the house. Is that correct?
Correct.
Okay. Other than police, Mr. Gabler, and the locksmith, has anybody else entered that house?
I did have assistance from a family member on installing cameras in that home, but that was right after Kouri's arrest, and that would be it.
Have you personally escorted those who've entered the home?
Yes.
In each instance, I guess, except for that locksmith who was trying to change the locks?
Correct, yes.
Okay. In escorting anybody that entered the home, did you observe anybody bring something from inside the home and place it, or sorry, something from outside the home and place it inside the home?
Never. No, that's never occurred.
Other than police removing items from the home pursuant to warrants, have you seen anybody remove any items from the home?
No.
Thank you. No further questions.
Mr. Benson, you and I have met before, but just to remind you, my name's Kathy Nestor. Okay. So your wife is the trustee of a trust that the house has been folded into, is that correct?
Correct.
And there's litigation surrounding that trust at this time, is that right?
That's
Civil litigation.
correct. Yep.
And since the day that Kouri was arrested, the family was not aware she was going to be arrested, right?
No.
Okay. And she has 3 young sons,
Correct.
and they were at school.
I believe so. I was not there when that occurred, so.
Your Honor, objection relevance as to what this has to do with the state's direct examination regarding security of the home.
Because I think she's laying foundation that there was a time when some stuff was taken out of the home regarding the kids. But I think we could just fast forward to.
I'll get to it.
Thank you.
Okay, I know what the notebook is. The orange notebook. It says that it's just a notebook that she was keeping because her therapist told her to do it. It says physician told her to do it. And I'm not sure what she would write in it, but the officers did open the notebook, read its contents, and then sought an amended warrant for authority to seize it. The defense said that in their court documents that the contents contained physician-patient privilege because they were for her therapist. So that's the big deal in it. But there's no, they've said it's not been disclosed or not if it's clear whether the information it holds is relevant to the case or further to the the Red Rum investigation. So I don't know.
After Kouri was arrested, someone who was not a member of your immediate family was the guardian for a brief time of those children. Is that right?
Correct.
And those children had to come back and get their things out of the house?
I believe so. Yep.
Yeah. And they were with that other person that was not you?
They came to the home, but I believe I was there when they arrived to do that, and they were escorted.
And in fact, hasn't there been, in another matter, hasn't there been an order entered that the children are permitted to go into the home to get items whenever they need it?
They are permitted, but they have not gone to the home.
But at least once they did.
Not to my knowledge.
You just said they went in there with their guardian.
No, you asked if someone had gone to the home, but it was the guardians that had gone to the home to pick up their stuff.
Oh, okay. So the children weren't with them?
Correct.
Oh, I'm sorry. I didn't understand. That's what you were saying. I apologize. So the guardians were there at least once?
They were there once, to my knowledge.
Okay. And Mr. Gabler has been in the home, correct? And Mr. Gabler's been assisting this prosecution with providing them with reports and interviews and all kinds of things to assist this prosecution. Is that right?
Your Honor, objection. Anything Mr. Gabler's provided has been pursuant to a subpoena.
We can keep moving here, Ms. Nestor.
Mr. Gabler's working with this prosecution team, as far as you know. He's provided them with materials for however he provided it to them.
Correct.
All right. And he had authority to be in that home because he was working for your family. Is that right?
I wouldn't say he had authority to be in that home. He was accompanied by me when he was in that home.
How many times did he go in that home?
I don't recall the exact number.
More than 5?
I don't recall.
More than 20?
Not more than 20.
Okay, so less than 20 times, but more than once or twice.
Correct.
And when Mr. Gabler would go in there, he did search for items that he thought would be relevant and helpful to the prosecution, didn't he?
I believe so.
Yeah.
Your Honor, renewing the objection.
I think Ms. Nestor is about to move on to a new topic.
And the times that the warrants were executed, we just took some testimony about 4 different warrants that have been executed since Kouri's arrest on the house. 4 times. Were you there for each time they did the warrants?
Yes.
And you saw the searches every time?
I would let them into the home to perform the search.
Okay. And how many people would be in the house, give or take, when that was going on?
You're talking 4 searches, so you'd have to be more detailed.
How many officers would you see? Typically, was it 1? Was it multiple officers that would come in?
It would be more than 1.
So you couldn't be with all of them the whole time, right?
Correct.
How big is the house?
It's 4,300 square feet.
Okay, and there's multiple floors, is that right?
Correct.
Okay. And how long did those searches take, average, when they would go in and search under these last 4 warrants over the past 12 months?
It depended upon the case and what they were looking for. So it was dependent upon the warrant.
And as the trustee, the person that would be present, did they tell you what they were looking for?
No, in some instances they would, some they wouldn't. So
Tell me the instances you remember in the last 12 months what they were looking for.
I don't recall exact items. There were a lot of items.
Okay, so they did take items out of the house every time?
I don't recall if it was every time, but they did give a list of items that were taken on the, in regard to the warrant.
And the first time the house was searched, did it appear like was the house in disarray after the search? In other words, were things thrown on the floor? Was there?
Would you pause for 1 second,
Yep.
Ms. Nestor?
Your Honor, this is beyond the scope and irrelevant.
I think this is beyond the scope of the motions you filed. I don't recall any arguments regarding unreasonable execution of a warrant.
No, that's not why I'm asking.
I think we need to move on.
Has Katie been in the house?
No.
Never? Not since the death of her, not since the funeral?
You got to, hold on.
Sorry, let me
Would you
rephrase.
redefine the time period that you're describing?
Not since the time of Kouri's arrest, Katie has not been in the house?
She has not.
And Amy has not been in the house?
Not that I recall.
And your father has not been in the house?
He hasn't been in the house, no. He's there. You'd have to be more specific. Do you mean the house or the detached garage? What
Anywhere
are you
on the
talking
property?
about? He has been on the property.
Okay. Were you present on the day of Kouri's arrest when they were searching the home?
I was not.
Were you the person that came and changed the locks that day, or did someone else do that?
I didn't change locks. We hired a person to come and change the locks.
So you personally didn't appear at the house that day?
I was at the house.
Were you there while the search was ongoing?
No, I don't believe so.
So do you know how many people went inside and outside the house that day?
Objection, Your Honor.
Sustained. We need to move on.
Do you know you were not at the house the day that the arrest happened?
Your Honor, he
Judge?
just testified that he was.
Yeah, you're going to have to be more specific, and we're going to have to move on. You need
I will.
to stay
I will.
reasonably tethered to the motions that the defense has filed.
The day that Kouri was arrested, there was a lot of people on the property. Is that correct?
Law enforcement.
And were there others?
I don't remember seeing anybody but law enforcement there, as well as a locksmith to change the locks.
Were you there the entire day?
I was not there the entire day.
Okay. What portion of the day were you there? An hour, half an hour, 6 hours?
Just as long as it took the locksmith to change the locks.
So at the very end, when they were finished?
Correct, I believe so, but I
Okay.
don't recall.
Okay, that's all I have. Thank you, Your Honor.
Anything else for this gentleman?
No, Your Honor, thank you.
May we release this witness?
Yes, sir.
You're welcome to step down. Mr. Bloodworth.
Your Honor, the state has no further witnesses on this first motion to suppress statement and evidence.
And so I believe this is the point where the state would say all burdens either are with or have shifted to the defense. Is that correct?
That is correct, Your Honor.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, give me a sense of where we're headed.
Can I approach for just 1 minute?
Sure.
Mr. Blevins?
Okay, so that was that. That's it. That's everything they showed. I guess he's going to rule on this on February 3rd as to what he's going to do. Hours after that, at 3:21 a.m., Kouri called 911 reporting that her husband was not breathing. He's cold. He doesn't have a pulse. I think they were having problems for a while. They had a lot of disagreements. And I think it all started with when she started doing that business and she started taking money. Now remember, she stole money from him, but then she also had taken money from him where he had, done it legally, and he was getting frustrated over her. The prosecutors alleged Kouri, who had started a real estate business flipping houses, owed hard money lenders at least 1.8 over 1.8 million. Yeah, and I think that she purchased that mansion. I think she did it she did it without him knowing. Didn't she sign his name to that? I don't remember if she signed his name on. I know she signed his name to a lot of stuff. And he was like, no, and I think he blew up. But I think he also had a funny feeling about her too. I don't think he trusted her anymore. They were going to get divorced regardless. Why didn't she just let the divorce happen, you know? I guess it was all the money thing. I guess she found if they did get divorced, he would find out about all the money she'd been taking because he would have had somebody go in and look at all his finances. And that would have been, that would have been bad. Because remember, she still has these forgery charges open and on the side of this whole murder charge. New court filings by the prosecution in the Kouri Richins aggravated red rum case paint a picture of strongly worded language, prompting Richins' defense team to characterize them as snarky screed of personal attacks against them for doing nothing more than complying with their constitutional duty to represent their client. Richins is accused of fatally poisoning her husband, Eric Richins, with fentanyl in March of 2022 at their Eastern Summit County home in Camas. I think it's Camas. Sorry. It's in Utah. Just as their trial is about to get underway in April, the Summit County Attorney Margaret Olson and Deputy County Attorney Brad Bloodsworth filed oppositions to the defense team's motion to suppress. Those documents are strongly worded, and now Richins' team is accusing Olson and Bloodworth of violating a section of the Utah Rules of Professional Conduct for Attorneys, calling for sanctions against the Summit County Attorney's Office and for the prosecution's filings to be struck from the record. Richins' public defenders, Wendy Lewis, Kathy Nestor, and Alex Ramos, appear to assert that Olson and her prosecution team have a problem with the defense doing their job and have made it personal. This stems from a recent disclosure by Olson to the defense. Richins' defense team called into question the accuracy and possibly the truthfulness of lead detective Jeff O'Driscoll's previous testimony on January 3rd of 2025 when he was asked about going into Richins' home on April 14th of 2023. On January the 8th of 2025, the defense filed a motion to suppress the statement that Detective O'Driscoll obtained from Richins during that interview at her home. The defense filing shows that the grounds for the motions to suppress concerned whether Richins or her former attorney had asserted her right to an attorney prior to the interview and whether the April 14, 2023 interview violated her Fifth or Sixth Amendment right to an attorney. The reply to the state's motion opposing the reopening of evidence says that on January 21st of 2025, when the prosecution was preparing Lieutenant Justin Hemingway to testify at a suppression hearing, Lieutenant Hemingway shared his recollections of conversations that occurred among law enforcement officers involved in the Richins investigation prior to Detective O'Driscoll's interview of Mrs. Richins. These conversations dealt specifically with the fact that Mrs. Richins was represented by counsel and whether or not they could proceed with her interview in light of that being known. Attorney Kathy Nestor asked Detective O'Driscoll again while under oath during the January 23, 25 suppression hearing whether he knew Richins had a lawyer at the time he went to interview her, and he answered, "No, I did not." It further says the prosecution team remained silent during this testimony despite knowing about Lieutenant Hemingway's potentially inconsistent memories that were revealed to them only 2 days before. What's more, it says prosecutors never tried to correct the testimony during redirect and did not call Lieutenant Hemingway to the stand. On January 31st of 2025, Richins' attorney says prosecutors told them outside attorneys had been brought in by Summit County to investigate a possible inconsistency between Detective O'Driscoll's testimony at the suppression hearing and the recollection of Lieutenant Hemingway, and that the results of the investigation would be produced. On February 6th, Richins' defense team received an email with a summary of the internal investigation. It says the summary showed that at least 3 witnesses confirmed that the conversations took place about whether Richins could be interviewed despite having an attorney, and the conversations were at the direction of Lieutenant Hemingway, who was Detective O'Driscoll's supervisor at the time, adding that one of the witnesses was an employee of the Summit County Attorney's Office, and this employee was advising law enforcement whether they could proceed with the interview. The defense filing then raised the following concern. The fact that an attorney connected to the prosecution may have directed that the interview of a represented individual should take place outside the presence of her counsel raises entirely new legal issues that were not addressed during the first suppression hearing because this fact was known only to the prosecution at the time. Richins' defense team then filed to reopen the hearing so witnesses could testify under oath about what was known by law enforcement and the county attorney's office at the time Richins was interviewed at her home in 2023. The defense characterized the county's attorney's disclosure to them as giglio material. Giglio material is any information that the government has that could call into question the honesty of a government witness's testimony. So on February 7th, 2 News Investigates left messages for County Attorney Olson asking for a response about accusations by the defense team that the testimony of Detective O'Driscoll was inaccurate or potentially untruthful. We did not receive a call back from Olson, but we did receive a statement from Sergeant Skylar Talbert, the Senior Public Relations Liaison for the Summit County Attorney's Office. They issued a full denial. It says, the detectives involved in the Kouri Richins matter have always conducted themselves ethically and testified truthfully. The defense's motion filed last night suggests otherwise is grounded in neither fact nor law. The motion's suggestion that a particular detective testified untruthfully is irresponsible. The state will respond fully on the record at the appropriate time as provided in the rules. It is highly unfortunate that the defense in this case repeatedly chooses to malign individuals instead of focusing on substance and evidence. Last week, Olson and Bloodworth filed a series of oppositions to the defense motions, calling the motion nothing more than the defense counsel's latest implementation of current and former defense counsel's long-standing strategy to publicly malign honorable people to influence potential jurors. It's a cheap litigation trick, no more, no less. This strategy holds no place in this serious proceeding or our profession. On Tuesday, Richins' defense team filed a response saying that the prosecution's faux outrage is utterly bewildering, as they are the ones who felt compelled to make the disclosure. Additionally, it says that the county attorney's office got the summary of the internal investigation sealed and accused prosecutors of trying to shut down a public hearing and have resorted to call defense counsel desperate and their arguments to be poppycock. It says they will not sink to that level and will continue to do what they need to do to protect their clients' rights and hold the prosecution accountable for their actions. Richins was back in court on Friday as part of a hearing over the selections of jurors for their trial. At that time, the judge did deny the defense attorney's request to reopen an evidentiary hearing in the case. So there you have it. The defense has been shut down. So what comes next? Well, I'm sure there will be something before the trial begins in April, so you guys stay tuned. Thanks for watching. Well, on Monday, they had a hearing for Kouri Richins. The defense is pushing for a change of venue. I don't see how that's going to help them, but they had a bunch of items on the table that the judge was to rule on. They're also bringing up a doctor to testify about his findings. So it was about a 3-hour hearing.
In 213500139, State of Utah versus Kouri Richins. Can I have counsel for the state make their appearance, please?
Good morning, Your Honor. Brad Bloodworth and Lindsay Sherbanak for the state.
And on behalf of Ms. Richins.
Wendy Lewis, Catherine Nestor, and Alexander Ramos for Ms. Richins, who is present.
Very good. Good morning, Ms. Richins. We're here this morning on a motion for change of venue filed by the defendant. I've spent a lot of time reading published cases regarding motions to change venue. Spent a lot of time looking at the defendant's and the state's survey results. I have several questions. Ms. Lewis, are you arguing the motion?
Yes, Your Honor, but I have Dr. Edelman here, and I'd really like to start with his testimony, and then, yes, I will be.
Let me ask you a question about that. If I assume that Dr. Edelman's survey results are sufficiently reliable to be admissible, I have a couple of clarifying questions about what questions he asked and what the range of responses were. Does he need to testify to anything else?
Yes, Your Honor, he does. I think he needs to testify about the methodology used by the state and why that survey is not reliable.
This is why I'm confused. Doesn't that survey weigh in the favor of your position?
Yes and no. I mean, the bottom line of the survey in terms of the number of people who are aware of the case is similar. But the state survey does not deal with the ultimate question regarding guilt or the perception of guilt in the community, which is really the point of a change of venue survey. And which Dr. Edelman can explain so much better than I can. But in terms of looking at the ultimate question of guilt and in terms of looking at what specific facts that are in the media that potential jurors are aware of, the state survey does not identify any of that.
Okay.
And the way the state survey is conducted is not within the methodology that is typically used for change of venue surveys. Is a different kind of survey. And Dr. Edelman, I think, though, can fully explain the results of the survey in detail that we have presented. He can answer your questions. He's got a PowerPoint presentation that goes through how this works and how it should be considered, these surveys, in a change of venue.
All right, that's fine. All right. I may move that examination along to the issues that I think are most relevant, but that's fine.
Okay. Are we ready?
Mr. Bloodworth?
Your Honor, before that, the state has a motion that may impact this testimony.
Sure.
May I?
Yeah.
Your Honor, on December the 17th, 2024, the parties sought extraordinary relief from the Supreme Court, in part in connection with their compromise regarding jury selection. During the pendency of that interlocutory appeal, the defense informed the court that if the Supreme Court rejected the parties' compromise position, then the defense would file a change of venue motion.
I'm sorry, Brad. I can't hear you very well. Can you? I apologize.
The Supreme Court issued its order that rejected the compromise on February the 18th, 2025. Rule 29 gives the defense 14 days from that date to file a change of venue motion. The defense did not file its change of venue motion within the rule's time period, but ultimately the court ordered that the defense file its change of venue motion on March the 17th. Presumably
Hold on. Who ordered them to do that?
Your Honor, you did.
I remember saying something along the lines of, you keep mentioning a change of venue, but you keep not filing it. So I set a deadline by which we had to get this thing briefed.
Correct, and that deadline was for the opening brief from defense was March 17th.
Okay, understood. Keep going.
Presumably because of the time crunch that the defense's delay caused the court order that the defense would not get a reply brief. Yesterday evening, Sunday, the defense filed a 16-page expert affidavit styled as a supplement to its change of venue motion that is found at docket 970. In reality, that affidavit is a poorly disguised reply brief. The state has not had sufficient opportunity to meaningfully review it, much less cooperatively consult with the defense's expert or discuss the affidavit with the state's expert. Accordingly, the state moves to strike that affidavit from the record.
The state's motion is denied. You can it's denied without prejudice. You can reassert it if you determine it's necessary, depending on whether I ever rely on that affidavit at all during this hearing. I have some concern that you're all missing the point. Why couldn't the court just accept both surveys and say they show a range and engage with the numbers in each survey?
Your Honor, the state prefers that the court proceed that way. I've seen the draft of the 100 slides that Dr. Edelman's fixing to testify to. I would prefer the court just ruled on the papers.
I do have some questions for Dr. Edelman about whether I'm understanding the other side of the numbers in his surveys correctly. So I'd like to hear from him to make sure I get some clarification on that. And if it turns out that I'm misunderstanding what the other 20.2% of the people that answered the survey said or didn't say, we may need to get deeper into it. But
I was just saying, I think it's important that we make a complete and clear record on this issue. As you know, this issue is highly important to the defense.
Understood.
And we want a complete record on this particular issue.
The hard drive that you submitted, does it make less than a complete record?
The hard drive?
Didn't they submit? Yeah. Isn't that thumb drive showing Dr. Edelman's complete survey and results and methodology in writing?
I think without the explanation, no, it does not, because someone who doesn't understand how these surveys work, it doesn't mean a lot. There's a lot of explanation behind how the survey was conducted, what those numbers mean, and how those have been applied to the reasonable likelihood standard in other cases, and how it should be applied in this case.
Wait a minute. He didn't disclose any of those opinions. Or why would I accept his opinions about whether there's a reasonable likelihood here? That's my determination.
No, he's not giving his opinion on that. He's explaining the standard and how it's been applied in other cases. He's not giving an opinion as to how it should be
Other
applied.
Utah cases?
No, but the law is the same. The reasonable likelihood standard is the same, whether it's in Utah or not. That's the standard for a motion to change venue.
With respect, I'm not sure that's true. In federal court, the standard is much more. The reason I think candidly that federal courts are upheld frequently with respect to denying motions to change venue is that the federal standard is very different. Here, I think it's in state court, looking at state cases, it's a lower standard, less than preponderance, the 4 James factors. I really care less about how we performed the survey versus what the results are. I'm persuaded that the methodology is sufficiently reliable to be admissible under Utah's threshold for reliability. I do have some questions, though, about what the results mean. Can we start with that?
Yes.
Okay.
We can start with that.
Dr. Edelman, may we swear you in, sir?
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
I do.
Thank you. Please have a seat.
Ms. Lewis, may I just start with some questions that are written in bold type on my notes, and then you can fill in and make whatever record you think is appropriate.
Of course.
Doctor, good morning.
Good morning.
Okay. I understand that let's stay focused on Summit County for the moment. How many people responded to the telephone survey?
What do you mean by responded? Completed it?
Yes.
400.
Okay. So when we look at results saying they or someone they know has a connection to the Richins family, 26%, that's 26% of 400 responses?
No, it's 26% of those who have read, seen, or heard about the case.
Okay.
So, yeah. So if somebody doesn't know about the case, and that's a fair point, they might know the family. That's true. But the skip pattern didn't do that. So,
Okay.
Yeah.
So maybe the better starting point is recognize the case. Is that correct?
Yeah.
Is that the first level?
Read, seen, or heard about the case, yes.
And use that phrase for me again.
Read, seen, or heard about the case.
Thank you. And so the 79.8% of respondents indicated that they had read, seen, or heard about the case, and that was based upon the summary provided in the survey, correct?
Correct. So there's those 2 recognition questions, which were built off of the media coverage. So read all the newspaper coverage, watched all the coverage, and then identified the things that were most salient and most likely to trigger a memory without being overly biased.
And I recall, and I didn't copy and paste it into my notes, that the The brief summary of the case that was used to provide context for whether someone had read, seen, or heard about the case was Eric Richins died on this date. Kouri Richins wrote a children's book and is alleged to have murdered her husband. Is that fairly stated?
Yeah, so there's no reference to poisoning or any of that kind of stuff.
Okay. So if 79.8% indicated that they read, seen, or heard about the case, does that mean that 20.2% of the 400 that completed the survey indicated they had not read, seen, or heard about the case?
Correct.
Okay. Okay, then we go another layer deeper, and there's a question about whether of that 79.8% that had read, seen, or heard about the case, am I correct that your survey results show that of that group, 69.1% had formed a belief that the defendant is guilty?
Correct.
Okay.
That's, you notice it says prejudgment 1 and prejudgment 2. So prejudgment 1 is exactly what you just said, and then prejudgment 2 would be for the sample as a whole, for the population.
Explain prejudgment 2 for me.
So it's 70% believe she's guilty of those who recognize the case. But what does that mean if 100 jurors walked into the room?
Right.
Right. So, and that's that prejudgment 2. So I don't have it in front of me, but whatever that number is would be the prejudgment rate in the community as a whole. So that includes people who know about the case and don't know about the case.
And tell me why you can draw any conclusion about the prejudgment rate among those that know nothing about the case.
What do you mean by any conclusion?
Well, if they don't know anything about the case, why would they have a prejudgment walking in?
Yeah, and they don't. So it's only related to that know about the case. I don't think people who don't know about the case I would presume they don't think she's guilty because they don't know anything about it.
Okay, I appreciate that. So if we stay within the subgroup, the approximately 8% that have read, seen, or heard about the case, and we acknowledge that approximately 69 or 70% had formed an opinion that she is guilty, does it follow that 30% or 30.9, is it presume her innocent or have no opinion combined? Is that how it is?
Yes, but the presumed innocent is very low. It's like 1 or 2%.
Okay.
Yeah.
So practically speaking, it's have no opinion.
Yes.
Okay. Okay. And then if we go another layer, not deeper, but just another layer of the 79.8%, there is 50% who indicated that the defendant would have a difficult time convincing me that she is not guilty. Is that 50% of the 79.8 or 50%? I think it's 50% of the 69, correct?
Yes.
Okay.
And those rates change based on, like, if you know particularly prejudicial details, they go higher. So
understood. Yeah. Okay. And would you, let me ask you this way, is a sample of 400 sufficient to show statistical significance?
It's the generally accepted sample size for these, so it's plus or minus 5% margin of error.
So that's 2 standard deviations from the mean. All right. And that would say that it would tend to scale to the population as a whole of the county?
Yes, and a lot of that question kind of goes down to methodology too, right? All the things you do, like it's a random digit dial telephone survey. We do callbacks. We do like soft refusal conversions. So people who kind of are on the fence about taking the survey, the interviewers are trained to encourage them to take it. We call at night, we call in the morning, we call on weekdays and weekends. There's an introduction to encourage them to take the survey. They're told there's no right or wrong answers. They can always say no opinion, don't know. They can call back if they have questions. So all of these things to try to improve response rates. So you're not systematically missing an important group of people.
Let me spring some questions on you that I don't know that you handled in your reporter affidavit. Assume for me that 1,100 people who are qualified as Summit County jurors have filled out a 20 some odd page case specific questionnaire. I have no idea what it says. I just know there's 1,100 of them.
Yeah.
Is it a reasonable application of your survey data to expect that 20% of those 1,100 have not read, seen, or heard about the case?
Well, the survey was finished, I'm trying to remember the date now, in early March.
Okay.
So those numbers could change based on, I know, for example, I ran across a 45-minute interview on Court TV with the family's attorney representative,
spokesman,
saying many prejudicial things. So those
Sure.
numbers could be higher.
Understood.
And it depends on how the questions are phrased in the questionnaire. Right? They're not. It just depends. I haven't seen the questionnaire, so I don't know what it looks like.
Well, and forget about what the questionnaire says, but when they sat down to take it,
yes.
Is it reasonable, when they sat down to complete it, is it reasonable to expect that 20% of those people at that moment had not read, seen, or heard about the case?
Yes, I would say that.
Okay. Is it reasonable to expect that of those 1,100 people that had, of the 80% of those 1,100 that had read, seen, or heard about the case, 30% of them had not formed an opinion before they took the questionnaire as to the defendant's guilt?
Of those who've read, seen, or heard about it? Yeah, that's
Okay.
what I would say. So yes, that kind of comes back to my, if 100 jurors walked in the room,
right?
How many of them would have already prejudged the defendant is guilty?
Okay. All right, I think I understand.
May I just add one thing? So from my perspective, I always caution, because when we go down this route, it turns into a numbers game. Now, and I don't think, from my experience, I've done a lot of these, I don't think the question is, can you find 12 people that will say they can be fair and impartial? You can always find 12 people that can do that. And the biggest example would be if it was a numbers game, let's say the LA County, 10 million people. Remember the Rodney King beating? Well, that was the Powell decision. So everybody in LA County knew about the case, but let's say 90% believed the officers were guilty. Well, that still leaves 100,000 people somewhere. And if it was a numbers game, you would never have a change of venue, because there's always some group of people in there that can, that don't know about the case. And that's not really the question about whether you can get a fair trial. And the other question is, what are those people who are left? So in a case like this, burden of proof might be very important, and you want really smart jurors that really understand beyond a reasonable doubt and are very inductive, analytical jurors. Those are the best jurors in this case, but they're also the jurors most likely to know about this case, because they're most likely to follow what's going on in their community. So your best jurors are the ones that are most likely to be excluded because they've heard about it, have developed opinions. And the question is, well, who's left? And that is not necessarily ideally a fair trial, in my mind. So I don't get into the numbers game where it's always, can you find 12 people? I mean, I've done enough jury selections. I'm sure you've done many, and you know what it's like when you're trying to, someone says they have an opinion. It's very easy to get them to say they can be fair and impartial. We do it all the time. It's an adversarial system. So I don't think at this point, that's not the question. The question is there a reasonable likelihood that she can't get a fair trial? So I focus on, is there a whole lot of bias out there? Do people know a whole bunch of detail? Do they know prejudicial detail? And the other problem is voir dire is, and the way memory works, it's very hard for people to recall everything they know. So if I say, tell me everything you know about this case or a movie, let's say Star Wars, that you all can tell me a bunch of good stuff, but you'll miss a whole bunch of important things. And if I asked recognition follow-up questions, you say, oh yeah, of course I knew Darth Vader was Luke Skywalker's father, right? In voir dire, you can't do that. You can't say, oh, well, have you read, seen, or heard if, she confessed? Not she didn't. I'm not saying that happened, but if they don't mention a confession, that's happens in a lot of cases. You'd be poisoning that juror. Maybe they know it, maybe they don't. For example, in this case, only 10% of people mentioned the walk the dog letter when asked, where have you read, seen, or heard about this case? But later, over 40% recognized that item. So there's this group of people out there that know it. It's prejudicial. Maybe it comes into evidence, maybe it doesn't. Let's say it doesn't. How do you identify who those people are?
Those people that were asked about the walk the dog letter, was it only the group that had read, seen, or heard about the case that were asked that, or was it everybody?
We don't ask, if they don't know about the case, we don't then feed them in
seed.
about it.
I understand.
So that's the biggest thing. And it's not just like conjecture. I mean, so this whole thing for me came about, there was a case in Texas, John Fight, and he was a Catholic priest charged with murder. He killed a beauty queen in like the 1950s. And this case had gone to trial for 30 plus years. And then they charged him with murder, brought him back and all this. And in Texas, you actually have to bring people in the community, and they testify in the change of venue hearing about what they know and all these things. And we kind of treated it like a mock voir dire to prove that point. So they told us everything they knew, and we'd ask, well, is that everything you know? And they said, yeah, that's it. And we'd say, well, have you read, seen, or heard of John Fight confessed to a priest in a monastery? Oh yeah, I knew that. You didn't just mention. Sorry, too much coffee. I'm sorry. I'll slow down. And it triggered a memory. And then we'd say, do you know anything else? They'd say, no. And then we'd say, well, did you hear that John Fight allegedly attacked another woman at a different church? Oh yeah, I knew that too. It was in Edinburgh. Okay, is that everything you know? Yeah, that's it. And then it's, well, have you read, seen, or heard if there was a cover-up? Oh yeah, the Catholic Church moved him around and blah, blah, blah. So that is the problem in these cases. In normal voir dire, none of that's an issue because people don't have case-specific attitudes towards a case. They just have general attitudes.
I appreciate your pushback to the idea that it's a numbers game, but I don't have an infinite number of options here. The defendant has asked me to move the case in one way or another to Salt Lake County jurors. Those folks are not blind to the media coverage of this case. If I understand your survey results, about 42.5% of.
I love this judge. He's so down to earth. He's so like, I don't know. I wish more judges were like this guy. He's just very even keel, but he's fair.
Them have read, seen, or heard about the case.
Yes.
And 57% of those folks have formed an opinion regarding that she's guilty.
Right.
Why don't all of the dynamics that you've just described apply with equal force in Salt Lake County?
Well, good question. And I think, one, it's far fewer, but also more importantly, they are not as familiar with case-specific details. So the people in Salt Lake.
But didn't you, and this is a genuine question, I'm not trying to cross-examine you. Didn't you just tell me that people are not good about recalling what they know?
Well, let me clarify. When I ask, have you read, seen, or heard if, those are recognition questions. And that's where we identify the extent of their case knowledge, compare it to the open. And they know much fewer case-specific details when we ask the closed-ended question, which memory is much better. They also reported that they didn't follow the cases closely. So they're not as engaged. They don't have as many connections. So there's a lot of those factors that come in. And it's also a much larger community. So as you'd expect, there's so much more going on in Salt Lake that this case hasn't captured their attention. I also look at the fact it's not very far away. It's not a huge inconvenience compared to some other cases, like in Moscow, Idaho, we did change the venue, moved it to Boise. Well, that's a big, that's really far.
Right.
And there, I'll give you an example. The recognition rate in Idaho, in Lake County was 98%. It was about 97% or something like that in Ada County. Virtually no difference there. The differences that mattered were the connections, the personal connections. Did they go to the university? Had they been to the victim's house? Had they seen it? It's those things. And you see a lot of those unique factors here. And that's kind of the stuff that stood out to me as justification. And just looking again at the severity of the crime and the fact that she's looking at, if convicted, many years in prison, it seems like a fairly reasonable, low inconvenience to move it to the largest county since it's so close, and recognition's lower, prejudgment's lower, case-specific knowledge is lower, recognition of prejudicial details that really stood out are lower. So there's all that benefit.
Okay. Let me pause there.
Yeah, that's a lot.
Why don't you lay whatever other foundation? I appreciate you letting me get answers to my questions.
Oh, thank you. They're excellent questions.
All right. You guys have a moment to sort of turn around my plan here.
Sure.
So, can I just focus on the
Sure. Yeah, I mean,
over the stuff.
I think we just went over a lot of what's in there.
Okay, all right. So if that's right, Your Honor, I think we still pull the ground point, we can skip over a a lot of it based on the questions you just asked,
Okay.
you just answered.
Sure.
And address what we have not done.
Brittany, would you turn that television?
Do you want me to go through
attorneys
his
are
background? I was
so
planning on just,
annoying.
you're okay with,
I know how to read.
all right.
Oh, they're
Well,
the
then why don't we
worst.
just go ahead and start with that?
1 second. Let me get. Alex, is there a PowerPoint that you want published?
There is one up, Judge.
Okay, 1 second. Let me do a little finagling here.
While he's pulling that up, Dr. Edelman, maybe we could just start with when you were initially hired to do a survey on a change of venue, you said that you follow a 3-part process, correct?
Yes.
And maybe let's start with explaining how that 3-part process, what it is.
Yeah, so it's a 3-phase process that was taught to me by Dr. Ed Bronson, who is one of the kind of forefathers of all this. He did like the Oklahoma City bombing case and Boston Marathon and Skilling and many of the big ones. And basically the first phase is to collect the media coverage and make an assessment if it contains any prejudicial, sensational content, the extent of the coverage, anything unique. If not, that's the end of it. So we don't do any more, and that's capped. So that's capped at like 6 hours. If it looks like there's extensive coverage or prejudicial coverage or something that might be concerning, like maybe there's one specific item that stands out, like there was a trial, somebody was convicted, and then the conviction was thrown out years later. Well, that's pretty prejudicial to know that a jury already convicted them. That might justify going to phase 2, which would be a community attitude survey to assess the impact of the media coverage on prospective jurors. Because just because there's prejudicial coverage doesn't mean it automatically has an effect on people. I've had cases where we've done the survey where there's a lot of coverage and there's low recognition rate or not a high guilt rate. Once the survey is completed, there's a range of things that the data may support. Could be not a moderate issue where recognition is like 40-50% and guilt's not very high. It's a big community, so maybe it's just like extended voir dire, a better questionnaire or individual sequestered voir dire, a lighter cause challenge standard, things like that, all the way down to, like in federal, there's a lot of intra-district transfers we do within the district to state cases, change of venue. So it just depends. And then the last phase would be what we're doing now. If both sides don't agree, we would get here. And sometimes they do. I just did one in Tennessee, the Tyree Nichols case, and both parties agreed to move it. So we didn't have a change of venue hearing. The judge moved it based on the survey data. So those are the 3 phases. So it's not just like, let's go spend a bunch of money on a survey. It's let's do it piece by piece so you're not burning through county money. It's the deal.
Let's go ahead. All right. Why don't you just go ahead and, Judge, if you want us to move on something, that just why don't you let us know?
I think we can keep moving. I'm really more concerned about the results of the survey here and any nuances in it that you fear that I wouldn't appreciate by just reading the summary of the data.
Sure. Well, I will say, just on this issue, we don't have to go through all this, but you can, if you want to skip to the media coverage itself and not so much. This is kind of the impact of pretrial publicity and how it works, the cognitive process on juror decision making. But do you want me to offer this? Or?
I don't know if right now if this would be a good time to address how the pretrial publicity can be confused with evidence in the case. When we have a jury who has been exposed to a lot of pretrial publicity, how can that affect them when they're sitting as jurors in the case?
Yes, so there is research on that and how memory works. And there's one study, what they did was they read pretrial publicity and then 5 days later watched a murder trial. And then a couple of days later, they were asked whether the specific pieces of content were from the pretrial publicity or from the evidence they heard. And after just a few days, the source gets stripped. It's integrated into a general memory, and you can't remember if that was pretrial publicity, if it was trial evidence, or it was in both. And that's just how memory works. Like
Dr. Edelman,
yes.
May I cut to the chase here a little bit? That would seem to counsel in favor of never impaneling a potential juror who had been exposed to pretrial publicity at all. That I don't think is the law in any jurisdiction in the United States. How would you say, what's the through line there about the fact, especially in the modern media environment?
Well, I think the significance of that, again, like people's exposures on a spectrum. So if someone just said, well, they know very little, I'd be less worried about it. If someone knew, for example, about a prior conviction, those are things that become significant. So if you can't remember if the prior conviction came into evidence or not, those are bigger things. So I don't think it's for everything, like you said. I think if you look at the types of pretrial publicity that are most impactful or what your biggest concerns are. This case had some things that were initially reported that maybe are not true, or maybe those theories have changed. So but you've already been exposed to it so much. One of the most common things is that you saw was that she was poisoned with a Moscow Mule. And people spontaneously mention that. There's a big belief that's true. And if the theory has changed, well, that's very significant in this community in terms of people believing that. So you're starting from the point you already assume that's correct. And so if they hear something similar, for example, it was a different drink or whatever, you're just triggering a memory. So you're not hearing evidence for the first time. It's not like, I'm looking at the probative value of this new evidence as a blank slate. I'm just recalling what I already know and integrating consistent information with what I've already read, seen, or heard.
Is see if I can summarize this correctly in my question. Is the percentage of respondents who identify familiarity with some of the more inflammatory facts of the case higher among the group who indicated that defendant would have a difficult time convincing me that she is not guilty, or is there not that correlation?
There is.
Okay.
There is. So that's correlated with the number of details they know, which is consistent with the social science literature. That's an internal validity check. You see that relationship. It's consistent with how closely they followed the case, how many details they know, and specific details that are more prejudicial than others.
And on the flip side, if they indicated that starting small, going larger in terms of group size, they have formed an opinion that defendant is guilty, but defendant would not have a difficult time convincing them that she's not guilty, or they have read, seen, or heard about the case and have formed no opinion regarding defendant's guilt. Do your survey results show that those groups of people, those subgroups, have less case-specific detail recollection, less exposure to pretrial publicity?
Yes. So it's when we say less, it doesn't mean it's not high. It depends. You have to look at it. And there's actually we have a chart on exactly what you're asking.
Can we go there?
Yeah. That would be the only thing I'll say on the coverage. If you jump into the one slide, I just wanted to highlight was keep going, but we can skip all these. This is just, it was with keep going. It was one more. No, just because there's one. This is what most concerned me. I just want to touch on this before we move on. So one of the things is the imbalance of the coverage, where you have information that's supporting one side and not the other. So when you have Mr. Skordas going on TV and espousing, not only repeating things, but speculating on motive and the psychology of the defendant. In this episode, this is a 45-minute long episode that appeared just a few days ago. And there's stuff in here about not only about the boyfriend, but about this woman is speculating on the defendant's mental state and so on without ever evaluating her. And then Mr. Skordas is supporting it and reinforcing it. So it's not like this stuff has stopped. It's still happening. It's very prejudicial. It's only on one side. And that is one of my bigger concerns is all this pretrial publicity benefits one side. It's not balanced. And one side's not speaking to the media and the other has free reign to do stuff like this. So that's quite concerning. So I just want to highlight that before we move into the survey. I think it puts the defendant at an unfair advantage and it helps the state quite a bit.
Right. We just acknowledge for the record that Mr. Skordas is a spokesperson for members of the Richins family, not for the state of Utah?
Yes.
Yes.
Okay.
But it still helps them.
No, I
get the benefit of it.
I understand.
Yeah. Okay.
All right, go ahead, Alex. And Dr. Adam, I want you to just stop us when you.
Okay. We're at the survey now.
All right.
So if you want to, would you like to skip just to those tables or?
I understand what makes a juror eligible in Summit County. We can keep rolling here.
Right. This is just the structure of it. Okay. So these are the high level, and most of these surveys are designed based off of 30 plus years of research and people doing these. So there's very clear standards of how you do a community attitude survey for change of venue. And a lot of those questions have been tested, validated. We do cognitive interviews before the survey goes out, where we read the survey question to people and ask them to interpret the question verbally so we understand, to make sure they're processing it correctly and understand the answers, so that people answer the question and interpret it consistently, which goes to construct validity. So important. But yes, so this kind of just shows a high level recognition rate, 80 versus 43%. You can see half of those who know the case followed it somewhat or very closely. In contrast, Salt Lake was just 25%. You have a guilt rate of 69% versus 58. Definitely guilty, 18 versus 8. And that my surrogate for fixed opinion, the presumption of guilt instead of presumption of innocent, is 50%. And then negative opinions. You can see people who've been exposed to the media coverage have somewhat or very negative opinions of the defendant.
Let me ask you on the question that would you have a difficult time convincing them? Would Ms. Richins have a difficult time convincing them she's not guilty? Mm-hmm. Where did that question come from? You said that's the question you use to talk about burden of proof, really, but how did that question, where was it devised from?
Yeah. So one of the more controversial questions is, can you set that aside and be a fair and impartial juror? And there's a bunch of research and literature on it that it creates socially desirable responses. And you'll see inconsistencies. So people will say, 74% will say they could be a fair and impartial juror, like on remember the American Taliban, John Walker Lynn case?
You're really fast.
Sorry. American Taliban case. 74% said they could be fair and impartial and that he deserved a fair trial and so on. But 30 plus, I think it was 34%, gave inconsistent answers in the survey. Like, he's as bad as Osama bin Laden. He's definitely associated with the Taliban. He's definitely guilty. So you're not seeing consistent responses. When we look at what's called internal validity, you want consistent relationships. So if somebody thinks someone's guilty, strongly believes that, they should say they cannot be fair and impartial at much higher rates than people that don't know anything about a case. And you don't find that. And it's because there's a clear socially desirable response. I'm supposed to be fair. I want to be fair. I want to be a good citizen. And people don't know how evidence is going to impact them because they don't know what's going to happen. This question...
Dr. Edelman, maybe ask you a question. What order are the questions asked in? What do they ask the fair and impartial question first, and then the other more specific questions regarding...
In which study?
The American Taliban case.
In the American Taliban case, it was after they are asked the guilt question, they're asked the fair and impartial question, and then later on in the survey, they're asked different questions.
Why aren't the questions asked in the reverse order? And are there surveys in which they're asked in the reverse order and internal validity goes up?
I would have to look at the exact instrument because it's probably 40 pages long. But unfortunately, I don't have that in front of me, so I'm not sure. I could say I've done research on this question with I don't know if you remember the Robert Durst case. Yes, the Jinx. So what we did was we recruited people from the Jinx Facebook page who publicly stated very sensational, inflammatory comments, like he's a sociopath. I'm so glad he was arrested. I'm physically ill. These are pretty strong statements. If a juror said that in a courtroom, they'd be excused for cause, even if they say they could be fair. And then in the survey, we asked what they knew. They knew about the confession. Remember the cheeks, he had the microphone on. They knew about murders that were inadmissible in the new case. They reported that he's guilty. I think it was like 100% or something like that. And a very high rate said that he couldn't change their mind. the question we ask. Then we read them a standard instruction from a real case about the law requires you to be fair and impartial. Everybody deserves a fair trial. And then we ask them the follow-up, can you be fair and impartial and set it aside, and why? And all those jurors or people who professed extraordinarily strong opinions in a public forum magically say, oh, yep, I could be fair and impartial. And the woman who said, he's a sociopath, I'm physically ill, was, I can listen to the evidence, everybody deserves a fair trial. So there's just no underlying support for the notion that that is a reliable question. There's also published literature on it. I'm not going to go through all of it, but one study, Moran and Cutler, over 70% said they could be fair and impartial, but 34% said that they couldn't put the media out of their mind. Inconsistent. This question came from a judge in Tennessee in a murder trial, Nicholas Johnson, and all of these jurors had a lot of detail, and the judge would ask them the magic question, can you be fair and impartial? And they would kind of, I think I can try, things we've all seen a lot. And then he'd say, he asked them this question, well, would Nicholas Johnson have a difficult time convincing you that he's not guilty? And they'd say, oh no, he can't change my mind. So it was like this clear epiphany. So when I saw that, I was working on the post-conviction stuff. I started using it in surveys and found that it's consistent, it's internally reliable, it correlates with things like case knowledge, how closely they follow the case, prejudicial items. So it has all those checks that you want to look for internal reliability and validity. So I started using it.
Okay.
Okay. And this kind of is an indicator of the difference when we talk about connection and impact. This is a relatively small community, and you can see 70% have talked about this case or heard people talking about it online versus just 25% in Salt Lake. And those are some of the things that really stand out when it comes to spreading rumors, misinformation, demonstrating that this case has captured the community's attention, is just people talking about it. And seeing it on social media, and then the connections to the family.
Will you go back one slide, please? Okay.
Okay, so this comes back to case knowledge, or media items knowledge. Shouldn't call it case knowledge. But you can see that people in Summit County who have heard about the case recognize quite a few details that were widely reported in the media. So 60% of them knew at least 4 of the 8 items we tested, and 56% knew 5 or more. And you can see those numbers are much lower in Salt Lake, which just shows, again, that people in Salt Lake are not following it as closely. It's not as significant to them as it is here.
And there were 9, correct? 9 facts that you asked?
You're right, it's 9. Sorry.
And what were the 9 facts that?
Off the top of my head.
Do we have them in another
there's
slide?
The slide there. You'd have to go to all of them. This is the recognition question. This is just, we can kind of skip through all this.
Dr. Dolan, may I ask you a question about the 8 media items?
Yes.
The state's expert, whose name escapes me at the moment,
Dr. Monson.
Dr. Monson talks about the use of a red herring question to identify which respondents are just agreeing.
Acquiescing?
Yes, indeed. What is your view on whether any of that's baked into the recognition of the media items?
Absolutely. So actually, if you wouldn't mind jumping to that slide that kind of goes into that, keep going. And I'll just keep going until you see the similar case that's similar to the bogus story that he used. Just keep going to the end of all this. But typically you don't use bogus items. They're called bogus items in the change of venue world, and there's research on this. And the problem with bogus items is you have to create an item that's believable, right? If you create something that's so outlandish, it's obvious it's not a real item. But by using an item that's believable and close, it's not that people are acquiescing. It's that they've developed a cognitive schema about the case, and it's consistent with their strongly held beliefs. What you're supposed to use of what we did is we use items that have less reporting on it. They've only been mentioned a few times, once or twice or less, and you should see lower recognition rates for those items, and you do. We have an item that only has 11% recognition rate, which is our item. Rather than a bogus item, we use that. And I'll keep going. The example, one more kind of on the point of doing this is this. This is the bogus item that he used. A Washington County woman was arrested and charged with the kidnapping of a 9-year-old girl from Cedar City. Well, guess what? There's a bunch of real cases that are consistent with this within the time frame where they're doing the survey. And if you go to the next slide, these are all the stories. And jurors, if you look at the respondents in his open-ended about this case, keep going, they're not acquiescing. They're actually, this is a quote, this is an example of one person referring to this case. So it's not acquiescing because a desire to just say yes to be because of inclination. They're citing a real case that's similar to the items he created. And if you go to the next slide, there's a whole bunch of them that fit into that.
Did your survey use a bogus-ish, or sorry, not a bogus item, but a
lower recognition.
Yes. Item? And what were the results there?
Jump all the way back to 2 surveys. And there's huge differences. So why would people acquiesce in one and not the other, right? You would see that similarly, and you'd see yes consistently. You wouldn't see variance across the items. You would just see really high recognition rates across everything. So this one only has 43%. This one has, keep going. I think the actual item we used, it might not even be in here. Keep going with our listed, and you can see it. Until you see the list of all the 8 items. Those. Okay. So the last one, Kouri wanted to kill her husband so that she could start a new relationship with her boyfriend with as much money as possible. That only has a recognition rate of 12% in Summit County and 7% in Salt Lake.
Okay.
I don't know where we are now. Do you want to go back to some of the survey numbers?
Because this kind of goes to that too. Keep going until you hit this table. So this is how we check, again, internal validity. All right, there's predictions of what we expect to find from the social science literature. People who know more information, have more case knowledge, are more likely to have bias. That's what we expect to find. That's how you check for construct validity. That's how you check for internal validity. And that's exactly what we find in our survey. We're finding consistent, predictive relationships that are based on 30 plus years of social science research. That's some of the ways we test for this. And this is part of why we do it this way and why we use the established questions and measures that have been used for decades and validated. Okay. And
forgive me.
No.
And I acknowledge that your survey results may not either be this granular or this cumulative, but did you determine the area under some of these curves? Meaning, of the 400, what total percentage recognized between 0 and 2 or 3 facts? Does that make sense?
I'm sorry. What do you mean? One more time for me.
Well, there's lots of small subgroups, right? And they're in each of these.
I got you. This is only for people who have read, seen, or heard about the case.
Okay.
Because the other people aren't asked any of these questions.
So, even among the people that have read, seen, or heard about the case, did you calculate what percentage of those recognize 3 facts or fewer?
Recognize which one?
3 facts total or fewer.
So you can see, so if a couple interesting things. One, you can see like 0 facts, only 29% say guilty, right? 71% have.
Yeah, I know. I'm asking a slightly different question.
Go back a couple slides. It shows how many know this one here.
Thank you.
Yeah. I would have to look at the data itself to
So if I'm reading this correctly, among the 80% of Summit County respondents that have read, seen, or heard about the case, 34% recognize 3 facts or less?
Yes, correct.
Okay. Okay, thank you.
Sure. And then, so if you jump ahead a little bit here, so this is just an example of one, and you're seeing again that how knowing this detail, this was widely reported. Quite a few people know this fact, and it's correlated with perceptions of guilt and our fixed opinion question. So it's significantly related to that.
And do you have the percentage of people surveyed in Salt Lake who knew 0 to 3?
It should, in theory, be as well. This is just for Summit County.
Okay.
Okay, and then the next one, the Moscow Mule one, that's a big one. Very widely reported, very high recognition rates for this item. And you notice 77% who know it think she's guilty, and 57% reported that she'd have a difficult time changing their mind. This is one about buying fentanyl the weeks before. 64% know about that, and if you know it, very high guilt rate, 81%. And this kind of gets back to the voir dire problem of if you know this is a prejudicial item or the previous one, and they don't mention it in voir dire when you ask, what have you read, seen, or heard about the case? Well, there's a significant percentage that know it, but you can't ask this question because if they don't, you're poisoning that juror. And that is the biggest unique thing about high-profile cases versus your regular case when you're doing jury selection.
And how is that going to be better with the Salt Lake County jury?
Well, that's true everywhere. If it's a case where there's pervasive media coverage and a lot of people know facts, you'd have to look and see what that recognition rate is, but it's lower.
It's lower? And we have that, don't we, in the survey?
It's in here.
It's there. Okay. All right, go ahead, Alex.
I think I understand these dynamics.
Yeah.
Was
Okay.
there anything else you wanted to put on the record initially here, Ms. Lewis?
Yes, let's go. Just go ahead and when we get there. Go ahead, Alex, just.
Do you want to talk about this or?
Well, I want to talk about, I do. I want to talk about the survey that was conducted by the state. And as the judge said, the recognition level is similar.
Mm-hmm.
But why is the survey that you did more reliable and should be considered in terms of what we're going to actually see in the courtroom as compared to what they did?
Well, I think at a high level, I would ask, I'm not quite sure what the survey is trying to measure. So the survey I'm trying to measure is bias, prejudgment against the defendant, and whether a presumption of guilt is pervasive. There's no question in there about guilt or what their opinion is. What details, there's one question about details, which is just briefly described. So there's a number of issues there. The whole thing to me looks like it's a test. It's written, the cognitive effort to answer it. You've got, here's a list of 9 names. And then if you answer yes to each one, then there's a question about each name. And then here's a list of 6 random stories. Sorry. And then asking, how familiar you are with that. When we write surveys, one of the things you want to do is make it simple and easy to follow, because there's something called survey fatigue, and the more complex it is, the more likely you're to start getting bad data. So I don't think name is an appropriate identifier for case recognition. A lot of people don't recognize names. I mean, I remember I did the change of venue for the Pittsburgh synagogue shooting. Robert Bowers was the defendant. I would not assume if somebody doesn't know the name Robert Bowers in that area that they don't know the case. I don't think that's appropriate measure. Names are much harder to recall. And then just some of the I don't understand the definition of impartiality that he's using. Don't recognize the name versus not recognize the name. Does that make you impartial? It's not about recognition of a name. It's about, do they think that she's guilty? I've never seen a definition of impartiality in a case where it was just based off of if you say you know the case or don't know the case. That's not the criteria. The questionnaire design is another issue, I think, in terms of, like I said, the complexity of it. There's questions that I still don't understand what the question's asking. And then when you do an online survey, there's something called Satisficing. And
I'm sorry, called?
satisficing. And there's things you have to look at. So the way this was done was a text message to like 50-something thousand people. So you're getting it on a phone. You could be at a movie, you could be at dinner, who knows where you are. And if you tap on it, you're given a survey, and you have to make sure people aren't quickly just burning through it fast to answer questions. You don't know how closely they're reading a question. You don't know if they understand the question, which is why we do telephone surveys, because you can read the question to the person. You control the pace. You can try to do soft refusal conversions to encourage them to take the survey. You can answer questions. You can ask probes. There's all these things you can do that you can't do in an online survey. One person was Googling stuff as they took the survey and literally copied and pasted something from a newspaper article into the open-ended question. You don't know if people are taking the survey with friends. I mean, you don't know if they're giving the link to someone else. And there's all these things. Who takes online surveys when we're so used to spams and text messages? All of these issues. I don't know what the phone survey looked like because it was never provided to us. The other thing is, you always tell them there's no right or wrong answer, and you could always answer with no opinion or don't know. That was not done here, and it wasn't given as an option. One of the big things with yes or no questions, first, they're used all the time. Go look at a Pew, Gallup, all of them use yes or no questions. They're not automatically affected by acquiescence. But you give a no opinion or don't know option, which reduces the pressure to answer yes. There's no option to use that here. So there's a host of things there. And again, there's 30 plus years of research on this. There's professional code from the American Society of Trial Consultants designed specifically to write change of venue surveys, which are based on APOR, American Association of Public Opinion Research, and research methodology that have been published. That's why we do it that way.
And the American Trial
Society of Trial Consultants.
They specifically in their code include the question about presumption of guilt.
Well, not a presumption of guilt, a measure of guilt.
A measure of
guilt. To measure guilt. That's the question, to identify if you can get a fair trial, not how many people know the case. They could know the case, and it could be nobody thinks she's guilty because the coverage was really favorable.
And the other one that is not in the state survey is checking specific facts of the case.
Yes.
That is one of the standards used in these type of surveys.
You measure case knowledge. Even his question, if you go next one, the case knowledge question, it's not even a measure. Well, this is the one when we talk about ambiguity and construct validity. Construct validity is, what are you trying to measure? So we're trying to measure bias. That's our construct validity. I don't know what this means. Thinking about your opinion of Kouri Richins or her case, how fully formed would you say your opinion is? I don't know anybody that understands what a completely unformed opinion is. And what happens is people interpret the question differently. Some people think it means uninformed. Some people might think it's not strong. And when people interpret the question differently, you have a problem with internal validity. If we all don't interpret the question the same way, it's not a reliable, valid measure.
So we need to use language that has a general understanding as opposed to something. We need to use language that people have a general understanding of what that means.
It's a basic standard of survey design, which is why the questions we use are piloted. We do cognitive interviews to make sure they understand them when we add new questions. And it's based on people doing this for 30 or 40 years. We don't just manufacture questions and then throw them into the wilderness. Okay. And even when he asks what they know, he doesn't say, please tell me, first of all, please explain what you know. It's what have you read, seen, or heard, not explain. And the word briefly tells me, don't tell me everything you know. Be as brief and concise as possible, which is not what you want. You want a full explanation of everything. And then how certain would you say you are that your explanation is accurate? What does that mean? Does that mean that my explanation is accurate of what I know, or the explanation is accurate of the description?
Or are we asking if the media coverage is accurate? I don't know, but it can be interpreted different ways, and that's the problem.
Alex?
And then population of interest. It only looks at registered voters, and I don't know if this is significant because the list here is made up of the DMV list and registered voters, and only 63% of Utah eligible voter population is registered to vote. It's actually ranked as 45th in the country. There's a big number of people who are not registered to vote, but are eligible to serve as jurors because they have driver's license and in this county. There was no question about that. There was no question to remove felons, all the basic things that you typically include. So yeah, that as well.
Go ahead, Alex. All right, I do want to talk about, and you have touched on a lot of this already, but is there anything else about voir dire and why that isn't going to solve the difficulties in this case that we haven't touched on yet?
So one of the things that comes a lot when I do this is, well, why don't we just try to
interject?
Sorry.
I need you to highlight the challenges of voir dire that are specific to Summit County that would not be present in Salt Lake County, given your survey results showing the substantial, though not as high, level of exposure to the case in Salt Lake County.
Yeah. So the problem that exists here in terms of if people have a lot of detail, like there are people in Salt Lake that know this case. The benefit, again, is they don't know as many case-specific details. They haven't followed it closely. So fewer people are likely to know specific things that they know.
Can I ask a very practical question? If you were advising the defense, would you advise them just strike everybody that recognizes the case?
Well, here or there?
Both.
Well, here's the problem in my mind. Let's say that's your gut reaction. So let's just get rid of everybody that knows about the case.
Yeah.
Here it's 80%. Sure. Let's say. Well, who are the 20% left? Well, what if your jury profile, when you're actually thinking about trying the case, is like the best jurors for us are the most engaged in this community and they're most educated because they're most likely to stick to the jury instructions and most likely to hold the government to the beyond a reasonable doubt standard.
But with respect, you just pivoted to favorable jury, not fair and impartial jury.
Well, so if the idea is a fair jury are just people who are disengaged in the community, are not highly educated, don't follow the news, well, you got people that don't know about the case.
I think, but with respect, people that are relatively disengaged, overwhelmed with their daily activities, not engaged with the news, are fully capable of being fair and impartial jurors. So stick with the fair and impartial prong for me for a second.
Okay, so I mean, if that's the premise, is it's okay to get rid of like highly educated jurors, or if that's your profile, then sure. One thing you can do is say, let's get rid of everybody who recognizes the case and see what's left. I mean, I've never seen the sides agree to that.
Why isn't that dynamic the same in Salt Lake County, though?
Well, in Salt Lake, there's fewer people that recognize the case, right?
Sure. So if you get rid of all of them, isn't the same dynamic of the people that recognize the case, in your view, are likely to be highly educated, highly engaged? I don't know, I'm spinning hypothetical here based upon.
There'll be more people that are highly engaged, highly educated that don't know about the case.
Where does that come out of your data?
Because they haven't followed the cases closely. Like here over, what was it? The number of people in Summit County that are fascinated by this case, follow it closely, somewhat or very closely, are much lower than in
How many facts indicate following closely versus not closely? What would be the break over there?
How many facts?
Yeah. How many media facts recognized?
Oh, there's a
would indicate following it closely versus not.
You'd have to jump. There is a cross tab on there at offhand.
Can we go back?
Go back to it.
Do we have any idea where it is? Go back, Alex. Is it this one?
Go back. Well, I mean, this would kind of tell you, this is the theory of 100 jurors walk into the courtroom. Let's see if this answers that.
I can do that math.
Yeah.
I need to understand your.
So you can see that second one. Followed it somewhat or very closely, Summit County 40, Salt Lake only 11.
Okay, so let's stay there for a moment. Does it follow then that 60% of Summit County jurors do not follow the case somewhat or very closely?
Correct.
Okay.
I'm trying to find that. If you go back, there's a cross tab that shows the relationship. So this is case facts relationship. But go back one more. Keep going so you see it. A cross tab that shows. This one. Okay. So this kind of gets to whether they fought it somewhat or very closely. And you can see the guilt rate's quite high. And that's just a measure of what you'd expect of engagement. So if they followed it very closely, it's probably mediated through case-specific knowledge.
Right.
Which ties into guilt.
I'm trying to interpret the numbers at the bottom of this matrix. Does that mean that out of 400 respondents, 462 have followed it not too closely or not at all?
Well, it's not out of 400. This is out of the people that have read, seen, or heard about the case.
Okay. So bear with me.
And one thing, just because you passed it, but just mentioning that the rumors that have spread in this community as well that are unique here, that, yeah.
And so back to Judge Morazic's point, in Salt Lake County, the fact that someone has not heard as many factors or hasn't heard of the case, does that translate as it does in Summit County that those are just uninformed jurors? Or does it have to do with the fact that Salt Lake County has more of a news influx and it's a bigger county?
I always look
That might have been worded real well, but I think you understand what I'm.
Well, I mean, let's take a step back. We started with Salt Lake County to see if recognition rate was lower because it's really close here and it's the largest county. Like that's always the first step. You know, that was the primary county I looked at, or only because it's big, it's 30 plus miles away, and recognition rate looked lower. If we're high numbers, we would have looked at a different county. We would have kept going further away. And
Let's talk about that just for one moment, because that comes up in the state's response. Why didn't you look at Washington County, for example?
Washington County? Well, we talked about that. So the plan was we had money in reserve to do 400 completes for a comparison survey. We didn't want to do 401 county, and then it turns out there's no difference, and we spent all that money. So the idea was to start with 200, stop, look at the data. If the data in Salt Lake looked bad and recognition rate was high, we would have done Washington County as the next one, and that way we're not burning through the county's money. When we looked at the 200, the recognition rate was much lower. So rather than spending another $11,000 to do more, we stopped.
And can you address also, do we need to be concerned about that we looked at 400 in Summit and only 200 in Salt Lake, and how that might affect the numbers?
How it affects, what do you mean?
How it affects the percentages. Is 200 enough to
the margin of
make
error?
these? Thank you. The margin of error.
It's 7 plus or minus 7 at 200 instead of plus or minus 5. That's it. And again, the point isn't precision I'm not trying to predict the outcome of the trial or the outcome of an election. I'm trying to weigh and assess if there's bias in the community. Reasonable likelihood, lower than the preponderance of evidence. So that's the question. Is there bias? Not precision and exact measurement. That's not what I'm really going for.
Okay. And what's your conclusion on whether or not there's bias in the community in Summit County?
Based off of the survey data and the nature of the media coverage, I think there's a reasonable likelihood that she can't get a fair trial here. I think the example, like I mentioned before, when we compare the open-ended, on average, I think people mentioned like 0.7 media items, details about the case, but they knew on average of about 4.3 additional items when we asked the closed-ended question. Only 10% mentioned the walk the dog letter, which is significantly related to prejudgment, but over 40% know about that. So those are the kind of things that come into play.
I just want to, I'm sorry, Doctor, I just want to clarify that. So when you asked the open-ended question, what do you know, 10% mentioned the walk the dog letter.
Yes.
But then when you went through and said, have you heard about the walk the dog letter? That
40,
jumped to 40.
Jumped over 40, yeah.
But that's only among the 80% that recognize the case
yes.
writ large.
Right, but it shows you the problem, the pervasive problem of there's a group of people out there that know prejudicial, potentially inadmissible content. That's just one of the items, but you don't know who they are, and you can't say, well, Ray, did you know this? Because they could say no, and then you just told them, or they could say yes, and then you just again confirm that people know more than they know. So, what are you supposed to do as the in voir dire if you're the defense? How do you exercise cause challenges if you don't know if that person could truly be fair? You have to weigh what they know versus what they say. If you look at all the court decisions, that's important. It's a totality of the circumstances, and you just don't know what they know. And that is, again, I harp on this because I've done over a lot of these. I've worked on over 70 of these. That is the problem with these cases relative to every other normal jury selection we do. General attitudes are not predictive of behavior. Specific attitudes are. When we have well-developed attitudes, we look for information consistent with how we see the world. It's called confirmation bias. Information consistent with what I already know is given more weight. It's stored in long-term memory. It's easier to access. Information that's inconsistent is not stored into long-term memory. We make a cognitive effort to refute it. So all you're doing when you hear this evidence that's consistent with what I think about this case is confirming what I already know. You're triggering nodes in memory, which are all this stuff I saw in the media coverage, and it becomes activated, and information, new information is processed based on that. So in voir dire, when you ask, tell me everything you know, people will not remember everything because that's the way memory works. Just like movies we saw as kids, we don't remember everything, but when you watch it with your kid today, it's like unlocking a vault. You watch 10 minutes of it and the whole story unfolds in front of you before you've seen it. That's how memory works. And that's how it works for jurors too.
May I ask a question?
Yes.
You may.
Have you reviewed the questionnaire that went out? Not the responses, but the structure and form of it in this case?
I have not.
Okay. Thank you.
And I will say,
well,
that's okay. If the answer is no, that's fine.
Yeah. Okay.
Okay. Thank you.
He actually did review a draft of the questionnaire.
Oh, okay.
The first draft of the questionnaire.
I did see that. All right.
Is there anything else that we haven't covered that you think we need to talk about?
Not off the top of my head. The only thing I will say is one of the questions we ask are what rumors you've heard in the community and in what you heard about the cause of his death. And that's where you see, again, small community, the spread of misinformation and speculation that about her, about whether she's a good mother and drugs and all these different things that aren't in the media. And you can see a strong belief in terms of the cause of death being what's widely reported in the media. So just, if you look at the opens, there's quite a lot there as well.
And you didn't see that in Salt Lake on the rumor question?
There's a much higher, I don't know, no opinion when you look at those opens.
Okay. I don't think I have anything further.
Okay. Need a brief break, Mr. Bloodworth? I don't know how much time you have with Dr. Edelman.
Your Honor, I do not need a break. I don't know, 15 minutes?
Okay. You okay to keep going?
I have a diaper on, so I think I'm good.
All right, very good. Mr. Blood.
Thank you.
I hope that didn't get put on the record.
In fact, it went out to all the people that you're worried about.
Good morning, Doctor. My name's Brett.
Good morning. How are you?
I'm well, thank you. How are you? As I read your affidavit, there's kind of two parts. One is a styled media analysis, and the other is styled telephone survey. Is that right?
Yeah, I think that's fair.
And then there's also, is it fair to say there's some interrelationship between the two?
I think it's a kind of like two-step. Like, is the media coverage prejudicial, and then has it had an impact on the jury? I would say on prospective jurors.
Okay, and is it fair to say that the media analysis is
more subjective and the telephone survey is more objective?
It's a qualitative analysis for sure. It's, yes.
Qualitative versus quantitative then?
Correct.
Let's begin, please, with the media analysis portion.
Okay.
In your media analysis, you base it on a limited search of the park record. Is that accurately stated? It's page 10 of your affidavit. Do you have it there? I'm going to refer to it.
I try to be conservative with how I collect the coverage. So I looked at the park record. That's the local paper. I wasn't looking at things that don't have circulation in the community. So I would say it's an underestimate of the number of articles. I didn't look at the radio station stuff and things like that.
What sort is the park record circulation in Summit County?
Actually, can you?
This mic's not working for me apparently today. I'll lean into it.
Thank you.
What sort is the circulation of the park record in Summit County?
I'm not sure. I know in the survey, over 50% of people who read the paper mention that paper as one of the newspapers they read.
I take it then that you don't know the park records circulation in Summit County vis-a-vis ABC4's viewership in Summit County? Or KLS TV's viewership in Summit County?
Is that the radio station or?
It's a TV station.
TV station, yeah. I was only looking at a conservative number of articles because I don't want to look at things, for example, in like the New York Times, because I don't know if people read the New York Times in Summit County. So it's a conservative estimate and a conservative approach to collecting the coverage and reviewing it to write the survey. So I'm not looking at blogs. I'm not looking at things like that. I'm looking specifically at the newspapers with circulation in the community.
And specifically only the park record?
Correct.
But you will acknowledge that people in Summit County read the New York Times?
Sure.
And they watch the 4 Salt Lake City local TV stations?
Yes. I might understand that's the only one here, right? You don't have a TV station that's just Summit County.
No,
Right.
Do you understand that the Summit County media market is the Salt Lake City media market?
Yes.
But you understand people in Summit County watch 48 Hours?
Sure.
Dateline?
Sure.
Good Morning America?
I'm assuming if people still watch TV these days.
Sure. And they read People magazine as well, don't they?
Yes.
Park record covered defense motions in this case, didn't it?
I'm sorry, defense motion?
The park record covered defense motions in this case.
I guess, sure.
Okay. On Q9 little I of your poll, or rather of your survey, I've been corrected on that, of your survey, you mentioned, you asked people what is their source of local news coverage, and they're supposed to give you a response. Can you take a look at that?
Let me see. Q9?
Q9 Romanet 2.
Let's see. That's only asking the source of Q9I.
Yes.
Not their source of information.
Can you just clarify what it's?
Yeah, so the reason I did that was back to the idea that the source of information gets stripped. People forget where they heard it.
Mm-hmm.
So I used this low recognition item. Have you read, seen, or heard if Kouri wanted to kill her husband so that she could start a new relationship? That was something the family spokesperson had said. And I wanted to see if they remembered that it was him as opposed to like in your, state's papers or something like that. I just wanted to know if they remembered the source of a particular comment.
And 23 people provided the source, is that right?
Yeah, I would have to go back and look. But.
And of those 23, 3 referenced the park record?
3 out of 20. Well, one, I don't have it in front of me, so was it 23 as opposed to 38?
Let's provide it for you.
Sure.
Ms. Lewis, while Mr. Bloodworth is looking for that, can I just confirm that this thumb drive contains the written version of Dr. Edelman's declaration survey results and supporting exhibits and appendices? Is that correct?
It does not include the PowerPoint, which I
Okay.
can send you. It only includes what I was unable to file attached to our motion because it was too large.
Okay.
So it's his declaration and the survey, but it is not the PowerPoint.
I understand that the PowerPoint, the tables in the PowerPoint, though, come from the survey results that are on the thumb drive.
Yes.
Okay, very good.
This is the one about the boyfriend. It wasn't
Even if
it was
water up there.
referring to
I'm
specific
good. Okay.
fact, I think.
Of course.
Thank you.
Sir, can you please again say what you're trying to measure there?
Well, what I wanted to measure was whether or not they remembered that some of these comments came from the state, or from this, I'm sorry, not you, from the family attorney who was speaking to the media, because I thought that was a significant source of bias.
Okay. And then you asked him, what was the media source?
Of that item.
Of that item.
Only. Now, it could be two things, because it was published in the newspaper, but the quote came from him.
Okay. And 23 people responded, and 3 of those 23 got their information from the park record, correct?
Yeah, which that's possible. I mean, it was published in the park record.
And 3 got that information from the defendant, her mother, and her boyfriend?
Her mother, boyfriend, and Kouri. Yeah. And that's, again, I don't know. It's possible that was some connection to that in the article as well. They might have referenced that. I don't know.
Your media analysis, you've already said it didn't include 48 Hours, Good Morning America, People Magazine. The defense filings, did it include the statements published in the media by the defendant, Ms. Richins' former counsel?
Yeah, there's articles, obviously, in the newspaper when she was the attorney. Is that what you're referencing? Or
where, sir, do you cite those in your analysis?
Cite them? I mean, they're part of the articles that we included in our, it should be an exhibit, the articles that I reviewed.
Where do you cite that in your, where do you quote those articles in your affidavit? Where do you consider and analyze those articles in your affidavit?
I didn't quote them.
Where do you analyze them?
They're analyzing the qualitative review of, is the media coverage overly prejudicial or not?
But not analyzed in writing in your affidavit?
No.
You're familiar, of course, with the interviews that the defendant's family has given the media?
Yeah, that's part of, we didn't get to it, but that's part of the presentation I had, looking at some of the things that were positive things that she had put out. So there's negative media coverage, and then there's attempts to kind of balance it out. You can see the reaction, one, how few people viewed that stuff, and the negative reaction, the comments people made when that was done. So it certainly didn't balance it. And you can look at the survey data and see the overwhelming opinion of her is negative, not positive.
Where in your written affidavit do you discuss that and analyze that?
It's in the survey report. What is your opinion of Kouri Richins, from very negative to very positive, and then the 3 words you'd use to describe her.
Let me ask a better question. Where in your affidavit do you address in writing the defendant's family's interviews?
I don't. There's a lot of articles and things I don't address when I do that at this section. I don't write out every single article and every single TV episode and every radio story and every podcast and every episode of court TV that references the case.
Well, more to the point, Doctor, you analyze all media coverage or much of the media coverage that's negative about.
I didn't say well. I told you I did a conservative analysis. I believe there's another expert.
If you'd wait for the rest of the question.
Sure.
But it's true that in your written affidavit, you did not analyze in writing any of the negative media, or rather any of the favorable media coverage.
Sure. Okay.
Mr. Bloodworth, we can move on.
Your Honor, I appreciate it. I will, because you directed me to, but I think everyone here is aware we're making a record not only for this court, but others as well.
I think the bigger point is that as between Dr. Edelman and me, I have a better recollection of the media coverage and mass of this case.
I don't dispute that, Your Honor. Thank you. You address in your media analysis defense or state filings, our filings in this matter, but not defense filings. Is that accurate?
I'm sorry, I'm not following you. What do you mean? I address it in
your written affidavit?
I address the state's filing?
You address various states' filings in the case?
Oh, in terms of on the rec, yeah, absolutely.
But you don't address any defense filings, do you?
I didn't run across any defense filing that was balanced out what was in the state filing. I'm not quite sure. It seemed to me a lot of it was responding to what was out there on the state side.
So are you familiar that the defense has filed 3 times for sanctions against the state in this case?
To do what? I'm sorry.
Are you aware that the defense has filed 3 times against the state for sanctions in this case?
Sure. That's not,
yes, sir.
Yes.
But you did not include that, and you did not find that?
No, I don't think that's significant.
Are you aware that the defense has moved to disqualify the state in this case?
Again, I don't think that's significant. People don't mention it when you ask what they've read, seen, or heard about the case. That's not significant, and it doesn't balance out case-specific details in terms of guilt.
We can keep moving.
Sir, can we turn briefly to the telephone survey?
Sure.
You mentioned earlier that the defense the state in its survey judged recognition on Kouri Richins' name.
One of the questions, yes.
What was the other question?
Embedded in 6 other stories about the Olympics and so on was a question about this case.
Wasn't the screening question there was 2 screening questions, right? 1, Kouri Richins' name, and then 2, a case involving a lady who allegedly murdered her husband and wrote a children's book about it.
Right after, again, 9 names and then a blend of 6 stories that's in there.
So your survey was designed to assess case recognition, familiarity, and prejudicial media content and bias. Is that right?
I would say it's designed to measure the impact of pretrial publicity on prospective jurors, case recognition, and the impact on the presumption of innocence.
Sir, if on page 1 of your affidavit you wrote, surveys was designed to assess case recognition, familiarity with prejudicial media content and bias. Is that accurate?
I think that fits in what I just said, yes.
Am I right then that it was not designed to assess media content favorable to the defendant?
There's open-ended questions. What have you read, seen, or heard about the case? If somebody had favorable media coverage, they would have mentioned it if they remembered it. And there's research on this, and it shows that favorable pretrial publicity is not as impactful as negative pretrial publicity. Some of the most impactful pretrial publicity is negative character evidence.
But you'll agree there is some impact of favorable publicity. And you agree that it does have an offsetting factor to prejudicial publicity.
I'm sorry, say that again?
You'll agree that to some measure it offsets prejudicial.
No, it doesn't.
Never, ever, ever.
I don't think the standard is never, ever, ever. I don't think any answer to any question is never, ever, ever.
We can keep moving.
Okay.
You spent a significant amount of time addressing Mr. Scortis in your affidavit?
Yes.
Why didn't you address any of the defendant's various spokespeople?
I did. It's in the presentation, but we didn't go through it.
But it's not in your affidavit?
Correct.
You referenced the gag order in your affidavit. What is your understanding of the gag order?
From my experience, a gag order would be anything you can't speak to the media.
Dr. Edelman, what is your understanding, if any, of the gag order in this case?
I'm assuming it's that you can't speak to the media.
Do you have a understanding of the gag order that was issued in this case?
Not at the moment. I'm sure I read about it at the time in the newspaper coverage.
You reference how the prosecution has not filed documents very often under seal.
Correct.
Do you have an understanding of the rules in this case when the prosecution can file documents under seal?
Mr. Bloodworth, we can keep going. I understand the dynamics at play there.
Sir, you write on the first page of your written affidavit, based on my analysis, it is my opinion that the Summit County jury pool has been exposed to prejudicial publicity, right?
Absolutely.
Would you agree that based on your results showing that 300 of 1,500 summons have not heard about the case, it's not the entire Summit County jury pool, right?
I don't know because there's new media coverage since they filled out that questionnaire. So, like I told you, I already watched one that was a 46-minute long.
I think, did I understand your answer earlier, that notwithstanding changes in the environment or additional coverage since you performed your survey,
sure,
that would be your expectation?
Sure.
Okay.
So you'll agree the math extrapolates out to approximately 6,400 of 32,000 approximate Summit County jurors
Sure.
have not heard of the case.
Sure.
Okay. So I don't have anything further. Thank you.
Ms. Lewis, any additional questions for Dr. Edelman?
Real briefly.
Do you need to reconnect that, Mr. Ramos?
I do. May I approach the witness?
Of course.
Your Honor, may I approach the retrieve?
Yeah, no problem.
Oh.
Once you're connected, Mr. Ramos will republish that.
Thank you.
I just want to review one of the slides.
My apologies. I apologize for being slow. Alex, would you do me a favor? Unplug that for a moment. I apologize. Brittany, it appears, yeah, plug it in. It's not a glitch-free system. We lost table 2.
No, we haven't been on all day on table 1.
Oh, well, that's also important information.
We're pari passu now.
Okay. At the moment, I can't show that slide, but maybe you can just ask the question and see if we can go off my memory.
We skipped the slide earlier about the positive pretrial publicity in this case. Do you recall that slide?
Yes.
And what was it that you found in terms of positive publicity?
There were 2 things. One was I think she did like an interview or something she sent to a television station or news station. It was just a voiceover.
Statement.
Embedded in the story.
And that was the statement that was sent out between attorneys. Do you recall that?
Yes.
Okay. And what was the other?
I'm trying to remember what the other one was without seeing it.
Ms. Lewis,
notwithstanding Mr. Bloodworth's cross-examination, I don't think there is a credible argument that the media coverage in this case has been complete, wholly accurate, or balanced. I think we can move on.
All right.
I mean, I've been on record with my concerns about it.
Correct. I don't know if I have
Didn't
any.
suddenly get religion.
Can I just make the point as to, just one more point on that, and I'll finish. How many, on the slide, and I don't know if you recall, how many people viewed that story compared to
It was
all
like
the other stories?
2,000, 2.1 or something like that.
Viewed the positive coverage. Yeah. All right. I don't think I have anything further. Just one moment. I don't. I'm finished. Thank you.
Mr. Bloodworth, may we let Dr. Edelman step down?
Yes, sir.
Thank you for your time, sir. You're welcome to step down. Thank you. Council, may we take a restroom break before proceeding?
Yes.
Okay, we will take a 10-minute break back at 11:45. Thank you. Does your screen show the seal of the court?
The seal?
Yeah. Okay. Good. Ms. Lewis, ready to go back on the record?
Yes, Your Honor.
Okay. We're back on the record in 231-500-139. Ms. Lewis, any other evidence that you wanted to put into the record on the motion to change venue?
No, Your Honor.
Okay. Mr. Bloodworth, is the state calling any witnesses or admitting any evidence? In addition to the stuff that's been filed?
No, Your Honor.
All right. Ms. Lewis, it's defendant's motion. You're entitled to the first and last word. Any argument that you want to
Yes.
put on the record?
Your Honor, a change of venue motion isn't a numbers game. That's not what this is about.
Right.
All right. That's why when we're looking here at the standard, is there a reasonable likelihood that she can get a fair trial in Summit County? And the survey that the defendant has submitted shows that there is not a reasonable likelihood that she can get a fair trial. The number of people in this county that are aware of the case, the number of people who know prejudicial details that have been out in the media, and the number of people who indicated rumors and speculation about the case that are not accurate in any sense is extremely high compared to Salt Lake County.
Where would you say is the breakover point? This is something that I struggled with.
Well, I think we're talking about, when we're looking at the two counties, let me just say, we picked Salt Lake County because it's convenient. It's 28 miles. When we're talking about the gravity of what Ms. Richins is facing here. And to find a jury that does not have the knowledge of the case that Summit County has. Taking that 28 miles is absolutely reasonable under the circumstances to avoid what potentially, and more than potentially, what based on the numbers, not the numbers, but based on the survey and the response to the survey shows that there's a reasonable likelihood, which is not a very high standard, that she can't get a fair trial here. Now, could we go to a different county? Yes. Could we go to Washington County? Maybe in Washington County, probably in Washington County, the recognition rate is going to be lower than Salt Lake County. Probably, and we could do that. But in determining where to hold a trial, it makes sense to look at the convenience of everybody who's involved. And I'm going to segue a little bit, and I don't think I need to spend time on this because I'm sure you know this. You asked us what we wanted to do, move the county to Salt Lake or bring Salt Lake jurors here. It doesn't really matter as far as the defense is concerned. It was not our position that we want to bring it here because we don't want her to be in Salt Lake County Jail during the trial. If she's been in Salt Lake County Jail during the trial, that's fine. But we have chosen all along to try and pick what is most convenient for everyone involved in this trial. We did that when we had a stipulation with the government or the state, and that is why we're going to that's why we're looking at Salt Lake County. I don't think there's a magic number. There's not a magic number in terms of where we can have a fair trial. For example, in the Coburger case that Dr. Edelman mentioned, the recognition between Ada County, which is where Boise is, and I think it's Leda County, I don't know, where Moscow is, the recognition was almost identical in terms of the number of people who recognized the case or had heard about the case. What we're looking at is we're looking at a large county, and Salt Lake County has 1.2, 1.3 million people. So out of those people, 42% recognize the case. That means that we have a very large number of people in Salt Lake County that did not recognize the case, as opposed to here, where we have a population of 42,000 people and 80% of them knew about the case. And out of those, 70% already believe she's guilty.
Let me engage with you on this for a minute. First, before I can get to the practicalities, I have to find that there's a reasonable likelihood that Ms. Richins would not get a fair trial in Summit County.
Yes.
Among there are 4 factors I am required to consider, and then I'm also required to consider the totality of the circumstances.
Yes.
One of the factors is the effect, nature, and extent of pretrial publicity. So let's discuss the numbers under that factor. Yes, there are 1.2 million people in Salt Lake County, but only 1,500 of them were summoned, and only 1,400 actually completed the questionnaire. So what we're really talking about is 1,400 people, and what percentage of those 1,400 have been exposed to information about the case. Is it the exposure or the nature of their connection or following of the media attention?
Well, I don't think we can look at one without the other. Exposure in and of itself is not a disqualifier. That's why the state survey is problematic, because they say, well, you could bring in 1,500 people, and conservatively, you're going to find 165 who haven't heard about the case. That's not the point. We're not predicting, this isn't a political poll, we're not predicting the number of jurors who know nothing about the case. And you can have jurors who have heard of the case. Yes, I've heard of that. Yeah, I'm aware she's charged with murder. That is not the same as having a large percent of the population who knows not just that, but also knows those specific factors about the case.
Right. So if we drill down there, in Summit County, it was only 1,100 out of the 15 summoned who completed the questionnaire.
Okay.
And if I understand Dr. Edelman's testimony and results correctly, 50% of the people who recognized the case followed the case not too closely or not at all.
I don't think it was that high, but
I think if we add the two numbers together, it's exactly 50.1. 15%, 1.5 of the 79.8 that are recognized the case followed it not at all. So there's 131 out of the 880 that follow it not at all, about 440 of the 880 that follow it not too closely or not at all. Let's assume those numbers are roughly twice as large in Salt Lake County. In defendant's view, is that the signifier, or is it other James factors that really matter here?
Well, I think it's all of them. That alone is not the signifier. No, it's not. I think what was important when we look at the other signifiers, particularly the standing of the victim in the community. In Salt Lake County, the familiarity with the Richins family was 3%.
Right. Up here, it's only 26, though.
26% said they were familiar with the family.
Right.
That's correct. But we also don't know here where our jury pool is going to come from. Now those numbers looked at all of Summit County. All right. Recognition in Park City is probably lower than recognition in the eastern part of the county.
You'd expect.
And so when we bring in these people, we don't know at this point what the balance of that is going to be. So if we get a large group of jurors from Camas and Colville and Hennifer, then we have concerns. We don't need to worry about that in Salt Lake County. In Salt Lake County, there's not going to be a stronger recognition in parts of the county as compared to other parts of the county, if that makes sense. So you could bring in a jury here. We know 26% of the county overall, based on the survey, said they had familiarity with the Richins.
Well, 26% of the 80% that read, heard, or seen something about
That's
the
right.
case.
And we may have people who don't know about the case that, in fact, we likely do have people that don't know about the case in Summit County that is familiar with the family, and we're going to get them in here, and those people are probably very likely there's going to be people disqualified who may not know about the case but may know about the family and then have concerns about being on the jury. And those numbers, I mean, we're looking at a picture here. We're looking at a picture with the survey. But when we bring in the actual jurors, if we have a large percentage from the parts of the county where the Richins are well known, those numbers are going to be higher. So we're taking a risk by having a Summit County jury that we're not going to be able to seat a fair and impartial jury. There's a reasonable likelihood that we can't because we don't know exactly where those numbers are going to shake out. But we know in Summit County, they're going to be there. In Salt Lake County, we can get jurors from the east side, we can get jurors from the west side, we get jurors throughout the entire county, and we're not going to see, based on the numbers that we have right now, a huge difference, if any difference, for example, on that factor, the standing of the Richins in the community.
Do we have any evidence in the record that, but for the pretrial publicity, so put that aside, that Kouri and Eric Richins or Eric's side of the family is any more well known in the county at large than, geez, we've done a lot of gnarly cases in this courtroom involving crimes against children, first-degree felony sexual assault cases, other murder cases.
I'm not entirely sure what you're getting at, but
I guess what I'm saying is I'm not sure these people have a standing in the community that is as great as you suggest. Wouldn't the number be substantially higher than 26%?
the Richins family are the biggest landowners in the southeastern part of the county.
Well, one of the Summit County Council members owes like an entire chunk of Echo Canyon, but like I'm not sure he's that well known outside from his former Summit County Council members.
Well, we don't know.
I mean,
all we need
here, we'll take it outside of the Richins family. If an Osgothorpe was either a victim or not, I mean, there's a barn named after them on 224, but that doesn't mean that people know the family in a way that would disqualify them, right?
I don't know. We don't know the answer to that.
I appreciate that was really my question is, do we know one way or the other? And
We do know that the Richins have part of the library named after them. We do know that.
We know all Richins does.
Well, there was no denial that it was this Richins family in the affidavit. I feel pretty confident if it were a different Richins family, that would have been included.
Okay, but I mean, geez, whatever. I understand your position, but more generally, I spent hours upon hours trying to figure out the through line through the change of venue cases and determine where district courts go wrong in denying a motion to change venue. And let me ask you about this. It seems that there needs to be an inflammatory plus factor that goes beyond adverse pretrial publicity. In James, it was the 45 days of community involvement searching for the missing infant. And during that time that occurs immediately after the infant goes missing, the media coverage starts to turn on the defendant before he's even charged. Forgive me for a moment, a case that whose name I can't remember, the crime was alleged to have occurred in the courthouse. And so there the judge was concerned that we can't have potential jurors or impaneled jurors interacting with the crime scene every day of the trial. In Stubbs, for whatever reason, the judge only summoned 16 jurors for a venire, and 9 of them knew the family. So that is an outlier. But then we look at Kayer, Lafferty, Bishop. In Bishop, they had a survey. 71% of those people that, 80% of the respondents said they believed the defendant to be guilty. No abuse of discretion. What do you see as the through line or the place where a district court commits a reversible error?
Well, let me first address. There are almost no cases that are using the reasonable likelihood standard because all of these cases, Bishop, Lafferty, they were interlocutory appeals. The standard had changed. By that time, that wasn't the standard anymore. And the court has to look at it from, was there actual prejudice at that point? James is the only case I came across.
Stubbs, right?
And no, Stubbs was post-conviction, and it said they applied the wrong standard.
Yeah, I think the Court of Appeals, though, says we're going to apply the James factors. And then the Supreme Court says, well, you did it wrong, but even though you did it wrong, your result was correct. But so if we look at the Court of Appeals decision in Stubbs, they applied the James factors afterwards. Your point is well taken.
Well, I think that's a major difference. We don't have a lot of data out there, but changes of venue occur constantly, and not all of them are, the O.J. Simpson case. They're not all, the level of prejudice that maybe was in the James case. There's nothing that says that the media coverage, the negative coverage, has to be at a certain level. It only has to be at a level that there's a reasonable likelihood that the defendant cannot get a fair trial. So I don't think there's a magic cutoff. There's not a point where it has to be this extreme where you don't get it. Where we have a number of factors out there in the media that some of them may not even be admissible once we get to trial. But they are in people's heads. We've got the walk the dog letter. We've got the financial motive. We have the paramour, which was something that was a term that was Greg Skordas put out there. And we can't ignore Mr. Skordas. We can't, because he is respected in the community. He is a spokesperson for KSL, which is the #1 watched news station in the entire state. And we have someone out there who's a commentator who now is out speaking against our client. Now, the difference between that and Salt Lake is in Salt Lake, people don't care as much. They're not paying as much attention.
Right.
And that's why Salt Lake is an appropriate place to have this. We're not saying that there has to be zero knowledge of the case. We're not saying that. What we're saying is, is the jury so connected to the case? Is there such a community awareness or a community concern that they are paying attention to all of these negative factors? And here, it's clear from the survey that they are, that at least to a much larger degree than they are in Salt Lake County. You keep going back to the numbers. Well, there's still this many that haven't, this many that hasn't. That doesn't matter. We could always say that. There's always a number of people, a sufficient number that you could probably find 12 people who could be fair. That's not
24.
That's not what the standard is here. It's not. And under a reasonable likelihood standard, and the fact that it is so easy to avoid this issue in this case, so easy.
I can't consider that, though, until I make the first decision, right? Because if I make the first decision, it doesn't matter how easy or difficult it is. It's required.
That is correct. You're right. It's just, you're right. It's hard to separate those out because we are in a situation where this is an easy fix. And I
think it's
do,
one of the judges, it wasn't in James, was it in Stubbs, that the judge commented it would be super easy for me to just grant the motion.
to bring another jury into the county.
Yeah.
Yes, which we still think you can do, but it's neither here nor there because either way works. And I lost my train of thought.
I apologize for interrupting.
That's okay.
So I understand your position regarding standing in the community.
Okay.
I mean, the size number is what it is.
It is what it is, and it's small.
Yeah. No, you're right.
It's a small community. And the gravity of the offense, all right, it's not a death penalty case, but other than that, it's they're.
You'd acknowledge doesn't include a child victim, no sexual violence, right? That seems to be notwithstanding the distinction you made on the reasonable likelihood standard, that seems to be a dividing line between cases. Adult victims.
In James it is, that's true. I don't think
And in
that's
Stubbs.
true in Stubbs, though, they really focused on other issues, but
Yeah, but I mean, 17-year-old high school student, rape victim.
I mean, I have a hard time addressing that because I do think a homicide is equally as prejudicial and the gravity of the offense as a 17-year-old rape victim. I don't know how you balance that factor out. I think one is as serious as the other.
Okay. That is a good faith position that the Utah Court of Appeals seems to differ on, but I agree. I understand.
I think, and honestly, let me just say, and of course this is just speculation. Most of these really high publicity cases deal with children victims. That's very common.
Right.
That's what gets the high publicity. That's just not the situation here.
Right. And then we come to the fourth factor, the nature and extent of the publicity. Okay.
Which I think we've spent a lot of time talking about. It's permeated every single hearing in this courtroom.
Sure.
It's been out there since day one. I talk about in my motion the number of stories that came out the week she was arrested. Now, it's different than James because the community didn't know that this was being looked at as a murder until the arrest. So it makes sense that the publicity didn't start until her arrest. But if you look at the articles that came out within the first 3 to 5 days, I think is what I've listed, maybe it's the first 7 days, it was immediate, it was prejudicial, and it was all over the news. I think the fact that Dr. Edelman focused on a conservative focus on the Park record is meaningless because we know it's all over the news. We know that there's national media, but the national media, the point is 48 hours, or I think it was 48 hours, People magazine, yes, it's everywhere, but it's people in this community that are the most interested in this story. So those are the people that are the most focused.
Or a greater percentage of people in this county follow it closely.
I mean, yeah, it's the same thing. I mean, you can say it either way, but there's a much greater interest here than there is 30 miles from here. It's just the nature of the beast when you're dealing with this small of community. So I think the 4 factors in James are very, very clearly met here. Are they, is it a sensational story where a child was, found dead outside the courthouse? No, it's not that story, but it doesn't have to be that story for there to be a reasonable likelihood that she cannot get a fair trial here.
I understand your position.
I don't think I have anything else, but let me just double check. I think just in closing, and maybe I've said this, but there's not a perfect answer here. There's not a perfect jury pool, but that's true no matter in any case. We're not looking for a perfect jury pool. We're looking for a jury pool where she has a chance of having a fair trial. And in this county, there's a reasonable chance that that's just not going to happen.
Okay. I appreciate that. Mr. Bloodworth.
Your Honor, can we start as a matter of law? It's my understanding, and I've seen no writing says otherwise, that the request for relief, the relief requested is to bring a Salt Lake County jury into Summit County.
That was the flag in the sand made by Mr. Ramos following my frustration with the ambiguity in the motion filed by defense. I'm happy to give you a ruling about my authority to do that.
Your Honor, as the state has briefed, the state doesn't think you have the authority.
You were quite clear about that in writing.
Okay.
Do you want to address that now?
Yes, sir. Seems like a good place to start.
Anything you want to add on that?
I want to answer your questions to the extent you have them.
I understand the state's position. I'm just not persuaded by it as a matter of law for reasons that I can explain in a moment. Notwithstanding that the court may summon jurors from only one county, if the court determines a fair and impartial trial cannot be had in the county where the action is pending, and that's an if that is as yet unresolved, the court may summon a jury from another county. You're on record. You've created a record. I don't know if there's anything you want to add on that.
No, Your Honor, I don't have anything to add to the written record. I appreciate that you are citing a conflict in the jury and witness, in the language of the Jury and Witness Act.
Yeah, let's just do this now, recognizing that I'm not sure it's relevant yet. But should it become relevant, the court determines that it does have the authority to pull jurors from another county following the granting of a motion to change venue under Rule of Criminal Procedure 29. Granted, under Utah Code 78B 7-107 subsection 2, quote, prospective jurors shall be randomly selected from the county in which the trial will be held, end quote. That language was added in 2017 by State Bill 169, Senate Bill, 169. Senator Hilliard and Rick Schwirmer, the state court administrator at the time, spoke to the bill during committee hearings and stated this bill does not do anything substantive. It's just cleanup and technical changes, no policy changes. Then Utah Rule of Criminal Procedure 29C1A states, if a party believes that a fair and impartial trial cannot be had in the court location or in the county where the action is pending, that party may move to have the trial of the case take place with a jury from another county or the case transferred to a court location in a county where a fair trial may be held. That rule was last amended by the Utah Supreme Court in 2018. That is after the language in Section 107, subsection 2 was added, and the provision regarding, quote, a jury from another county, end quote, was left in place by the Utah Supreme Court. This circumstance indicates that the Utah Supreme Court did not consider Rule 29C1A to be in conflict with Section 107, subsection 2. Moreover, in 2023, the legislature repealed 78B 3309, which was a statute providing that the court may on motion change the place of trial in the following cases, among other circumstances, when there is reason to believe that an impartial trial cannot be had in the county, city, or precinct designated in the complaint. Currently, 78B 3A 103 speaks to venue for civil actions, as stating that a court may transfer venue in accordance with Rule 42 of the Utah Rules of Civil Procedure. But the 2023 repeal of 78B 3309 left Utah Rule of Criminal Procedure 29 as the standard for transfer of venue in criminal actions. Considering the foregoing as a whole, the court rules that Utah Code 78B 107 subsection 2, Utah Rule of Criminal Procedure 29C, and the Utah Supreme Court's recent memorandum decision in this matter, upholding the court's determination that it can pull a jury from only one county. Those three things do not conflict. Therefore,
The court rules as a matter of law that notwithstanding that the court may summon jurors from only one county, if the court determines a fair and impartial trial cannot be had in the county where the action is pending, the court may summon a jury from another county. I'm more concerned with the if at the moment. Talk to me about that part.
Your Honor, the analysis is James. It's not whether or not there's publicity. I think everybody acknowledges to varying degrees that there is publicity. And well, I guess everybody acknowledges there's publicity and everybody acknowledges to varying degrees the harm that that publicity may have upon a jury pool.
Brad? It's really hard to hear from behind you.
I'm sorry. I don't know why it's quieter today.
Would you
I'll
like
get a lapel?
the sure? Yeah.
I can hear you if you're right there in the mic.
I'm leaving for it. Let me grab it.
Okay. In all fairness, I think I'm kind of deaf in one ear, so that's part of it.
We have the technology.
Okay, is this better?
Wendy, does that work better?
Sorry, what?
Does the lapel mic work better?
Fine.
Okay.
Good. Go ahead, Brad. I was sorry. I was listening.
Will you put it on your tie? Tricks of the trade. There you go.
Okay.
Please proceed.
So, Your Honor, it is all four of the James factors. It is not simply whether or not there's publicity and whether or not the publicity is on balance prejudicial. And the state acknowledges that, perhaps on balance it is prejudicial, but I think in fairness to, or, as the court evaluates Dr. Edelman's testimony, I think there is some offset. I think former defense counsel's presentation on 48 hours, the family interviews on 48 hours, the defendant's statements that got extraordinary media coverage nationally, I do think it does offset the otherwise predominantly prejudicial coverage. And I mentioned that here because, and we may discuss this later, I think the court should in some measure discount Dr. Edelman's testimony because he does bring to it a bias. I'm not saying it's a dishonest bias or an intellectually dishonest bias, but he is an advocate. And his testimony from the affidavit through to today only really analyzed half of the media coverage. And I think that bias is probably reflected in his polling as well. And the court saw it, I think, acutely today when the court would ask a question and Dr. Edelman would pivot to whatever he wanted to talk about in advocacy of the defendant. All right, back to James, I guess. And the point that publicity is only part of the analysis. It is, to some part, a numbers game. Not exclusively a numbers game, of course not. But I think we kind of start with the numbers. And if you look at the defense's polling out of 1,100 Summit County jurors that returned the questionnaire, approximately 200 of them have not heard the case. And if you take that same measure with the state's polling data, it's approximately 400. So I think the court then needs to kind of look at whether or not, given somewhere between 200 and 400 summons jurors to fill 8+4 seats, whether or not through voir dire, we can select a fair and impartial jury.
Would you acknowledge, Mr. Bloodworth, that in some cases there seems to be an overriding concern that notwithstanding the potential numbers game, there's some inflammatory plus factor, the formation of an angry mob at some point in the pretrial period, community involvement was heavily referenced in James. You would acknowledge that there are cases where it's not a numbers game, it's the inflammatory plus factor that determines the issue.
Your Honor, I do acknowledge that, and that does not exist here. This case had no media coverage until the defendant went on a book tour on local media.
Your Honor, I know it's argument, but he's stating things that aren't accurate. It had no coverage until she was arrested. That's when the media coverage started in this case.
I'll get to that in a moment. I understand your objection.
Okay.
Your Honor, I point to the ABC article that
Maybe we can
we
just
cite.
acknowledge that we've considered lots of murder cases in this courtroom, probably many more than the Summit County electorate realizes, because for some reason they did not get covered while this one did.
Your Honor, I'm not being clear. I mean, prior to arrest, the death of Eric Richins was not covered. And it wasn't covered because there's not that plus factor.
Or it was covered minimally and factually.
In the sense of an obituary type of presentation, sure. But the community had no interest in Eric Richins' death until arrest. And that is an indicator that there isn't that plus factor that exists here. There wasn't a search, there wasn't a child, there wasn't something remarkably horrific that grabbed the community's attention.
Okay, I understand your position. Anything yet?
Your Honor, it looked like you had a question a minute ago.
No. I mean, synthesizing the cases, the best I can do is to say pretrial publicity is a factor, but it's not the one that determines where the cases turn.
No, you're not. I think, no, it's not. I think you're accurate, Your Honor. I think the first James factor breaks in favor of the state. I think they were the defendant and Eric Richins had similar community standing. I think that.
Would you state, I mean, it seems that they had similar community standing to each other and to a bunch of other young parents who run small businesses in Eastern Summit County.
Your Honor, right. In our paper, we used the word common standing there. And it really is. If you were to, objectively look at that family before Eric Richins' death, they were Summit County.
Right, okay.
Your Honor, as it relates to the nature and gravity of the offense, the gravity is undeniable. It's the defendant's facing life in prison, but the nature isn't particularly horrific compared with, well, James, but what's it? I'm blanking on Brinkley and the other cases.
Bishop, Lafferty.
Bishop,
yeah,
all of them. And at bottom, I'm not sure that even the publicity, given all the prophylactic measures that the court has put in place, summoning 1,500, even if it's 1,100 post questionnaire, employment of the questionnaire, which was developed with extensive input from the parties, and also the seating of alternates, and allowing the parties to question during voir dire. Voir dire works. And given the analysis of under James, given the extensive prophylactic measures in the forthcoming voir dire, with the numbers available, we can seat 8+4 fair and impartial jurors.
Okay. I understand the state's position.
Thank you.
Ms. Lewis, you're entitled to the last word.
Your Honor, the court is going to consider the state's argument that Dr. Edelman is an advocate, not an expert, and should be disregarded.
I'm not.
Okay. We were going to cover that, but we didn't based on the court's question.
No, I appreciate his admirably candid answers to my questions.
Okay. For the state to stand up here and say the offset of publicity takes care of the problem doesn't even pass the smile test.
Yeah, I don't think that's really their argument.
Okay. Well, I mean, they stated that. They said, oh, there's been positive publicity, so it all washes out. We know that's not the case. There has been a minuscule amount of positive publicity that nobody cited to in the summary when asked what they knew about the case. No one. No one said anything positive that they heard in the news or read in the paper.
You don't need to convince me of this. I've been concerned about the amount and nature of the media coverage writ large of this case since it caught court staff by surprise when the case was filed. I understand your concern.
And interestingly, when we talk about the gravity of the offense, and Dr. Edelman could probably speak to this, but a nature of case that typically gets a lot of publicity is when a woman is accused of killing a husband or a boyfriend. That is not unusual. That rises up to the level in many ways of when we have a child victim. Look at the Karen Reed case right now. Cases where women are accused of murder tend to have a higher rate of publicity than other murder cases, especially an attractive white woman, let's be honest.
Yeah.
It's different. And that's why this case probably has garnished the amount of publicity it has. And it's extreme. Publicity in this case has been extreme. I don't think anyone can stand up here and try and downplay that or deny it.
I agree with everything you said, but then it begs the question, that publicity does not stop at Parley's Summit. It's coming from the Salt Lake media market, national media, and new media. Why is a change to Salt Lake going to change anything?
Again, I think the survey makes that clear because people in Salt Lake County aren't as invested in the outcome of this case as they are here. They aren't following every detail of this case, whereas a huge percentage of people in this county are. And we don't know where those jurors are going to come from. We know that a huge percentage of the county as a whole is following the case. If we get a disproportionate number of jurors from the eastern part of the county, then that's going to be even worse. We don't need to worry about that in a different county, be it Salt Lake or really any other county in this state.
Or worry about it less. I mean, all the dynamics that are present in Summit County are present in Salt Lake County, just not to the same percentage level.
And that's all we need. It's a reasonable likelihood. It is a low standard for the court to determine that she can't get a fair trial in this county. It's low. So yes, that is absolutely correct. But voir dire, and I'm segueing a little, voir dire is not going to solve the problem. Voir dire is not terribly useful in a high profile case. And in Summit County, where we've got people who know about the case, 80% of people know about the case. And we are asking them to say, can you put that all aside and be fair? We know that jurors say yes. We know that.
Why would we do that at all? I guess what I'm saying is, why wouldn't we focus on the 200 that don't recognize it to start?
So we're going to strike every single person who said they've heard of the case.
Well, that's your decision, not mine. You're going to have to make those motions, but I imagine you're going to.
It actually is your decision because we will
I'm
make
not
the
going to
motions.
strike people for cause sua sponte. I'm going to rely on counsel to identify those that need to be struck and make motions. You're going to have to do that. You're telling me you're not, within your range of options in either county, would be to choose to move to strike someone that recognizes the case or not, right?
All right, well, let's say we do that. According to their survey, we'll have about 165 people left in Summit County. In Salt Lake, we're still going to have a large jury pool if we were to strike every single person who said they knew about the case. And that
Doesn't it bear noting that we're only going to do attorney conducted voir dire, not only of 180?
But how is that relevant in terms of who we're left with in the type of jurors that we have left?
Being absolutely transparent, right? 180 people are going to be questioned carefully by counsel over the course of 3 days, right? You
Yes.
with me? Okay. So whether there are 1,000, 800, 600, or 400 people in either county that either don't know anything about the case or have read, seen, or heard about it, but don't follow it at all, does it matter which county they're coming from? As long as you have a sufficient headroom above the 180 to be sure you're actually going to get 180 that either haven't heard about it or heard about it but don't follow it at all. And I'm relying entirely on Dr. Edelman's survey for this this question.
But again, you're turning it into just a numbers game, and that's not the standard.
Well, if it's not a numbers game in part, then the survey doesn't matter at all.
But based on your analysis, we would never have a change of venue granted ever.
That's not true.
Why
If
is
there
that?
was an inflammatory plus factor, it wouldn't matter.
Wait, say that. You lost me.
If there was an inflammatory plus factor in Summit County, it wouldn't matter at all, the numbers. If an angry mob had formed outside the jail when Kouri Richins was arrested, if the crime had occurred at the courthouse, if, for example, there had been, as in James, community involvement in a candlelight vigil for Eric Richins after his passing in a search for the cause of his death for 45 days after his passing, that'd be different.
The James factors don't say there has to be an inflammatory plus argument. It says we look at those factors, and those 4 factors apply here.
I guess what I'm trying to get at is why do you think it's reasonably likely she's not going to get a fair trial if there's enough jurors to go around that don't know anything about the case? For example, in Stubbs, there weren't enough to go around. It was a big problem. In Iron County, these survey results would predict not enough to go around. Summit County's small, but it's not that small. This is what I'm struggling with.
But is that the standard? If you
Reasonable likelihood's the standard.
Oh, right. So that doesn't mean that you might be able to get a fair jury here. We might. That's true. We might. There's a reasonable likelihood that we can't. That's the standard.
But why do you say that? I guess this is why do you see it's reasonably likely that she won't? Other than, is it a concern that the survey results do not accurately show the pervasiveness of the effect of the pretrial publicity? Because otherwise, we do a lot of these cases. We do a lot of murder cases involving normal people. We do a lot of sexual assault, first-degree felony cases involving normal people. We do cases involving gruesome photographs.
How many murder cases have had over 150 news stories?
This is what I'm asking you about.
In Summit County? I would say none that you've tried. Have you ever had a case with this many stories and
Wouldn't that
negative
reduce the
publicity?
James factors just to the pretrial publicity, though?
It satisfies that factor. It doesn't reduce it to just that factor, but it satisfies that factor.
I appreciate that.
And I do think we meet all the other factors also.
Tell me why that is.
Well, nature and gravity offense.
Sure.
Clearly, we meet that one. It's a small community. We meet that one. The closest call is the standing of the victim. I don't, and I do think that's an issue here. And I've talked about it. I've explained it. I don't know. Maybe I'm not making myself clear, but that is going to vary depending on where most of our jurors come from.
Correct.
So we know it's an issue here. We know it's a family that's well known. We know that, but it is. I mean, when you look at and you drive down the street and you see a library named after them, when they're the biggest landowner in the county, when they're extremely wealthy.
Is there evidence of that in the record? I mean, I got to go off the affidavits that were filed, right?
I don't know. I thought I got that from the record before we got in the case, but I'm not going to swear to that.
I mean, I can take judicial notice that there's a building called the Sheldon's Richins Building that's a government building over at Kimball Junction, but Mr. Bloodworth.
Your Honor, there's no evidence of that in the record, and I don't think it's an accurate statement either.
Okay, I'm going to go with the first part that I don't think there's an affidavit to that effect, but keep going.
Of jurors are going to know the family in Summit County. We know at least 26% in the county as a whole recognized the name.
Let me push you just a little bit, make sure we're working from the same numbers. 26% of the 80 that recognized the case. We don't know what percentage of the other 20 recognized it.
We don't, because they weren't asked.
Right.
But I'm going to guess it's not zero.
Probably along the lines of 26%.
Probably.
Yeah.
At least. So, yeah, I think on that particular question, that 80% number is not as relevant as on some of the other questions, because people who know nothing about the case probably don't know anything about the walk the dog letter either, but people who know nothing about the case may very well know the Richins family or be connected to the Richins family. So that number, I think, if anything, is probably underrepresented, the 26%. I think it's big enough. It's big enough. It doesn't, not each of the four factors has to be the biggest ever. It doesn't have to be that every single person in the county knows them. It's the standing of the victim in the community is definitely something to be considered. This is not a nobody. This isn't a gang murder where nobody knows or nobody cares, sadly, who the victim might be. That's not the case we have here. We have a young man, a young, attractive man, a father whose family is very embedded in this community. And the fact of the matter is, Kouri Richins was only embedded in this community due to her marriage to him. Without him, her standard in this community drops significantly.
Didn't he grow up on the Wasatch Front and move here in 2012?
No. Who?
Eric.
He grew up in Davis County, I understand.
Okay.
But the family has had, my understanding is, and I don't know if this is in the record, but the hunting land here is well known.
All right.
And leased out for people to hunt on. And that actually, I do know, goes back to, and I think that's in the record, goes back to Eric Richins' grandfather. So the Richins family has been known in Summit County because his grandparents were here, even though he specifically did not grow up in Summit County. The family has been a long-standing founding member of this community.
Okay.
So I think it meets it. Is it a closer call than the other three factors? I admit it probably is, but it's enough. It's enough to meet the standard, the low standard of reasonable likelihood that she cannot get a fair trial. She can get a fair trial in Summit County. I mean, Salt Lake County. We believe she can. We believe the numbers show that. We believe the survey shows that. We're dealing with a huge county comparatively. So, and in terms of voir dire, I just want to say, telling people to put it out of their heads. And when we get people in here who maybe are going to know more than you say, and you say, okay, we'll just get rid of all of them. I have no idea if that's going to be plausible, if that's going to work, what we're going to be left with. We're speculating. But when you tell someone who has a preconceived notion to just put it out of their head, let's be honest, it's just not realistic when there's a lot of publicity on a case. And there is a lot of publicity in this case. There's a lot of publicity in Summit County. There's a lot of publicity nationally. And again, I think it's really important that the national publicity does not have the same effect outside this county as it does in this county. So that's not a reason to say, oh, it's going to be the same anywhere else. It's just not true. It's like in the Coburg case. The knowledge of the case is just as high in Boise, but the people, the connection to the case was not. And that was enough to change venue to Boise. This is very similar. The county sizes here are very similar. We're looking at a very similar situation. And again, the Supreme Court hasn't looked at very many cases on the reasonable likelihood standard. So we don't have a lot of law that we can rely on and point to. We really only have one case. And I don't think anything in the James case indicates it has to be this. It has to be this exact thing. That's not how case law works, so we know that. I believe we've met the standard. I think we've more than met the standard. And if we're going to ensure her a fair and reasonable trial, a fair jury, moving the trial out of Summit County is the only way to do that. And we would ask the court grant the motion to change venue.
Okay. We take a 5-minute break. Can't delay in a ruling here. Clock is ticking. I'll be back in 5 minutes. Thank you. Under Utah Rule of Criminal Procedure 29, C1A, if a party believes that a fair and impartial trial cannot be had in the court location or in the county where the action is pending, that party may move to have the trial of the case take place with a jury from another county or the case transferred to a court location in a county where a fair trial may be held. A trial court must evaluate a pre-trial motion for change of venue based on demographic, geographic, and cultural evidence unrelated to the identity and potential for bias of an actual jury venire. A judge should grant the motion whenever he or she finds a reasonable likelihood that a fair trial cannot be had unless the motion is granted. And bearing in mind that the court must take the totality of circumstances into account, the factors to be considered include the standing of the victim and the accused in the community, the size of the community, the nature and gravity of the offense, and the nature and extent of publicity regarding the case. Here, regarding the standing and victim of the accused in the community, the court finds the declaration of Kouri Richins Benson, docket 945, to be credible and relevant to the standing of Eric Richins and the defendant in Summit County. In short, Eric and Kouri both grew up outside of Summit County. They moved here in 2012, and they subsequently began raising a family and running small businesses in Camas. Prior to Eric's death and the events alleged in this case, they had a standing in their community at Summit County that was roughly equal to each other and roughly similar, equal to Summit County at large, given that they occupy the statuses of young parents involved in small businesses in their respective communities. Regarding the size of the community, approximately 43 residents are in Summit County based on census.gov data and estimates as of July 1, 2024. Of those 43,000, 1,500 were summoned as jurors in this case, and of those 1,500, 1,100 completed questionnaires. As noted, the court cannot and has not reviewed those questionnaires in any way prior to today. Notwithstanding its relatively small size, Summit County is not homogeneous. Based on this judge's experience serving in this county for the last 5+ years, there are material differences among county residents related to income, lifestyle, family structure, and religious and civic affiliations. And these differences express themselves, at least in part, between what locals refer to as the East Side, communities of Henneford, Colville, Oakley, Camas, and Francis on the one hand, and the population living in the Snyderville Basin and Park City on the other. With respect to the nature and gravity of the offense, defendant is charged with, among other crimes, 2 first-degree felonies, including 1 for aggravated murder involving pecuniary gain and administration of poison. These charges are very serious. While the state has declined to seek the death penalty, defendant nonetheless faces the risk of a life sentence. Notwithstanding the seriousness of the charges, this case does not involve some particularly inflammatory elements that are involved in other cases, such as the involvement of a child victim or sexual violence. And the fourth factor, the nature and extent of publicity. The court finds that there has been an extreme level of media attention on this case. And that coverage has been incomplete and therefore misleading. It has involved inaccurate summaries of evidence that may be admissible. It has involved discussion of evidence that the court has ruled is not admissible. It has included speculation by commentators who have no personal knowledge of the facts of this case. The nature and extent of the media coverage of this case is an indictment of those media outlets and our current media culture. But on the other hand, that coverage has been spread out over the 2 years during which this case has been pending, and there have been substantial periods of media quiescence between court hearings and between significant court filings. But even this level of media attention has not affected significant swaths of the community, according to defendant's community survey, which the court finds reliable. For example, 20% of Summit County residents have no familiarity with this case, or stated more precisely, Dr. Edelman's survey results would predict that 20% of Summit County residents have no familiarity with this case. That is, they have not read, seen, or heard about this case at the time that they were surveyed. Of the 80% of Summit County residents that are likely to have read, seen, or heard about the case, 30% of that 80 have not formed an opinion as to defendant's guilt. 50% of the people who recognize the case indicated that they follow the case not too closely or not at all. And 15% of those that indicated they recognized the case indicated that they followed the case not at all. Using the 1,100 potential jurors that have completed questionnaires in Summit County as a base to apply these percentages against, the court finds that approximately 220 have not read, seen, or heard about the case. Approximately 644 identified or would identify that they do not have a connection to the Richins family. Of the 878-ish that are likely to recognize the case, 270 are likely to respond that they have not formed an opinion about the defendant's guilt, and 131 of the 878 that are likely to have read, seen, or heard about the case are likely to indicate that they have not followed the case at all in the public media. Given that attorney-conducted voir dire of 180 jurors is contemplated over the course of 3 days, these numbers, approximately 220 that are likely to not recognize the case at all, another 270 that have formed no opinion on top of that about Ms. Richins' guilt, another 131 that have read, seen, or heard about the case but don't follow it at all, they provide an ample pool from which the parties can exercise for cause and peremptory challenges regarding other factors and nonetheless clear 24 jurors for cause in an effort to identify 12 8-seated jurors plus 4 alternates that are undeniably fair and impartial. And while the numbers are not the only factor that must be considered by the court, they are a relevant factor. And they militate against a determination that the size of the community or the nature and the gravity of the offense or any concerns regarding the standing of the victim or accused in the community makes it reasonably likely that defendant will not get a fair trial. Moreover, and more broadly, as stated by the Utah Supreme Court in State versus Lafferty, pretrial publicity, even persuasive, adverse publicity, does not inevitably lead to an unfair trial. Here, considering the James factors as a whole, the court does not find a reasonable likelihood that a fair trial cannot be had unless defendant's motion to change venue is granted. Therefore, based on the totality of the circumstances discussed, the findings and conclusions made by the court on the record today, defendant's motion to change venue is respectfully denied. Now, defendant may choose to seek appellate review on an interlocutory basis of this ruling. And we'll talk about that in a second, Ms. Lewis. If they do, if she does, and if an appellate court determines that this court has abused its discretion in denying the motion to change venue and that the motion should be granted, the court rules as a matter of law for the reasons already stated on the record that the court has the authority to pull jurors from another county and that the proper result, if the motion to change venue were to be granted, would be to pull jurors from Salt Lake County for a host of practical reasons. First, it's just not that far away. It would take jurors from Murray, Holiday, or the zip code that I live in, barely more than 10 to 15 minutes than somebody from Colville to get to this courthouse. Second, in consultation with the Summit County Sheriff's Office regarding security concerns related to a high-profile trial, transporting a defendant back and forth from Summit County to Salt Lake County each day is not a good security plan. And third, with respect to housing, Ms. Richins in ADC, there's no guarantee she would take her. They would take her. It's a Summit County case. She would likely have to be housed in Summit County. The witnesses are in Summit County. This is a Summit County case. It is not an abuse of this court's discretion to pull jurors from Salt Lake County for a Summit County case if defendant had shown or if an appellate court determines that defendant cannot find a reasonable likelihood or cannot, there's a reasonable likelihood that defendant cannot get a fair trial in Summit County. In short, if this case goes up on appeal, I want to make sure the parties get an opportunity to get guidance on that issue as well. Now, let me pause for a minute. I have a few procedural questions. Mr. Bloodworth, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Lewis, the parties will receive the 1,100 questionnaires probably by Wednesday, maybe Thursday morning. In the meantime, if defendant determines that she's going to seek an interlocutory appeal of this ruling, and if you're going to make a motion to continue the trial to allow that petition for interlocutory appeal to be considered and decided, sooner the better.
We'll do that now.
Go ahead.
We're making a motion to stay the proceedings and to continue the trial while we seek an interlocutory appeal.
And is it your intention? Oh man, I got to ask you some very pointed questions here. Do you mind? And if you don't know the answers yet, that's fine. Have you discussed with Ms. Richins
Yes.
the certainty that she will remain in custody while that process plays out?
Well, we would move to reopen the matter of detention, but we've discussed with her that that is a possibility.
I am disinclined to reopen the matter of detention. So let's be very clear here. There are no material changes in circumstances since the last time I considered the issue that I'm aware of.
Change in the trial date. Well, a change in the trial date is a material change in circumstance.
But you're the one asking for it.
All right, well, we just want to make a record. We believe that is a material change in circumstance, that the trial date is going to now need to be moved. She's been in custody for almost 2 years, and there are certainly circumstances, there's a set of conditions under which she could be released and not be a flight risk and not be a danger to the community.
Let's assume that she's not going to be released and that I find that there has not been a material change in circumstances based upon defendant's request to continue the trial. Have you discussed with Ms. Richins the fact that that interlocutory appeal process may take years?
Always seeking an emergency.
Well, we'll take an emergency appeal. I don't think it will take years, but we know it will take a minimum of months.
Okay.
And we have discussed that with her, yes.
Okay.
Your Honor, to that point, can we get maybe a more complete speedy trial waiver?
Yeah.
Not waiving if they want to interpret our motion as a waiver, that's up to the court. We're not waiving.
We're not waiving. If you want to interpret that by our motion, but we're not specifically waiving speedy trial.
I think the motion, Mr. Bloodworth, any speedy trial concerns are addressed at least during the period from this point forward by defendant's motion to continue. Any speedy trial concerns that have been baked in prior to today are what they are. I think that's true as a matter of law. I didn't see it differently, sir. Why don't we all just take 5 minutes and make sure that you want to do this right now? Just forgive me, 5 minutes. Okay, I understand your position. We'll come back in 5 minutes.
Your Honor,
Yes.
before the break.
Any change in position? Okay. Let's go one step at a time. The defendant is making a motion to continue the trial, correct?
Correct.
Any objection, Mr. Bloodworth?
Your Honor, I'm sorry.
Sure. Among the requests, but the only one we're discussing at this very moment, is defendant's motion to continue the trial so they may file a petition for interlocutory appeal. Any objection?
State is prepared to go to trial. The state is not objecting.
Understood. Ms. Lewis, I heard you also say that you're moving to stay the case. I understand that to be a motion to stay pre-trial proceedings, jury selection trial. Is that correct?
That's correct.
Okay. Mr. Bloodworth, any objection?
Just a point of clarification, Your Honor, does that include a staying of all deadlines set by rule?
I think
For
it.
example, tomorrow would be exhibit witness.
That's what I understand, is that as of 1:30 p.m. on April 7, while the court would retain jurisdiction of the case, no further pretrial proceedings would occur absent a specific request by a party.
Understand, Your Honor, prepared to go to trial. But it's not objecting.
All right. Other than needing a written ruling, which I should be able to provide by, I'll say Wednesday morning, but it'll probably be earlier than that. We'll say Wednesday morning. Any other requests or clarification today, Ms. Lewis?
We'd also move to expand the gag order in this case to include that no parties are charged with release or issue written press releases.
Is that inconsistent? Certainly more briefly stated than the current order. Let me call that one up. That was referred to as a protection order. Is that correct, Mr. Bloodworth?
Yes, Your Honor, it is. Looking around to see if I can pull from memory the document.
No, I've got it. It's 204.
Your Honor, it just makes the rule in order.
I'm looking at the wrong order. Forgive me. It does, but let's look at it together. Yeah, it's docket 68, protection order. All right, Ms. Lewis, the current order states, consistent with Rule 3.6 of the Utah Rules of Professional Conduct, that lawyers who have participated, who are now participating, or who will participate in the investigation or litigation of this case shall not intentionally, knowingly, or recklessly permit a witness, investigator, consultant, staff member, or other member of the lawyer's agency, firm, or team to make extrajudicial statements which, if made by the lawyer, would violate Rule 0.6. That rule prohibits extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. What is the clarification you're seeking?
Well, I didn't stop the press release going out. It was a violation of rules of professional conduct.
You'll need to be more specific. My apologies.
State's witnesses all testified truthfully, or at least the officers were all truthfully testifying. That went out in the press release. That violated that, but it didn't seem to help anything or change it.
1 second. My apologies. Would you say the last sentence again?
That the press release stating that officers were all testifying truthfully violates the rules of professional conduct, yet that particular protective order did not protect the defendant in that case, in that situation.
Without the court making any finding about whether any press release to date has violated the order, is strict compliance with the order going forward sufficient?
Yes, I guess we'll address it if something comes up.
Okay.
And I obviously need to make the record.
I'm not sure you do.
Don't worry.
There's no motion. We can just move on. Okay.
Your Honor, and can I just state for the record that the defense was ready to proceed to trial. The point of this is not to delay the proceedings. It's not to give the defense additional time to prepare. We were prepared to go forward. The point of this motion, for the record, is only because we believe that she cannot receive a fair and impartial trial in Summit County.
I find that representation to be genuine.
Thank you.
Okay. Ms. Lewis, anything else on the record?
No, Your Honor.
Mr. Bloodworth?
I appreciate that the court just
I'm moving it along here.
shut down the discussion.
Yeah.
The defense counsel just alleged an ethical violation by the state.
Yeah, we're
We
going to
already alleged
stop.
that. That wasn't a new allegation.
Folks,
Your Honor, OPC's ruled on it.
please stop. I'm not joking. Have a seat. Ms. Lewis, anything else on the record?
No, Your Honor.
Other than what you were about to say, Mr. Bloodworth, anything else on the record?
No, Your Honor.
All right. The motion to continue the trial is granted as unopposed. Defendant's motion to stay pre-trial proceedings, in this case from this point forward, is granted as unopposed. The court will issue a written ruling that incorporates its ruling from the bench regarding the motion to change venue so that there are no impediments to defendant's ability to seek appellate review on the motion to change venue. Ms. Richins, I wish you the best of luck. The court is in recess.
Wow. She is truly upset about this, isn't she? I guess I don't blame her. I mean, I can't believe it's been 2 years that she's been in jail. It doesn't seem like it's been that long since she got arrested. How long could this appeal that they're going to put up on this, obviously denied? Um, they want to stay in Summit County, which really quick, let me show you guys something. This is Summit County right up here in the corner. That's Summit County right up here next to where it says, next to the Utah on the state line. And then to the left of it is Salt Lake right here, which is a much smaller county. All right, so I Googled it, and there are over 42,759 people living in Summit County. And he's saying that they found 20% had not heard of the case or that could qualify as a juror so thus far without any void work going forward. That's 8,500 people. But they need 180 is what they're saying. They're already saying they're going to bring people in from Salt Lake County. I don't know if it really matters, you guys. They're going to file an appeal to this ruling. And I have no idea how much longer it's going to set things back. Could we be looking at a 2026 trial? Welcome in, everyone. Well, the Kouri Richins trial is still on delay, but there have been a few developments in it. Maybe one day we will actually get to watch this trial together, everyone. So the article says that as the Kouri Richins red rum case is on hold while the defendants are preparing to appeal a decision against moving the trial to Salt Lake County, 2 of the Utah Supreme Court rulings concerning the case have been published. Attorneys in the case already relied on both rulings, which were disclosed to them earlier in hearings as the case moved toward a trial previously scheduled to begin at the end of this month. One decision denies a motion by Richins and her attorneys to expand the jury pool to Salt Lake County residents. The Utah Supreme Court denied the request, affirming a decision by the 3rd District Judge Richard Masrick, which led Richins' attorneys to ask to move the trial to Salt Lake County altogether. That second request was also denied by Masrick earlier this month. He then granted a request to put the case on hold while Richins' attorneys filed yet another appeal. The court concluded about splitting jury selection, quote, "The trial judge correctly interpreted Utah law to conclude that jurors must be selected from a single county. We affirm." End quote. In the other decision officially handed down on Thursday of this past week, the state's high court looked at whether Laura Scott, the 3rd District Court's presiding judge, abused her discretion by denying a request for in-person jury selection. And the ruling states, quote, "The presiding judge did not abuse her discretion when she denied the parties' stipulated request for an in-person jury selection. The trial judge did not abuse his discretion when he denied the parties' stipulated request to expand the jury veneer." Associated Chief Justice John Pierce, who wrote the opinion for the unanimous ruling, acknowledged that the preceding judge said there is no question this is a high-profile case being covered by traditional and new media. However, the judge also noted there are many such cases currently in the 3rd District Court. The presiding judge reasoned that, as has been done in several other cases, issues regarding cameras and the number of people in and around the courtroom during a trial can be addressed with carefully crafted jury questionnaires, jury instructions, and decorum orders. The presiding judge concluded that the parties failed to adequately explain why in-person jury selection is needed to address general concerns about extreme media attention. Currently, all the jury selection done in the 3rd District Court criminal cases are done virtually. Richins' attorneys have not yet filed their appeal seeking to move her trial out of Summit County, which they argued was based on significant media attention and the large portion of Summit County individuals with connections to the case. She was ordered to stand trial on the charges of aggravated red rum and attempted red rum, first-degree felonies, 2 counts of distributing a controlled substance, 2 counts of insurance fraud, and 2 counts of filing a fraudulent insurance claim, second-degree felonies, and 3 counts of forgery, a third-degree felony. So that was just a quickie, but at least we have an update. It would be nice if we could find out when they're going to be scheduling this trial. We do need to plan our trial calendar watch. Stay tuned, everybody. Thanks for watching, and I'll see you on the next one.